Greetings to all of you, and thank you so much for joining us for today's North Dakota Constitutional Law Symposium, sponsored by the North Dakota Law Review. I am Michael McGinnis, Dean of the University of North Dakota School of Law, and it is my great privilege to offer these welcoming remarks to set the stage for this wonderful event. I am grateful to the editors and members of the North Dakota Law Review for their tremendous work in organizing the symposium, especially 2019-2020 Editor-in-Chief Alexander Carthew, Managing Editor Logan Carpenter, and their faculty advisor, Associate Professor Alexandra Sickler. Their hard work in providing us with such an outstanding and highly distinguished array of speakers on these fascinating and important topics is greatly appreciated. I am also grateful for the behind-the-scenes work done by our excellent UND law staff, including Rob Carolyn and J. Twan Moore, in helping us bring today's event from conception to reality. The UND School of Law is North Dakota's law school, and the study of the North Dakota Constitution and scholarly endeavors to enhance understanding of its meaning and application to the disputes and conflicts of the world we live in are pursuits that are very worthy of highlighting in an event such as this symposium. You will hear from experts, both national and local, on topics of state constitutions. Sixth Circuit Court of Appeals Judge Jeffrey Sutton will discuss ideas from his outstanding book, 51 Imperfect Solutions, States and the Making of American Constitutional Law, which I had the pleasure of reading when it was published in 2018. North Dakota Supreme Court Justice Jared Tufte will be presenting on the topic of originalism and the North Dakota Constitution. North Dakota Attorney General Wayne Stenjum will discuss separation of powers issues raised by the recent case North Dakota Legislative Assembly versus Burgum, and North Dakota Senator David Hogue will present on the evolution of the initiated measure process by constitutional amendment. Many other North Dakota lawyers will also be participating in today's presentations and panels. It is so exciting that the UND School of Law and its outstanding law review are able to provide this special education opportunity to our legal community. On behalf of the School of Law, I want to thank all of you for being a part of this important day, and I wish all of you the best for life and learning more about the North Dakota Constitution. Thank you.
Good morning, everyone. I'm Alexandra Carthew, and I am so happy to be here with you today. Thank you for some feedback. Thank you for your patience. I know we got a little bit of a slow start this morning. We had some difficulty streaming those remarks from our dean, Mike McGinnis.
And I'm Logan Carpenter. Thank you for joining us this morning.
Together, we began planning this event over a year ago as managing editor and editor-in-chief of the North Dakota Law Review. As many of you know, this event was originally intended to be in April, but had to be rescheduled in light of the COVID-19 pandemic. We are so grateful for the tremendous support we received from the faculty and staff of UND School of Law while planning and rescheduling this event. In particular, I would like to thank Dean McGinnis, our faculty advisor, Professor Alexandra Sickler, and J. Twan Moore for making this event a reality.
While this symposium has taken a different form than originally contemplated, we are delighted you could all join us virtually today. We also want to note that due to a change in our programming, the symposium is now approved for 7.25 CLE credits in North Dakota and Minnesota. Additionally, the program is now available on the symposium website for your viewing.
Many thanks to our tremendous speakers who are joining us today to share their knowledge and expertise. We are all excited to learn from you. For all of our virtual attendees, please use the chat function on the YouTube Live to submit questions for the presentations.
We are thrilled to be celebrating over 130 years of the North Dakota Constitution. On February 22, 1889, President Grover Cleveland signed the Enabling Act of 1889, allowing the people of North Dakota to create a state government and constitution.
The people elected delegates to the North Dakota Constitutional Convention, and it convened right here in Bismarck on July 4th, 1889.
131 years ago to the day, on August 17th, the convention approved a draft constitution and adjourned sine die. The original is still housed here in the Heritage Center at the State Archives.
In October, voters ratified the state constitution, and North Dakota officially became a state on November 2nd, 1889. In the 1970s, the North Dakota Constitution survived efforts to replace it with a second constitution at a new constitutional convention.
Since 1889, the North Dakota Constitution has been amended over 160 times. Our first speaker, Nicholas Samuelson, will be speaking to you in more detail about our Constitution. Nicholas Samuelson is a graduate of North Dakota State University and the University of North Dakota School of Law. He clerked for Justice Tufte of the North Dakota Supreme Court from 2019 to 2020, and he's currently an assistant state's attorney in Stutsman County, North Dakota. Nicholas wrote a companion article for the Symposium issue of the North Dakota Law Review, titled Digging for Roots in All the Wrong Places, Rethinking the Use of Secret Drafting Documents in Interpreting the North Dakota Constitution. Be sure to keep an eye out for the publication of his article later this fall.
I'd like to express my gratitude to the Law Review Board for giving me the opportunity to be here today. Special thanks also to Logan Carpenter and Alex Carthew for all their hard work putting on this symposium. They've really gone above and beyond to put on this wonderful event, and to say that they've had a few setbacks would be an understatement. So they deserve a round of
Is this working? Good.
Roughly, where did it cut out? All right, we'll try this again. Good morning, and thank you to everyone joining us online. My name is Nick Samuelson, and I'd like to thank Logan Carpenter for that wonderful introduction. My presentation today is on the secret sources of the North Dakota Constitution, and I was really excited when I heard that this was going to be the topic of this year's symposium, partly because I'm a big nerd for that kind of thing, for history and for constitutional law, but also because I had recently read an article titled Digging for Roots, the North Dakota Constitution and the Thayer Correspondence. It was interesting, but I took issue with a claim that was made, and I'll get back to that. So I'll start with a little historical background. Dakota Territory was organized by the U.S. Congress in 1861. North Dakota and South Dakota didn't become separate states until 1889. As we just heard, February 22nd of 1889, President Cleveland signs into law the Enabling Act, which called for the admission of North Dakota, South Dakota, Montana, and Washington to the United States. The Enabling Act instructed the citizens of those proposed states to prepare state constitutions, which it stated, shall be republican in form and make no distinction in civil or political rights on account of race or color, except as to Indians not taxed, and not be repugnant to the Constitution of the United States and principles of the Declaration of Independence. North Dakota's Constitutional Convention, comprised of 75 delegates, ran from July 4th to August 17th of 1889. And the Constitution prepared at that 1889 convention was approved by the voters October 1st, of 1889. Though it's been, by my count, amended 164 times, that original Constitution still governs us. There was another constitutional convention in the early 1970s, but that Constitution was not adopted by the voters. This is a picture of the original draft Constitution that I took over at the State Archives a couple months ago, and that's what it looks like on the inside. One of the most important developments during North Dakota's Constitutional Convention came on July 20th of 1889 when Delegate Erastus Appleman Williams of Bismarck introduced a complete draft constitution. This draft entered the record of the convention as File 106, so I will refer to that document as the File 106 Constitution. The File 106 Constitution was it was the talk of the town. Some remarked about its strength and clarity, and as one newspaper proclaimed, it will, if adopted, be looked upon as one of the very best organic laws ever enacted. But the most fascinating thing about the File 106 Constitution was the myth of its authorship. Delegate Williams did not author the File 106 Constitution, and he kept secret its true author. All he revealed to the convention delegates was that he received it from some Bismarck attorney, and that Bismarck attorney had received it from an Eastern United States attorney. Some suspected it was written by William Evarts of New York, but actually it was written by Professor James B. Thayer of the Harvard Law School, and this wasn't known to the convention. It wasn't known until about 1904 at a retirement party for Professor Thayer. And this was confirmed when, in 1989, North Dakota Supreme Court Justice Herbert Meschke and Assistant State Court Administrator Larry Spears published Digging for Roots. In that article, they published some correspondence between Professor Thayer and Henry Villard, who was the chairman of the board of directors of the Northern Pacific Railway. That correspondence, later discovered, Villard claims to have been motivated by benevolence for the newly formed states, but he was at least aware of a pretty big optics problem. The railroads had an enormous financial stake in the new states. Congress had given the Northern Pacific Railway 10,700,000 acres, or about 24% of all the land that would, in what would become North Dakota through a land grant. In addition, the railroads weren't exactly looked upon kindly by those in the statehood movement. The statehood movement was born out of a populist rebellion against corruption of big corporations, and the railroads had colluded with Minneapolis grain millers to fix false weights, excessive dockage, among other fraudulent practices. So I had already briefly mentioned Digging for Roots, the article by Meschke and Spears from 1989. And in that article, Meschke and Spears dug up some interesting history. For one, they unearthed and published correspondence between Thayer and Villard detailing the transaction and the development of the North Dakota Constitution. But the most interesting piece that they unearthed was a draft constitution titled Pedrick Draft Number 2. William Pedrick was a New York attorney who assisted Professor Thayer in preparing his constitution. And the most remarkable feature of the Pedrick Draft Number 2 was that it included a table of authorities, which keyed each provision to its source. So as you can see on the slide here, source of Article 1, Section 1 of our Constitution was Minnesota's Article 2, Section 1, and others. As you can see, Article 3, Sections 6 through 10 are constitutions generally, and this comes up a lot. So Meschke and Spears conclude digging for roots with a suggestion that we can use Pedrick Draft Number 2 and its table of authorities to shine some light on the secret history of our Constitution. And in particular, we can use the same rule for construing a model or uniform statute that has been used in another state. As that rule goes, a statute borrowed from another jurisdiction takes with it the source statute's baggage, so to speak. By baggage, I largely mean interpretive case law, because it is assumed that the legislature does its homework and understands how a statute taken from another jurisdiction has been applied there. This suggestion by Meschke and Spears seems to have taken hold. By my count, the North Dakota Supreme Court has cited digging for roots, or the sources published alongside it, in 5 published opinions, and in 4 of those cases, the court applies Meschke and Spears' theory. 5 citations in 31 years since the article was published may not seem like much, but it's the 3rd most often cited law review article by the court in that same time frame. So I take 3 issues with this theory that seems to have taken hold to some small extent with the court. First, Meschke and Spears' analogy to statutory interpretation doesn't really translate neatly to constitutional interpretation because of some key differences between statutes and constitutions. Second, the secrecy of the Pedrick draft means that it would not have informed the framers or ratifiers' understanding of the document. And finally, even if accepted as valid, the Pedrick draft materials rarely yield useful results. So my first argument, the statutory interpretation is flawed. With the sources of the constitutional provision in the Pedrick draft now easily ascertainable, so for example, Article 1, Section 1, keys to Minnesota, Article 2, Section 1, and others. With that easily ascertainable at this point, Meschke and Spears analogized that we can go through the same process as interpreting a model or uniform statute. So I've already summarized the analogy, but here it is once again. When one state adopts a statute from another, the adopting state's courts can look to the source jurisdiction's court decisions interpreting the source statute as persuasive authority. So when a state adopts another state statute, it comes with the baggage, and why shouldn't this carry over into constitutional interpretation? Especially where we now know that several constitutional provisions are borrowed from other states. Well, first off, there's some notable differences between statutes and constitutions that complicate that comparison. In the case of a statute, when we impute the source provision's interpretive case law, it assumes legal fiction that legislators do their homework and study how the law that they have proposed has been interpreted. Well, constitutions are different. Constitutions are popularly adopted by the people that they govern. Statutes are subject to a legislative process, and depending on that legislative body, that process can include the initial drafting, committee work, review by professional legislative staff, floor debate, and presentment to an executive for final approval. Even if a borrowed bill's source is never explicitly stated, the various steps make it at least plausible that these highly trained eyes, several sets of them, will lead to a source being discovered. Now, by contrast, the average constitutional ratifier, i.e. a voter, lacks the resources and expertise to discover a proposed constitutional provision's history and prior interpretations in other states. Rather, they're probably relying on the text of the provision alone, and maybe the information published by the Secretary of State in connection with the election at which the provision is put up for a vote. Second, imputing a uniform or model statute's prior interpretive case law serves a purpose not present when interpreting a borrowed constitutional provision. The purpose, a purpose of enacting a uniform act is uniformity. Therefore, our court here in North Dakota has said, when interpreting a uniform act, it gives special deference to decisions of courts and other jurisdictions that have interpreted the act. By contrast, uniformity between jurisdictions isn't a goal in setting a state constitution. So I have to acknowledge that the North Dakota Supreme Court has stated that the framers of the Constitution are presumed to have been aware of the constitutional provisions sources and their prior judicial interpretations. And that was State Ex Rel. McHugh versus Blaisdell. Now, in general, I don't object to this notion in instances where the framers actually wrote the constitutional provisions. However, under our specific facts of the North Dakota Constitutional Convention, much of our engrossed Constitution can be traced to Delegate Williams's File 106 Constitution. So even our delegates sitting in a quasi-legislative role were deliberately kept unaware of the source of the File 106 Constitution and its drafting history. Even ignoring, for the sake of argument, my earlier point about the differences between statutes and constitutions, lawmakers cannot adopt a legislative history that they don't know. Second, the use of secret sources is at odds with the North Dakota Supreme Court's originalist approach to constitutional interpretation. I don't want to steal too much thunder from Justice Tufte, who will be presenting this afternoon on the North Dakota Supreme Court's interpretation of state constitutions, of the state constitution, but the North Dakota Supreme Court has adopted what some might call a house style of sorts with regard to constitutional issues. And it often block quotes a statement of its interpretive principles. And distilled over the years, the court has said things to the effect of, our overriding objective in construing a constitutional provision is to give effect to the intention and purpose of the people adopting it. Or our primary duty is to ascertain and give effect to the intent and purpose of the framers and adopters of the Constitution. This court has consistently held that a constitution must be construed to give effect to the intention of the people who adopted it. These statements can fairly be described as originalism, which is a group of theories of constitutional interpretation, and through various iterations, many years of debate, originalism has concerned itself with the original intent of the framers, later the original understanding of the ratifiers, and more recently, the original public meaning of the text of the document. The North Dakota Supreme Court's statements of interpretive principles, I think, fit most closely with the original understanding mold of originalism. My argument on this point is extremely simple. Because the Pedrick Draft No. 2 and sources it references were wholly unknown to the ratifiers, or to the drafters, let alone the ratifiers, it cannot have informed the ratifiers' understanding of the document's meaning. And this isn't a case where we have to infer what a hypothetical ratifier would have known. We know what the ratifiers did not know about the Pedrick Draft because it was deliberately obscured by its drafters. And I have one last point that the Pedrick Draft No. 2 should not be used in constitutional interpretation, and that's that it's an impractical tool. So the suggestion made in Digging for Roots is that advocates can use this table of authorities to find a hidden legislative history behind our North Dakota Constitution, but to glean any useful results from this, a court or an advocate has to work backwards through a 5-step process. First, you have to match the present-day constitutional provision to the provision in the 1889 Constitution. And there's a couple obstacles that complicate this step. The North Dakota Constitution was renumbered in 1981. So for example, the anti-gift clause, currently codified at Article 10, Section 18, originally appeared as Article 12, Section 185 in 1889. Also, as of 2020, the North Dakota Constitution has been amended by my count 164 times. So our next step, step number 2, once the court has keyed a present-day provision to the 1889 provision, we then must confirm that the 1889 provision matches the proposed provision in the File 106 Constitution introduced by Williams. So a lot of the document was eventually, or a lot of the File 106 Constitution was eventually engrossed at the close of the Constitutional Convention, but not all of it was. For example, Section 21 of the 1889 Constitution, presently Article 1, Section 24, stating that provisions of the Constitution are mandatory and prohibitory, didn't appear in the File 106 Constitution or the Pedrick draft. Step number 3, the court then has to ensure the provision of the File 106 Constitution matches the provision in the Pedrick draft number 2. And this was a draft, it wasn't entirely File 106 which was introduced. Step 4, our court has to consult the table of authorities, and even upon reaching the table of authorities, sometimes you get very little insight. In several of these cases that the court has turned to the Pedrick draft, we find constitutions generally, which isn't really a useful result. And then when a source is identified, the 5th and final step is to consult the source jurisdiction's interpretive case law. And I've already explained why I think that imputing a source jurisdiction's case law is problematic. But even assuming that is valid, a 5-step process rarely yields useful results. So in conclusion, Meschke and Spears unearthed some fascinating history in digging for roots and expanded on the documented history of our Constitutional Convention. However, their suggestion that the previously secret source documents should be considered in interpreting the Constitution is inconsistent with what our court has said about constitutional interpretation. Thank you.
All right, thank you so much, Nick. At this point, we have a few minutes for questions from the audience. Now, if they are in-person questions, if you could just restate them so that our virtual attendees could hear them. And then Tatiana Hamilton, if you could just ask a few questions that you've selected from the chat, that would be great. Thank you.
Yes, Judge Sutton.
I didn't catch what the bottom line was about Professor Thayer. Did he really write it?
So the question was, did Professor Thayer really write it? And yes, Professor Thayer was the actual author of the North Dakota Constitution in conjunction with the railroads. So that is the chairman of the board of directors of the railroads hired Professor Thayer. In correspondence, he claims to have been motivated by benevolence and just, he wanted to gift a well-written constitution to the new states. Some of the literature is a little less kind to that suggestion. So South Dakota, as I understand it, had an 1885 constitutional convention. So they had already drafted some. I'm not as familiar with South Dakota and their history, but I know that there was a prior attempt at drafting a constitution.
One more follow-up, sorry. Is there anything, when you look at the original Constitution, are there things in it that look sympathetic to railroad interests?
So the question was, is there anything in the original 1889 Constitution that looks sympathetic to railroad interests? And to that, it maybe backs up Mr. Villard's statement that he just wanted to give a good constitution to the new states. I mean, I haven't, I'd have to go through a 5-step process backwards from the current Constitution to figure this out. I know that there are provisions in there that are more populist in nature and less sympathetic to big corporations such as railroads. And I think those were in the draft that was sent over and introduced at File 106. Yes, Judge.
It may be outside the scope of your topic, but to what extent has the court been able to identify source provisions through means other than the convention, perhaps just by identical text that's got an unusual phrasing that maybe only matches one or two other states? Did that come up in your research?
So the question is, outside of using the Pedrick draft number 2 and related materials, when has the court used other sources to determine a legislative history of sorts? And off the top of my head, I guess I don't know. I think there's been some reference to contemporaneous newspaper articles, but off the top of my head, I don't know the answer to that.
We have one question in the online chat from Seth O'Neill. He wants to know why the North Dakota Constitution is not on display at the Heritage Center.
I'm not sure why it's not on display at the Heritage Center, but it is at the archives. So I know that you can go over there and you can ask if you want to see it. They were super nice to Justice Tufte and I, and we walked over and we got to see it a couple months ago. Any other questions?
Okay. Thank you so much, Nick, for joining us. All right, our next speaker is Senator David Hogue. David Hogue is a native of Bismarck, North Dakota, and has worked in the private practice of law since 1988. He served as a JAG officer in the North Dakota Army National Guard for 23 years. He was elected to the North Dakota Senate in 2008 and continues his service to the people of District 38 in the state Senate. Senator Hogue is the prime sponsor of Measure 2 on this fall's election ballot, a proposal to change the method of amending the North Dakota Constitution. His presentation today is on the evolution of the initiated measure process by constitutional amendment. Thank you so much for joining us today, Senator Hogue. Hopefully we've gotten any technical difficulties with the mic that's actually attached to the podium ironed out, but if not, we will hook you up with another mic.
Could we send somebody down to turn on the podium mic? I am not sure how to do that, so we'll just take a quick break while we get that on.
Is it on? Okay, can you hear me? Can you hear me? Can't be heard. Well. Okay. Okay. How about now? Can you hear me now? Okay, perfect. Well, thank you, Logan and Alexandra, for inviting me. I really appreciate the opportunity. You know, as I was sitting up, a couple rows up, listening to Nick's presentation, I was actually thinking about the plight of a stand-up comedian. You know, they have been forced to go on TV without their live audience to ply their trade, and they don't get that feedback that they need in order to be good stand-up comedians. So it's kind of different, but I think I will be able to adapt. But I was just wondering, Logan and Alexandra, if you could hurl some random insults at me from time to time, that would help. Maybe heckle me when I get off track. I will do that. Okay, well, we're at a symposium, right? So we're supposed to have deep thoughts and ask profound questions. So I thought I would start with a question. And my question to the audience is, if you wanted to be deliberate and affect change in our society, how would you go about doing that? Now, I'm not talking about violent means. I know we all understand that you could fly airplanes into tall New York City buildings and bring about change. But I'm talking about lawful, peaceful change. How would you do it? Well, we know from the example of Martin Luther King that you could organize peaceful rallies throughout the country and advocate for change on behalf of a constituency. What you would not do, what you absolutely would not do, is what our U.S. founders of our U.S. Constitution thought, and that is propose an amendment to the U.S. Constitution. And that's my theory. And the reason you wouldn't do it is it's too doggone hard. You need 3/4 of the states to agree on a concept. And in our time, that is just not doable. We have blue states and we have red states. And they don't agree on a lot of things. But the notion that you would have 38 of those states today agree is a long shot. Nick mentioned the number of North Dakota constitutional amendments, which exceed 160. We've had 27 constitutional amendments of the U.S. Constitution. Of course, 10 of those were right out of the gate with the adoption of the Constitution. So we've had 17 U.S. constitutional amendments over 130 years. That's not a lot of amendments. That's not even what the U.S. founders envisioned. The 26th Amendment was the one that changed the voting age to 18, and that was back in 1971. We've had another one since then, but it's not a material amendment. It relates to congressional pay. But the other way that you could affect profound change, and I'd like to discuss it with you, is to amend state constitutions. And that is a process that goes out throughout the United States, but it goes on more readily in some states than others, and I would submit that North Dakota is one of those states. So I want to take some time this morning and talk about our Constitution as well, and a critical component of that Constitution, which is the initiated measure process. First of all, I think you might have gathered from Nick's presentation, the original 1889 Constitution followed the federal model in the sense that the legislative power was in a Republican form of government. There was no initiated measure. There was a notion that we should stay with the Constitution that had been proposed in other states. It wasn't until 1914 that an amendment to our state constitution reserved to North Dakota citizens the power to engage in direct democracy through the initiative and referendum process. I think the history of the initiative process has been well documented. I throw up a couple sites for you to take a look at if you have interest, but the initiated measure process came from what has been described as a populist movement. As Nick had indicated, there was some distrust for moneyed interests like the railroads, like the large multinational banks. And so this was seen as a way for the people to more accurately and forcefully express their will. I want to provide just a little bit of background about constitutional measures because it's kind of what I would describe as a unique area of the law because there aren't a lot of states that have it. And if you look at the states that do have it, you'll see, with the exception of Massachusetts and Maryland, most of the original states still don't have it. And it was really a function, I would submit, of their tradition and heritage. Before we do that, I wanted to make sure we have an understanding of three essential concepts within the initiated measure process. First of all, the initiative or initiative measure is a process by which citizens propose statutory law or constitutional amendment by petitioning to have a proposal placed on the ballot for popular vote. And one thing I have found in my service to the state through the legislature is that, and this is perhaps a stereotype, but most voting citizens do not appreciate the distinction between a statutory initiated measure and a constitutional initiated measure. They think of them interchangeably, and of course we know they're not. The referendum, that's a process where the citizens can veto a recent statutory law passed by the legislature and signed by the governor. And they have 90 days. When the bill is signed by the governor and filed with the Secretary of State, it becomes law, and that starts the 90 days running for members of the public to refer that measure. And that has been true. That 90 days has been one timeline that has stuck throughout our constitutional history. And it's 90 days to gather those signatures and to get them submitted. One feature I want to talk about a lot today is the direct versus indirect initiative. North Dakota is strictly a direct state, meaning the people can gather signatures and put it right on the ballot without any collaboration or intervention from the legislature. That's not true in all states. In some states, if you want to amend the Constitution, one of the things you have to do, one of the first steps you have to do, is to get the legislature to agree that it's something that should go forward. And that's what we call the indirect process. Indirect simply means that there's involvement in both the people and the legislative branch. Just a little more background in terms of petition circulators. I mean, we've heard a lot about them in the news in the past, I would say 3 weeks to 4 weeks. We know our U.S. Supreme Court has says circulating petitions, state petitions, does involve core political speech that's protected. Our North Dakota Supreme Court has put some reasonable time and place restrictions on circulating your petitions. And in this case of Belinsky versus North Dakota State Fair Association, the court said the state fair fairgrounds is public property. It's for a specific purpose, and it is reasonable to restrict the access to the midway and so forth, and to limit signature gathering to a rented booth space. And so if you were to go to the state fair or presumably some other public property, the public officials could restrict your signature gathering. Okay, here, I hope you can see those, but here are the initiative states. There's 24 of them. 21 statutory, meaning you can have an initiated measure to create a statute, and 18 constitutional. And I don't have a pointer, but I hope you can see North Dakota is direct as to both. Let me see here. Yeah, that looks readable, but this is the sum of the states. I put in parenthetical there that Maryland and New Mexico, I don't know if you want to call them initiatives. They don't have initiatives, but they do have referendum. So if you were to count those, you would say that there are 26 states, which is, roughly half of the states. But But the direct ones are the ones I want to talk about, because one of my hypotheses is that the direct ones, the small plain states, are the target of frequent intervention by non-citizens from outside the state who have a political agenda or have something that they want to pass, and they do it through investing in firms that are in the business of gathering signatures, and they come to our state. And it's not just North Dakota, but it's, I submit it's substantially in the states that are direct for constitutional amendment. There are 12 direct states. Here's the states with the indirect initiative process, and I break them down into constitutional amendments and statutory initiatives. Again, that Massachusetts is a little bit of an outlier because it's one of our original 13 states, but they have adopted that process. Well, here's one of my discussion points, and the question is, are state constitutions the playground of the rich and famous? And as I say in the bullet, I think the answer is increasingly yes. And I want you to consider the five previous constitutional measures that were not sponsored by the state legislature. Here is the funding sources for those five. All of this information is available on the Secretary of State's website. But if we go back to 2014, the 2014, there was a measure to take some of our oil and gas revenue and put it in a separate fund to be managed by a separate entity that is an unelected entity, and their job would be to spend the money to improve our outdoor parks, waterfowl habitat, and things of that nature. The interesting thing about that was by today's accounting, it would have been over $1 billion in that fund. But here's the breakdown of the spending you see. It was 13% came from in-state sources, 87% came from out-of-state sources. So that was one back in 2014. 2016, this is the victims' rights measure. These are all constitutional measures, by the way. 2016 is the so-called Marsy's Law, and I did not round up to 100%. There was absolutely no reported dollars from a North Dakota citizen who supported this measure financially. It was 100% from a gentleman named Mr. Nichols from California. That measure passed. In 2018, another 100%er, but it wasn't a big measure because the only thing it said was that you can't vote unless you're a citizen. And that was in response to, I think, some proposals in the West Coast where they were proposing that U.S. citizens be allowed to vote in local and statewide elections. And so there is an interest group out there, and they offered essentially, in this case it was $39,000 to gather the signatures to get it on our state ballot in 2018. Next one was one that we're familiar with because of its recent enactment, which is the 2018 ethics measure. This was referred to as Measure 1 in the 2018 ballot, and as you can see, it was 91% funded from out-of-state interest groups, and 9% came from local citizens. Here is the aggregate of those last four measures that I've described to you. 5% of the funding for the last four constitutional measures that went on the ballot, which came from in-state sources. 95% came from out-of-state sources. Now, that's the last four. Now, we know there's one that's going to be potentially on the ballot in the general election 2020, and I haven't done a pie because their story is not done. But you can see, I don't have a pointer, but what you can see is that their total contributions are $650,000. $450,000 of that came from an organization called Action Now Initiative, LLC, from Houston, Texas. Campaign Legal Center from Cambridge, Massachusetts. That was $126,000, and the third was for $73,000 from Represent Us. Now you see the box check for those last two. It's in kind, so we don't know exactly what they did, but we do know that they valued those contributions at those dollar amounts. If you look up at the top, I think this does have a pointer, but if you look up at the top, you can see there's $199, which is potentially from in-state, but we don't know that. This story will change because I'm sure they will gather more contributions. But if we were to put that on top of the other four, we would find that our last 5 constitutional measures not proposed by the legislature, about 97, 98% come from out-of-state interests. Now, one other thing I wanted to point out about this year's Measure 3, because it set a record, and the Secretary of State keeps track of this in terms of how fast can you gather signatures when you're paying for them. And in this case, the Secretary of State approved Measure 3 on Thursday, April 30th. So they had, if they wanted to get this on the ballot for this fall's November ballot, they had to get those into the Secretary of State's office by July 6th. And they did it. They did it with a couple days to spare and with, I think, close to 10,000 extra signatures. And that was never thought possible, especially in this COVID environment, where the gathering spaces to acquire these signatures is not readily available. But they did it, and as far as I can tell, that is the fastest any amount of signatures has been gathered for a constitutional measure. Less than 2 months. Let's skip over that. So let's talk about our original Constitution. Not surprisingly, it did not contain an initiated measure process. Only the legislature could propose constitutional amendments. And the amendment process was a 3-step process. First, the legislature had to pass a resolution in the House and Senate. The second step is that the legislature in the next regular session had to pass that same resolution a second time. And if it passed a first time and a second time, the measure had to be submitted to the people for approval. And if the voters approved it, that third step, it became an amendment to the Constitution. Here's the language of it. I don't think it's necessary for us to go over it, but it's in the North Dakota Legislative Council website for anybody who's interested in it. Skipping ahead to 1914, that was when we authorized as a state initiatives and referendum. And the requirements were different, but the basic ability to have direct initiatives was created. Statutory initiated measures, we've always drawn these distinctions, required 10% of the legal voters in a majority of counties. That majority of counties, obviously something we don't have today, but there's been a lot of thought given to that. in 1914, we still had this indirect process. The Legislative Assembly, as you see in my third bullet, must take up a measure and accept it or reject it without amendment. In case of passage by the Legislative Assembly, the measure became law. If it was rejected, the people got a chance to vote on it again. And finally, again, sticking with the referendum required a filing within 90 days of legislative enactment. I think I've referred to that earlier. So, continuing on with the 1914 amendments, they retain the requirement that the proposed constitutional amendments be passed by 2 successive legislative assemblies and passed by the electors. But as I said, it added an alternative way to amend the Constitution through the initiative process. And here's those requirements as contemplated in 1914 for constitutional amendments. You file at least 6 months before the general election with the Secretary of State. And by the way, the Secretary of State has always been our gatekeeper in terms of reviewing petitions, counting signatures. That's not the same in every state. In some states, it could be the governor. It could be the governor in connection with another state elected official. But in North Dakota, it has always been the Secretary of State. The signatures for a constitutional amendment required 25% of the legal voters of a majority of the counties in the state. And then if it was passed by the people, the constitutional measure goes to the Legislative Assembly for its approval. And you see that process. There was one feature that we don't have anymore, that last bullet. If a constitutional measure was defeated, meaning that the people didn't support it either before or after the legislature rejected it, it could not be brought up again for 6 years. Here's the actual language again. Okay, 4 years later, we had some changes to the initiated measure process in our Constitution. In 1918, the initiated measure signature requirement was set at a flat 10,000 signatures. The referendum was set at 7,000 electors. It added a provision, the 1918 amendment to the Constitution, added a provision prohibiting the passage of law for the giving or receiving of compensation for circulating a petition. So as of 1918, you could not pay signature gatherers to obtain signatures. And this is one of the things that became a significant debate during our 1972, our second constitutional convention. And I don't want to get too far ahead there, but some of our former state governors, two of our former lieutenant governors, Lieutenant Governors Sandstead and Amdahl, and former Governor Sinner, all were delegates to our 1972 convention, and they all debated this provision because it was regarded as one of the most important parts of the initiative process. So we'll talk about that. A fourth and interesting one of the 1918 changes is that the Secretary of State was required to print a publicity pamphlet wherein he could charge advocates or opponents of a measure up to $200, and they could write an article or an ad about why the voters of North Dakota should accept or reject that measure. And that's something we don't have today, but a lot of people have thought it's a good idea for there to be some forum to have a discussion about the merits of a particular measure. The last bullet there you see in the 1918 changes is something we have today, but it's modified, and that is that the legislature needs a 2/3 majority to override a statutory initiated measure. So obviously the legislature cannot override a constitutional measure, but if it's a statutory initiated measure, it can be done by a 2/3 majority. We revised that with the Constitutional Convention, but I'll get to that later. Here's the last two significant changes for 1918. If it was a constitutional initiated measure, only one vote of the Legislative Assembly required, followed by the vote of the people. So here we shortened the process, a vote of the people and a vote of the legislature. But it was still indirect as of then, because the legislature had a say. And finally, it required 20,000 signatures. Again, that's the text of our amendment. Okay, let's talk a little bit about the 1972 Constitutional Convention, because as was pointed out, we did not adopt that Constitution. The people did not vote it up, so it was never adopted. But what happened in 1969 is the legislature said, well, we need to have another constitutional convention. So in '69, the legislature passed the resolution. In 1970, the people voted on whether or not to have a constitutional convention, and they voted for it. And so in 1972, we held the Constitutional Convention. And it really, I say overhaul, but that's arguably too strong a word. I mean, some provisions were kept, new concepts were added, but it became the new Article 3 of our state constitution, and there were some significant changes. As I point out to you in that second bullet, the voters did reject the comprehensive constitutional revisions by a vote of 64,000 to 107. So now you're wondering, well, if the voters rejected it, how did it come to be part of our Constitution? Well, it's because the 1977 legislature, and I think particularly the Judiciary Committee, was thinking, you know what, the entire constitutional proposal did not gain the acceptance of the people, but what about the component of the constitutional proposal that related solely to initiated measures, referrals, and constitutional measures? And so what they did, what the '77 legislature did, is they passed a proposed constitutional amendment, which was to take what had been adopted by the 1972 Constitutional Convention, and they put it on the ballot. And the people adopted it by a vote of, you see it there in the last bullet, 102,000 to 75,000 votes roughly. I did want to point out some of the interesting debate that went on. I referenced former Governor Sinner was a delegate, former Lieutenant Governor and Sinner's Lieutenant Governor Lloyd Amdahl was a delegate, and former Lieutenant Governor Wayne Sandsted was a delegate, and they all had some interesting things to say. So you see at the bottom, there was the original proposal in the Constitutional Convention was, no person shall give or receive compensation for circulating a petition. And that was the subject of all of a series of debates. And what some argued was that we shouldn't have it because it wasn't enforceable. One delegate stood up and said, well, if I'm a dentist, I can give you a dental service, and in return, you can circulate a petition for me. And so since it's not an enforceable provision, we ought not to have it. Others, including former Lieutenant Governor I forgot his name. But he argued in support of the provision. He thought we ought to have it. Here is a particularly forceful argument from a delegate named Paulson, and I'm not sure where he's from. But I bold-faced his comments. He said, money by itself can abort this process and do evil with it. And I think if we have the original restriction in the proposed by the committee, we will keep the process for the people and not for the man with access to campaign money or whatever. Sandstead felt the same way. Here's the quotation I found interesting, because I didn't know this about our former governor, Sinner. He was a delegate, and he said on a number of times, I don't believe in the initiative or referral government, but he did support paying, as long as we were going to have it, he did support allowing them to be paid, because he reasoned as a legislator, we get paid to drive to and from the Capitol. He was from Castleton. And why shouldn't other people participating in the democratic process, why shouldn't they allowed to be paid? So he analogized the signature gatherers to citizen legislators and said, hey, I don't like this process, but if we're going to have it, we should allow them to be paid. Okay, so the 1978 amendments, which is a little bit confusing because, again, they came from the 77 legislature, but they were essentially adopted from our Constitutional Convention. They had a series of new concepts, and one of them was this concept of a sponsoring committee, where the committee has to contain 25 electors as sponsors. And we know from our prior case law that their names and addresses must be on every petition. That's the law. And the delegates to the Constitutional Convention thought that was important. If your neighbor was supporting it or somebody from your town was supporting it, they kind of wanted to know that before they made a decision whether to sign the petition. And they thought that was good policy. So that's what we have today in Article 3, is this so-called sponsoring committee. Again, the measure didn't change who was the gatekeeper. It's always been the Secretary of State, and it vests with the Secretary of State the power to authorize circulation upon the measure's approval as to proper form. Now, I think that word proper has been added and taken out, but at any rate, the Secretary of State's job has with it the requirement that he approve these petitions as to their form. And we'll talk a little bit more about what that means, because that was actually something that has developed in our case law, because the Constitution doesn't necessarily spell out what is proper form. The new 78 measure also vests with the Secretary of State the obligation to pass upon each petition and determine whether the petition is insufficient. Now, you presume that means counting signatures, and that's part of it. But as we'll see from our case law, that it's a little bit more than that for the Secretary of State. That last bullet there, you see, the petitions can only be circulated by electors. So although you can hire individuals to gather the signatures, they have to be North Dakota electors. Continuing on with the amendments, the electors who sign must provide an address and date of signature. That came right out of the convention. They thought that was imperative of the 72 convention, that if the Secretary of State is going to be this gatekeeper, he has to be able to verify that these people signed the petition. In 78 is where we went away from the flat amount of signatures to percentages. So since then, statutory measures require 2% of the resident population. And that's slightly over 13,000. It's about 13,450. The 78 amendment also granted to the North Dakota Supreme Court the right to adjudicate complaints about the process. And it made clear that they had original jurisdiction. So, and if you think about it, that's really a practical matter. There isn't time to go to a district court to obtain a ruling, because the clock is ticking in terms of trying to decide, does this go on the ballot or does it not go on the ballot? So that is really a very practical consideration. As you know, constitutional measures require 4% of the population. And that's the way it's been since 1978 in terms of those percentages. In 2004, we had an interesting amendment to our Constitution about initiated measures, and this is another one that was proposed by the legislature. And one of the concerns back then is that if there's insufficient public information about the measure, how can the electorate make an informed decision? So what they proposed is that the legislative assembly be granted the authority to try to look at the measure and determine its fiscal effect. And after it determines that fiscal effect, to make that determination available for the public. And the Legislative Council, which is an interim group of legislators, typically does do that. And they call upon the Office of Management Budget, the Legislative Council, to do that. But that was a 2004 amendment. The last amendment to our Constitution that relates to the initiative process was something that happened in 2013, and it was primarily brought forth by the Secretary of State. Because again, we talk about this time frame for how do you, once the signatures and the petitions come in, the Secretary of State has this, in the case of constitutional measure, he has to review these to make sure that they're authentic, to make sure that they're not forgeries, to make sure that they're in order. And he and others felt that you really need more time to specifically to allow for a challenge at the North Dakota Supreme Court. Because by the time he reviews them and by the time you allow enough time for a challenge to be heard, 90 days just simply wasn't enough time. And you see in that final bullet, the consequence if the North Dakota Supreme Court does not weigh in when they're petitioned to consider a challenge to a measure, it goes on the ballot. And to my knowledge, that has never happened. The Supreme Court has always been able to timely weigh in on a party's objection to a initiated measure, whether it was a constitutional measure or a statutory measure. I just wanted to talk about some of the contemporary legal disputes about measures, because a lot of them revolve around the Secretary of State's duties and whether he's properly executing those duties in the context of our Article 3 requirements. And so we have this approval as to form clause within the Constitution. And you think, well, sometimes the Secretary of State has no discretion, but we know that he has had discretion in certain cases. And the first one I mentioned to you is that Zeiser v. Jaeger case. He can look at the signatures and decide, are they forgeries? Are they bogus names? And in that case, he did conclude that there was a large volume of forgeries and bogus names. And importantly in that case, the people who circulated those petitions have to sign an affidavit that they believe that the signatures on there are true and correct and bear the signatures of the people who actually signed them. And some of those circulators were unwilling to do that. And so the Secretary of State took a look at it, and he said, I'm not putting this on the ballot. You've got signatures, Hillary Clinton's signature on one, Mickey Mouse, and you have admitted fraud from some of the circulators. And so the question, one of the proponents of the measure said, yeah, but even if you throw off all of those, we still have enough signatures. And the Secretary of State said, well, there's so many fraudulent signatures on this particular petition that I'm throwing out the whole thing. And when he did that, they did not meet the signature requirements. So to the extent that there's discretion with the Secretary of State, it's to look at a signature and to make a determination of whether it's fraudulent or not, whether it's not a legitimate signature. We learned that he does have that discretion, but very little else. As I said, the approval as to form clause has some limits, and I think probably the only case that I could find was the Lips v. Meyer case. That particular measure was about whether our three junior colleges would go under the state control of the State Board of Higher Education, or whether they would remain autonomous. And the measure contained a statement of intent. And some legislators, including Senator Lips from Bismarck, petitioned the court and said that a statement of intent is not proper on an initiated measure. It's inappropriate, and because it's inappropriate, it shouldn't go on the ballot. And the court agreed. Next, we have that the circulated petitions must contain the names and addresses of the 25 sponsors and full text of the measure. And absence of such information renders the petition invalid. And that was the case in Thompson v. Jagger, which was a measure that would have authorized non-pharmacists to own pharmacies, because we have a very unique statute in North Dakota that says if there's going to be a pharmacy, it must be owned by a pharmacist. Well, not surprisingly, this was another petition that was paid for by out-of-state interests who wanted to see that rule set aside, that pharmacies be owned by non-pharmacists. But what they did when they circulated their petition, they had the full measure, but they didn't have the names and addresses of the 25 sponsors on the petition. And the court looked at that pretty hard, and they said, no, that is a requirement. Because again, your neighbor has a right to know if he has anybody in his community who's supporting this measure. And so they agreed with the secretary, and they did not let that measure on the ballot. Approval as to form, the Secretary of State also has, I would argue, a little bit of discretion in that he does not have to let on the ballot a measure that is illegal in substance. And so this recall case, what the circulators were proposing was to recall a sitting U.S. Senator. Well, based on the advice of the Attorney General, the Secretary of State said, well, the state can't do that. The qualifications of a U.S. Senator are as prescribed in the United States Constitution. And there are no qualifications that we, as a state of North Dakota, can impose on a sitting U.S. Senator. So the court in that case agreed again with the Secretary of State that no, that doesn't go on the ballot. That recall petition doesn't go on the ballot because the purpose cannot be achieved So it's almost like a futility argument. We're not going to put something on that will not, cannot be achieved. Okay, my final potential amendment came from our last legislative assembly. And this came from the 66th legislative, and it's going to be measure 2 on this fall's ballot. And I hope you can read that. The underscoring represents new language to Section 9 of Article 3 of the Constitution. And essentially, anybody get a prize if they can recognize this, if they see where this might have come from? Anyone? Anyone at all? Okay, well, no prize today, but this comes from the 1914 constitutional amendment. This is indirect democracy of constitutional amendments. What it requires is that if the people initiate a measure to amend our Constitution, the next step in the process would be to have the legislature review it and vote to either approve it or reject it. If the legislature approves it, it becomes a constitutional amendment. If the legislature rejects it, it goes back to the people for a second vote to determine whether they want to adopt that constitutional amendment. Now, clearly, it does slow the process because it contemplates potential for 4 or 6 years for a constitutional amendment to be enacted. But that is the conventional timeline for the amendment of most state constitutions. And certainly, it's shorter than what we have for our U.S. Constitution. And so that's my question in this slide. Does it look familiar? Yes, it's the 1914 amendment. I call it the Barbra Streisand "The Way We Were" amendment because it takes us back to where we were in 1914 when we had an indirect process and we had the ability to have both the elected representatives of the people in the Legislative Assembly weigh in on a constitutional measure and the people themselves. So the only 2 changes to this measure from the 1914 that are significant are in 1914 you had to get 25% of the signatures of voters in a majority of counties. We don't have that anymore. You can go to our most populated counties, Cass County, Burleigh County, Grand Forks County, and get as many signatures as you desire. And second, there's no restriction on the consideration of a failed measures within 6 years, like there was in 1914. And the theory there is if you brought it up and the people voted it down, you can't bring it back for 6 years. So that is my presentation on the history of our constitutional measures and revisions to our Constitution. Be happy to try to answer any questions.
Thank you so much, Senator Hogue.
Thank you, Senator. We have a couple of questions in the chat.
Let me stop then.
Not that easy.
Okay, the first one is how you rectify injecting the legislature into an article of the Constitution entitled Powers Reserved to the People, since the article as written was proposed by the legislature in 1977 and approved by the people. It's the title of the article called Powers Reserved to the People, substantive to both the legislative and voter intent. If the powers are reserved, it's that reservation, not an absolute.
I didn't hear the first part of the question, please.
Okay, sorry. How do you rectify injecting the legislature into an article of the Constitution entitled powers reserved to the people?
Well, perhaps it's semantics, but the people still have the power to initiate a constitutional amendment. They still have final say on a constitutional amendment, even if they disagree with the legislature. They have the ability by a simple majority vote to override the legislature. And we know from our constitutional history when we had this process that they did so. And that same language, the reserved to the people, was never challenged on the grounds that the legislature was able to weigh in on some of those measures.
And then one more question in the chat. Are you one of the 25 sponsors of Measure 2, or do you work for people who are the sponsors?
Measure 2, again, let's back up. We can propose constitutional amendments in two ways. The legislature can pass by resolution a proposal, and if both the House and Senate agree, it goes on the ballot. The second way is that you can gather signatures up to 4%. You need up to 4% of the resident population. And either way, it gets on the ballot. Now, for Measure 2, I did prime sponsor that in the legislature, and it passed both the House and Senate, and therefore it goes on the ballot.
Thank you. That's all that's in the chat.
Do we have any questions from the audience here?
Yes, sir.
This is probably out of ignorance. Once it goes on the ballot, is it 51% vote for the people?
Yes, sir.
And has there been thought about raising that percentage? If I had one critique of initiatives, so I quite agree with you. The federal constitution is too hard to amend. 3/4 of the states, never going to happen with something controversial. But one has to wonder if 51% is too easy. And I've often thought even 55% would, you talk about out-of-state money. I think a lot of people would not make these investments if it were 55%, even 60% range. But I think even 55 would change a lot of this. Has that been discussed?
Thank you for the question. The legislature has. Oh, okay, thank you. The question is posed by a member of the live audience is whether there's been any consideration given to raising the amount or the percentage of votes needed to pass a constitutional measure. Currently, it's a majority of the voters, and the question is, should we consider something like 55% or some other supermajority? And I can tell you that the legislature has considered that several times. And we've had, I would describe it as rigorous debate about that. It hasn't passed. We've also considered going back to the old, you should have to get a certain amount of signatures from a majority of the counties, because the current practice is simply to go to Cass County, Burley County, and perhaps Grand Forks and Ward County, but not much else. There's no effort, nor why would they, there's no effort to go out into the rural areas and to attempt to gather signatures for obvious reasons. So that's been thought of. Another one that has been thought of is one provision that North Dakota does not have is we do not have a provision that limits a proposed initiated measure, particularly constitutional measures, to a single subject. So you can literally have a spending bill along with something to reform our election law. You can throw it all in there. And the idea, I suppose, is to try to get enough interest from different stakeholders within our state to get them excited about the measure. But there's no restriction on that regard, and many states do have that. Montana has that. In fact, Montana threw out Marcy's law because the Montana Supreme Court ruled that they had more than one subject in that particular measure. Yes, sir.
Sorry, Senator, just to follow up. So I'm from Ohio, and the problem we have with initiatives and referenda is that they're equally easy to enact. So that means, well, why not do the initiative and change the Constitution? It always sounds better if your project is in the Constitution rather than a mere statute. And so one thing that's been discussed in Ohio, and I wonder if that was happening here, is it seems like a good idea to make initiatives harder, conspicuously harder than referenda. So whether it's 51%, 52, who cares? But you ought to differentiate because it should be easier to enact a statute or referendum than an initiative. Is that something you've already taken care of? Or?
Yes, I think the question is, in Ohio, it appears that there's the burden for the petitioners to propose an initiated statutory measure versus a constitutional measure is about the same. So the default selection in Ohio is to go for the constitutional measure. Is that?
Exactly.
Okay. Well, in North Dakota, it is you require more signatures in North Dakota. You get 4% of the resident population, which is 26,905, I believe. So that's for constitutional measures. Statutory measures is only 2%. But the point of the slide I put up earlier about the current Measure 3 is they did it in 2 months' time because, you know, if you have the resources to do it, you can do it. So it is not a significant impediment in North Dakota to get a constitutional measure on the ballot. Now, the interesting thing is this, because the Secretary of State tracks all of these measures, whether they make it on the ballot and get the requisite signatures or not. But you will find, if you go back at least 10 years, of the measures that are funded by a majority of out-of-state interests, whereas, you know, the slides I show you, it's 80, 90%, 95% by out-of-state interests. They always choose constitutional amendment. And you know why that is. Because that's the way you work around the legislative branch. If it is funded locally, if it is a so-called grassroots, they tend to go to the initiated measure. And there I'm talking about the medical marijuana that passed. I'm talking about the license plates and free registration, motor vehicle registration for first responders. Those types of what I would characterize as grassroots, meaning they're funded locally, they always go initiated measure, or statutory, excuse me. Judge.
Yeah, Senator, you've expressed some concern about disproportionate influence from non-residents spending and otherwise assisting. Are you aware of other states that have imposed burdens on non-voters, non-residents that have been upheld by courts after free speech or other challenges?
I am not, because I think the spending on a initiated measure is regarded as free speech, Judge. So there aren't restrictions on who can pay for the signature gathering. I think there was a federal judge in either Nebraska or Kansas who weighed in on the other measure I mentioned, where you try to restrict the counties or require the counties to have signatures from a majority of the counties, and there's a federal judge who says no, that violates one person, one vote, because you're not giving the same rights to a resident of Cass County that you would to a rural county. But in terms of restrictions on spending, not aware of any, no sir.
Senator, I'm sorry to keep bothering you, but I love the talk, so forgive me for being so interested in it. When you think of the initiative, historically, I think it was designed to be more of a check on the legislature, as you put it, to
Yes.
kind of take control of the issue for whatever reason, good, bad, indifferent, out-of-state money. But the other reason to have initiatives is actually to check the courts. And I'm curious, when I looked at the examples, I wasn't thinking there were too many where the initiative has been used because the people of North Dakota didn't agree, for example, with a decision of the North Dakota Supreme Court. Has that not usually been the reason for an initiative, or has that happened sometimes?
Well, excuse me, I would argue that I can't think of an example in North Dakota, but let's go to our federal constitution. And you and I agree that it's way too hard to amend, and most people, I shouldn't say most, a lot of very smart, legal, scholarly people will say, well, that's why we have, substantive due process in the 14th Amendment, so that the U.S. Supreme Court can effectively amend our Constitution. And people argue that's what they've done, because there's no way to amend it, not unless things change. It's not practical to suggest that we'll amend our U.S. Constitution.
All right, thank you for the wonderful questions. We are going to take
Good grammar and spelling are important. But if you want to write essays that inspire,
just a few more
messages that forge brighter connections, and emails that get the job done, you need...
Okay, we are going to take a brief 10-minute break. Thank you for a wonderful presentation, Senator Hogue. Then we will come back at 11 a.m. for presentations from Terrence Moore and Assistant Attorney General Tara Brandner. Thank you.
One, 1, 2, 3, it works.
Testing, testing. Yep.
Testing, 1, 2.
Hello. Can you hear me? All right, we're good to go.
Welcome back. Tara Brandner has been an Assistant Attorney General in the State and Local Government Division of the North Dakota Office of the Attorney General since 2016. She represents a number of commissions, boards, and departments, including the Department of Health. Prior to working in the Attorney General's office, Tara was employed with the Minnesota Department of Human Services in St. Paul, Minnesota. Today, Tara will be presenting on efforts to legalize marijuana in North Dakota. Welcome, Tara.
Thank you. So as he said, I'm an Assistant Attorney General in the North Dakota Attorney General's office, and I've been there for a little over 4 years now. And before I give my presentations, I usually like to start with the about me or the how I became the pot princess in the state of North Dakota. So, you know, this wasn't a career that I saw myself going into when I went to the University of St. Thomas. We don't have a path to become a pot law expert like they do at some of the colleges across the country. It's actually something that, if you know Mary Kay Kelch, that she talked me into, and she, I would say, bamboozled me, to be completely honest. She told me about this wonderful position representing the Department of Health, doing health law and employment law and IT work and representing all 30,000 of these clients that she's piled together here. And then 4 days into my employment, she sent the intern, who was a UND law student at the time, into my office to explain to me what Measure 5 was. And it was all news to me at the time because when I had moved back to North Dakota, I was a registered voter in Minnesota. I had been living there for 6 years, and so I had no idea what Measure 5 was. And so 4 days into my employment, I started kind of the deep dive into marijuana law, and now it's kind of become my thing. It's interesting because for the past however many months, we've been dealing with the COVID pandemic. And so to talk about marijuana law is a real change and to some extent a relief. So with that, let's get started. And I already broke the mic. Just because Wayne Stenjum makes me say that, this presentation is not intended to be legal advice. If you have questions, I'm happy to discuss with you. Usually I say that if you should consult your own legal counsel because this is a presentation that I primarily give to law enforcement. So kind of what we're going to talk about today. So I want to talk about the history of the Compassionate Care Act in North Dakota, the Cole Memorandum, the Attorney General opinion that was issued in 2017, the status of the North Dakota medical marijuana program. I want to talk about what the numbers look like in North Dakota today, and then I want to just briefly talk about some of the constitutional and legal issues related to the legalization of marijuana as we go forward. So the history of the Compassionate Care Act. So on November 8th, 2016, North Dakota voters passed initiated Measure 5, legalizing the use of medical marijuana for patients with qualifying medical conditions in the state of North Dakota. If you look down at the next slide, you can see all of the blue is where the measure passed in each of the counties. The total passage rate was 63.8%, which is pretty high. In regions like the Fargo and Cass County region and Grand Forks County, the numbers were significantly higher. So it had overall pretty great support across the state. So once the measure was passed, we, as the legal counsel for the Department of Health, as the implementing agency, began to look at Measure 5 and say, okay, what are the things that we need to do? Because Measure 5 essentially didn't have an implementation date. So in accordance with the North Dakota Constitution, if there is no implementation date, the initiated measure becomes law within 30 days. And so as the Department of Health and myself went and we started to review the measure, we had a significant number of concerns and determined that essentially the measure required a statutory amendments. So as lawyers, it's a lot easier to explain. If you go back and you look at the original language of the measure, it was a copy-paste of Delaware's administrative code. There was no enacting statute or enacting language in the measure. And so there were a number of portions where we didn't distinguish between children and adults. We didn't have a maximum amount of marijuana that you could possess. And essentially, in some portions, you could say that it didn't even legalize the possession and consumption of medical cannabis. And so the Department of Health made the determination that they were going to have to find legislative support to propose statutory amendments. So what happened is Senate Bill 2344 essentially repealed and replaced the original language in the statute with a new section of law. And remember that because we're going to talk about that in a second. And what the new section of law did is it essentially incorporated all of the priorities in what's called the Cole Memo, or what's known to industry as the Cole Memo. The Cole Memo has since been rescinded by Jeff Sessions in 2018, but because states have relied so heavily on it, they are continuing to rely on it, even though it's no longer in effect. The new measure essentially went through the legislature, it passed, and it was signed by the governor on April 17th of 2017. And then the Attorney General's opinion was issued subsequently, and we'll kind of break each of those down. So the first thing I told you was that the legislative amendment 2344 repealed and replaced. And here's the problem that we have with that repeal and replace of the entire statute, is that every time an initiated measure is amended, it needs to be amended by 2/3 vote of the legislature. And so the question then becomes, if they repeal and replace, have they inherently taken away the law, and does the 7 years that it requires the 2/3 vote still apply? So that's the first issue, and we'll talk about that when we get to the Attorney General opinion. So the first task that the Department of Health had to go forward with is finding a bill that would satisfy 2/3 of the legislature. And we're talking about a divisive topic of medical cannabis in the state of North Dakota. It wasn't something that the legislature had previously supported, and so it was a pretty significant overhaul. And the other thing that you need to consider is that when the Department of Health is going in and making the determination of what amendments to do, remember that the people voted to pass this measure. And so the question becomes, how far do we take the changes, and what changes do we think are necessary? And so as you look through the law, there are still things that need to be changed, and there are still things that essentially could improve the law. But at this point in time, it's kind of what we have, and we'll continue to work through them as the program continues to be implemented. So let's talk about the Cole Memo and the priorities that were put in the North Dakota law. So the United States Justice Department essentially issued the Cole Memo. And what they said is that at the time they had limited resources, and they weren't going to prosecute individuals or go after states where they implemented cannabis programs, whether adult use or medicinal use, as long as the departments had essentially maintained these priorities. And the priorities essentially had to do with preventing the distribution to minors. It talked about diversion from the states where it was legal to states where it was not legal. And the laundry list of all these things is listed. And so the Department of Health's primary goal was to make sure that these priorities were listed. So again, keep in mind when we're looking at the original measure as it was stated, there was no distinction between adults and children. So if I was a child, I could conceivably grow up to, I think it was 7 marijuana plants by myself. I could possess an unlimited amount. And so that had to be changed. That's just a number, one of the most prevalent issues. So then the other thing that we talked about how it requires a 2/3 vote, but yet what the legislature had done was they went in and they repealed the original statute and they replaced it with an entirely new statute. So the question that was brought to the Attorney General is, does the 7 years still apply? So if the legislature goes in and they completely repeal the statute and they enact something new along the same lines, does it contain that 7-year requirement? And the Attorney General's opinion said yes. And essentially the reason for saying this was that when the legislature went in and they repealed the statute, while they made some changes, inherently they're enacting the exact same statute again, or they're doing the will of the voters through that enactment. They haven't done away with the law, they're simply just recreating it in another form at a different chapter. And so the position of the Attorney General is that the medical marijuana program and the law as it is, any change to it for the next 7 years will require a 2/3 vote. In the opinion, the Attorney General analyzed a court case from the North Dakota Supreme Court where they had looked at does the repeal essentially do away with the law, or has it just modified it to some extent? And in this situation, again, while the legislature did away with the original law, they reenacted it in another section, and so that wasn't just the complete doing away with. So let's talk a little bit about the status of the medical marijuana program in North Dakota. So this is a process overview, and a lot of the things that we have when it relates to marijuana are going to seem odd to you. But it's because of the federal illegality. So marijuana remains illegal on the federal level, and so there are a number of things that states do to kind of get around that process. So in North Dakota, a patient has to have a debilitating medical condition. They have to see a healthcare provider who's going to issue what's called a written certification. That patient is going to apply to the Department of Health for a registry identification card, or essentially a card saying that they have the ability to go purchase the product. If they're approved, then they can take that card and they can go buy the product from a registered compassion center. If you look at some of the debilitating conditions, here are some of them. They have been added to over the years by the legislature. Let me see if I can find some new ones. PTSD was an addition from the legislature, as was terminal illness. The legislature did go in and they did define terminal illness, but this one, the chronic condition, is essentially going to be one where states are going to see there's kind of a correlation between states who have chronic conditions and the increased numbers that they have. So right now, this is where states are seeing most of their patients come from. In North Dakota, that's not necessarily the case. The top number of patients right now who have a qualifying condition, the condition is anxiety. Intractable pain or chronic pain is the second. So I told you that if a patient had a debilitating condition, they had to go see a healthcare provider, and the healthcare provider issues what's called a written certification. So the healthcare providers who can issue that written certification are physicians, APRNs, and PAs. They have to be licensed to practice in North Dakota. The idea was that the legislature did not want a number of physicians from California and Florida and all these other states saying, yep, here's my patient, I've never actually seen them, but they have a debilitating condition, please let them buy marijuana in the program. So it is a North Dakota healthcare provider. And the distinction here, and here's why we call it a written certification, is because marijuana remains a Schedule I controlled substance, it cannot be prescribed by a healthcare provider. So healthcare providers are issuing what's called a written certification. And so essentially, when the bill first came out, a healthcare provider was required to say, yep, my patient has a debilitating condition, and I believe that they may see a benefit by using medical cannabis. The legislature and physicians had some concerns as far as medical ethics go and whether or not they can actually make those statements. And so at this point in time, the law was amended, and now what physicians are saying or healthcare providers are saying is, yes, my patient suffers from a debilitating condition. They don't make any certifications as to the efficacy of the product because they're not prescribing it. So I would go to my physician would say, yes, Tara has PTSD, I sign the form. The physician does not say anything else. So keep in mind, there are no prescriptions. And one of the things that I guess I want to highlight there too is, without the fact that it's a prescription, is keep in mind when you go to a physician and let's say you need a prescription for Lipitor, your patient's going to, or your physician is going to say, here's your prescription, you take this much every so often. That's not happening here. Physicians aren't saying, you take this much, you take this dosage, you take this product. They're just saying the physician or the individual has the condition. Because again, because it's a Schedule I substance, the healthcare providers don't have that knowledge and insights of what's going to work. It hasn't gone through FDA trials, and they don't know appropriate dosing levels. So they aren't making those statements. Remember when we talked about the priorities, we talked about minor patients. So minor patients now, under the North Dakota program, have to have a parent or legal guardian come in and say that, yes, my child has a condition. The physician has to say that as well, and the parent has to allow the minor child to use that. In North Dakota, under the medical cannabis program, the definition of a minor child is anyone under the age of 19. So it's not anyone who is under 18. And then what the parent is going to have to do is they're going to have to control acquisition and dosing. So at no point in time will a minor patient ever be in possession of medical cannabis. That will all be in the control of their parents. As far as patient applications, those began back in January of 2019. I'll give you some statistics at the end as far as where we are. But there's another individual in this program that is important, and it's called a designated caregiver. So what a designated caregiver is it's really anyone who's going to assist in the helping of that person, or assist the person in obtaining their product, or dosing themselves. So let's say it's me, I'm the patient, and for whatever reason I don't have the ability to go to the dispensary and to pick up my product. My brother could be my designated caregiver. He could go for me if he fills out an application and is approved by the Department of Health. He could serve as my designated caregiver. He could be the person who goes, purchases the product, assists me with dosing. Keep in mind that these people are not required to have any medical training. The only requirement on them is that they've never had a felony conviction, or it's been 5 years since their last drug-related conviction. Compassion care agents are the next primary person in this, and this is a pretty broad definition. It's anyone who's associated with a compassion center. It could be the CEO of the business. It could be the person who's called a bud tender. A bud tender is essentially somebody who helps grow the marijuana. Anyone associated with a compassion center has to go through the process to become a compassion center agent, and they are also subject to that criminal background check. So then essentially, these are again the three people or the three categories of licensees that the department has. The fees are gonna kind of drastically increase if you're an agent associated with a compassion center. If you are a patient or a caregiver, your fees are quite low, just to ensure that everyone has access. This is an example of a marijuana card, the marijuana card in North Dakota, the poor individual who has his face on here for the rest of his life. They originally put a picture of a cartoon character without asking for legal advice, and then the cartoon company reached out and said they couldn't use it. Of course. Here are the two types of compassion centers we have in North Dakota. We have 2 manufacturing facilities. Those are the individuals that are growing the product. Originally, there was a limitation on how much product they could grow. It's since been updated by the legislature to say that they can grow to meet demand. So those 2 facilities, there's one in Bismarck, one in Fargo. They pay a $110,000 license fee every 2 years. And then the next facility is those manufacturing facilities are going to sell to the 8 dispensaries, and those 8 dispensaries are going to distribute to the patients. So consider them to be like pharmacies, except for they're selling a federally illegal substance. But the dispensaries are essentially going to be where the patients are going to get to receive all of their training and their understanding of the product. So if you look at the state of North Dakota, what the Department of Health did is they went and they determined their 8 dispensaries were going to be they had to be located within one of these circles. And the idea was that 95% of the population in the state of North Dakota lives within those 3 circles. And so you could essentially make sure that patients had adequate access if you had a location in every one. So of course, in each of the major cities, there is a dispensary. This is a picture of the Botanist in Fargo. I think it's recently changed ownership and it's no longer the Botanist. If you've never been in a dispensary, you can't actually get in them in North Dakota because they're limited just to patients. But when I was in Oregon, I should probably not say this. If Wayne Stenjum is listening, this never happened. But when I was in Oregon, I had the opportunity to go into one of the dispensaries in Portland, and honestly, it was locked up tighter than a jewelry store. It was the fanciest place I've ever been, and it made me highly uncomfortable. But this is just an example. Everything's in glass cases. There isn't any product laying around. Now, in other states, if we're talking about Denver, not all dispensaries are going to look like this. North Dakota is highly regulated as far as the dispensaries are concerned. And I kind of wanted to talk quick about some of the requirements that compassion centers are required to go through. They have to have inspections by the Department of Health. They can occur at any point in time. All of the product goes through compliance testing. None of it can have pesticides used. It can't have mold. It can't have bugs. And so everything is tested by the department. There are safety and security requirements for each and every compassion center. They're going to depend on whether or not individuals are coming into the facility to purchase or whether or not they're the growing facilities. Because keep in mind, when we look at the Cole memo, we have to prevent diversion. And so the safety and security requirements are essentially there to make sure that only those people who need to have access to these facilities. And then everything is part of an inventory control seed to sale tracking system. And so there's companies that have essentially put up IT systems tracking a seed of marijuana for a marijuana plant all the way to the end user. So it's going to go through a system and the department is going to watch it every step of the way. Again, we talked about all those testing requirements. The state of North Dakota has a laboratory that it has contracted with to do compliance testing. We have a contracted lab. Our state labs don't want to do this because when we talked to risk management about what this looked like, poor Todd Anderson almost had a heart attack when we said that state employees may be handling a federally illegal substance. So at this point in time, we're having an agent of the state do it instead. And these are all the items that they're going to test for. These are all the types of product that are available. If you're a patient and your debilitating condition is cancer, you are authorized to have an increased amount of marijuana. But we have dried leaves and flowers. If your physician certifies it, you can have those. Otherwise, it's going to be tinctures, topicals, capsules, patches. The one thing that you'll notice isn't on that list is cannabinoid edibles. So in North Dakota, the program does not authorize edible products. There was a bill last legislative session to allow for edibles, but that did not pass. So I anticipate that we'll see it again. I'm not sure whether or not that will have any traction. So let's talk a little bit about the numbers. As of August 1st, there were 3,400 active licenses within the state of North Dakota. This is kind of a breakdown of where the cases or the debilitating medical conditions are. This is as of 2019, so this is old. As I told you earlier, about 25% now have anxiety disorder. That's their primary condition. And then the next one is going to be severe debilitating pain and then PTSD. So marijuana as a whole has a conundrum of legal issues related to it as we go forward. And the first and foremost, the problem is the supremacy clause. When I first began working on this subject, I had the opportunity to reach out to assistant attorney generals across the country, and there was a woman from Oregon who was wonderful, and at one point in time she said, I kept asking her, well, how do you deal with the fact that this remains illegal on a federal level? And she said, you just forget the supremacy clause exists. And I was like, whoa, I'm way too fresh out of law school to even think that everything I learned was fake and that doesn't exist. But it is something that you have to put in the back of your mind. And it really is something that is the forefront for all of these issues. The federal status, the federal prohibition really causes a significant number of issues as you kind of get down into the weeds. The next issue related that is starting to come up with the legalization of marijuana across states is going to be search and seizures. So courts are looking at, is odor alone probable cause for a search? And at this point in time, courts have said it is. The majority of courts have said it is. Other courts have said it is, but if the person provides you evidence that they're an enrollee in a program, then you're going to have additional information. Another issue that kind of started to come up around the Fourth Amendment search and seizures are canines. So if you have a canine search a car, the canine, as smart as it may be, can hit on the substance, but you don't know what substance they're hitting on. They're trained to hit on a number of substances, only one of which is marijuana. So the question then becomes, has the dog essentially alerted you to something that is now legal? In states like Colorado and the city of Denver, they're now training their dogs so that they don't hit on the odor of marijuana. And that's because they've had so many cases thrown out because the dogs have hit on marijuana, and that has kind of resulted in an issue. The next issue that we see related to constitutional issues is advertising, because again, marijuana is a federally illegal substance. The advertising restrictions around what dispensaries can advertise, what manufacturing facilities can advertise, are highly regulated. And so the question becomes, at some point in time, how do we work with the First Amendment limitations, and are we having constraints that are essentially could be unconstitutional? And so that's a topic of concern. And the last one, and essentially not the last one, but the one that we see most often are the employment law issues related to marijuana. Again, because the marijuana is a federally illegal substance, the Drug-Free Workplace Act from the federal government says that your employees cannot engage in the use of essentially federally illegal substances. And so the question becomes, well, if it's legal under state law, can we prevent our employees from doing it? And that's a question that a lot of employers are looking at and they're struggling with. And can we kind of parse those two out, or do we have to look at them separately? And at this point in time, the courts have been much more in favor of employers at this point in time. So they have said it's not an unreasonable, or it is reasonable for an employer to say, yes, you employee, you cannot engage in the use of marijuana and work here. And so that's something that I think as marijuana becomes more legalized across the states, I think we may see a shift in that. And for that's everything I have. This is our direct phone number for our office, because the last time I put my individual phone number on there, they put it on the website, and then all the marijuana supporters called me and left me really wonderful voicemails. But if you have any questions or concerns, I'm happy to address them.
Thank you, Tara. We'll take, if there's online questions or questions from the audience here, we will take those now.
Yep, we have a question from the online chat. So the question is, do you think that a designated caregiver should be medically trained? If so, what training? If training is required, should this be extended to family members who assist with other medications, such as insulin, breathing treatments, etc.?
I think that's a really good question, and it's a really hard question to answer. Thankfully, they don't pay me to make the laws. That's one that the legislature is going to have to answer. The reason right now that a lot of designated caregivers aren't medically trained is because they're just essentially they're family members. We're talking about marijuana is not covered by insurance. It's a pretty significant burden on an individual who's choosing to take this on and use this as their method of treatment. And I think by saying, hey, you have to go and you have to get a medically trained individual to help you now is going to increase the cost of that treatment. The other concern is because in medical schools and in nursing schools, you're not trained on marijuana, I don't know that there would necessarily be as much value in that. But again, thankfully, that's a question for the legislature.
All right, if there are no further questions, thank you so much, Tara, for sharing your expertise with us. All right, next up we have Terry Moore. Terry is a principal with the Helmuth & Johnson Law Firm in Minneapolis, Minnesota, where he advises business leaders on matters ranging from strategic thinking to contracts to litigation. Terry has been practicing constitutional law for over 30 years. Terry has represented individuals, businesses, and classes in state and federal courts, including the 8th Circuit and state Supreme Courts, on many constitutional issues, including First Amendment, due process, illegal taxation, and other issues. Terry has received many awards, including Attorney of the Year and the Minnesota State Bar Association's highest award, the President's Award. Terry argued in front of the North Dakota Supreme Court in Sorum v. State and will be presenting today on constitutional issues cited in that case. Thank you, Terry.
Thank you. Good morning, everybody. I should say good morning, clients. If any of you are taxpayers of the state of North Dakota, you are our clients in the recently decided Sorum versus State of North Dakota. Quick procedural posture in the district court. Well, background on the statute. I'll simplify. I realize I'm following the pod princess. I'm ahead of lunch. We'll get this done. So basically, in 2017, the North Dakota legislature passed an act that said the state of North Dakota no longer owns the riverbed of the Missouri River / Lake Sakakawea above the pre-Garrison Dam 1953 ordinary high water mark. It also gave away $187 million in refunds because that had been collected on royalties for leases since 2006, mineral leases in the area. So as taxpayers' lawyers, we sought to have the statute declared unconstitutional. Number of theories, but we're going to focus on the anti-gift clause because that's how the court decided the case. And really, if you're going to pass, we always felt if we didn't win the anti-gift clause, the other stuff wasn't going to help us. So we went to district court where the taxpayers and the state cross-move for summary judgment. Taxpayers win an injunction and a finding of unconstitutionality on about $187 million of refunds. State wins summary judgment on 96,000 acres. Basically, the district court, well, we don't even have to go into the district court's reasons for its decisions because both sides appealed, and as the taxpayers did not get the result we would have hoped for. We'll talk more about that. We have, the decision came out about 2-3 weeks ago. We filed a petition for rehearing on Thursday of last week, and we're waiting to be granted that petition for rehearing because they are granted so often. But here's what came out of this case. We got hundreds of millions given away. We got billions of dollars worth of mineral rights. But this case may go down 10 years, 20 years, 30 years from now for the decision the court made on the standard for a facial challenge. Now, I presume everybody who's attending and listening to this conference has an idea what that is, but I'll explain it anyway. A facial challenge, of course, is one where the challenge to the statute is it is unconstitutional on its face. There's no constitutional way or application to it, and it has to be stricken down. The other type of challenge is an as-applied challenge, which is the statute may be generally constitutional, but it's unconstitutional as applied to me. So taxpayers, if they're challenging a statute, always challenge the statute as a facial challenge, as were we. Now, there's a 1987 case, U.S. Supreme Court case, called U.S. versus Salerno. Now, in that case, which was a pretty routine facial challenge case, toward the end, in dicta, there's a comment by the court that says, in a facial challenge, it will succeed only if there is no application of the law which could be constitutional. Now, this has been much criticized and also much quoted around the country. Federal district courts, courts of appeal, state courts. And in North Dakota, coming into this case, before our case was filed, the North Dakota Supreme Court had addressed Salerno on 2 occasions, both in the last 5 years. One was called the Larimer case. And by the way, quick aside, I talk about a lot of cases. I've got all the citations. I think they're being distributed. It's just a list of the citations, so I don't have to continue to cite them and further distract from myself. So, in the Larimer case, it was a horrible school bus accident. The families of the injured challenged the constitutionality of the municipal liability cap. The Supreme Court quoted Salerno and said, well, if the injuries were under the threshold, it would be constitutional. And the fact that yours happened to be over doesn't make it unconstitutional because there is a constitutional application. Citing Salerno, not dwelling on it, kind of in passing, but important to the decision, critical to the decision. And then later that year, or a year or so later, I should say, the court had the Schoon case. Now, I thought this was interesting as we were briefing the Salerno, which we'll talk about more in a minute. In the Schoon case, I thought the court really didn't have to address Salerno. It was a facial challenge, and they had decided it. And then the court came in and said, quoting U.S. Supreme Court cases, saying the Salerno is the Supreme Court cases complaining call it, for example, one calls it a fictional standard. Another one says that it is not the test for viability on a facial challenge. This comes right out. It's been cited many, many times on both sides. So in the Schoon case, the North Dakota Supreme Court didn't touch Salerno itself, but talked about cases that complained about Salerno and quoted saying, the normal facial challenge, we look at a statute by provision. The normal thing is, if part of it is unconstitutional, we will declare the facial challenge successful and strike down that point, leaving in those points that would be constitutional. This would have been a dagger in the heart of Salerno in North Dakota for the facial challenge standard, except the court didn't say, we hereby don't accept Salerno. So come now to Sorum versus State. The taxpayers have challenged, among other things, the giveaway of $187 million in refunds collected from 25,000 leases dating back to the 70s, and the abdication of all mineral rights in 96,000 mineral acres in the Missouri River / Lake Sakakawea. Okay? We said, well, state owns it, act gives it away, violates the anti-gift clause. If you can't give a Supreme Court argument in 3 steps, figure it out, you gotta get another argument. So the state said, no, under Salerno, the state, in order to violate the anti-gift clause, have to own all 96,000 acres. So if there are 10 acres in there that the state doesn't own, well, it would be constitutional because the statute doesn't give that away because we don't own it. And this is, as I said, we had some fun arguments to make on that. For example, one of the arguments was, well, would it be constitutional if the state gave away all its mineral rights on dry land in North Dakota, in Williams County, North Dakota, because private people own some other mineral rights? We argued, would it be okay for the state to give away all its money in a certain bank because others had money in the same bank that the state didn't own. So that's really where the argument came down to at the Supreme Court, at the oral argument. And I'm happy to say we won that issue. But when I say this is where it will be, Sorum versus state might have serious constitutional impact over the next generation, is they took on Salerno, they took on that state argument I just recited, and they said in no uncertain words that you cannot make a statute constitutional by adding, you can't save the constitutionality of a statute that's partly unconstitutional by adding constitutional aspects. So we did win that issue. Anyway, taxpayers. So the decision went on to talk about the Submerged Land Act. And this is where the court, I believe, made a mistake of law. But having decided that the argument wasn't constitutional, I'm sorry, the state's argument was not viable, the court went on to find that the state never owned the money in SIF, $187 million, didn't own the 25,000 leases it had been signed onto and collecting on since the 70s, didn't own any of the 96,000 acres. Therefore, the state can't violate the gift clause by giving away what it never owned in the first instance. Well, how do you find that the state didn't own the land? Well, first of all, you have to look at what was our argument? Why did they own the land and the mineral rights and the money? Okay. 1953, the Submerged Land Act said any federal any federal lands beneath waters acquired by the federal government for purposes of navigation, read the Garrison Dam. No question that the Submerged Land Act, federal act, applies to the 96,000 acres we're talking about, okay? It said all that riverbed, all that lake bed, if the water's navigable, federal government is giving it to the state. So we thought that was a pretty good reason for ownership. Then our second argument on ownership was 1989 State Sovereign Lands Act. And we'll get more back to the Submerged Land Act later because that's critical. 1989 Sovereign Land Act said all the beds of navigable waters are hereby transferred to the state. It's self-executing, da-da-da-da. So, all right, that's our second nail. Then 1979, we had the Furlong case, 91, the Mills 1 case, 99, the Mills 2 case, 2016, the Reap case, all saying if it's navigable water, the state owns up to the ordinary high water mark as it changes from time to time, as affected by the Garrison Dam. So that's our third nail. And we felt pretty good. And really, if the court finds that the state owns this money, these mineral rights, then we almost have to win the case because it's absolutely, the state makes no bones about we don't own any of this anymore. So back to the Submerged Land Act. And this is where I believe the court made an error of law, and is what we briefed on our petition for rehearing. Under the Submerged Land Act, there's a grant, Section 1311, for those of you keeping score. There's a grant of all the lands that I talked about before. However, under Section 1313, there's an exception. There's an exception to the grant. In other words, federal government is giving the states everything except anything that they've acquired in a proprietary capacity. Well, what's a proprietary capacity? What does that mean? Well, the Submerged Land Act tells us in section 1314, they talk about paramount capacity and proprietary capacity. Paramount capacity is, in our case, navigation, but think of broad government, international affairs, things that are paramount. Whatever else the government gives to the states, the federal government, they cannot give these away, right? The control of navigation, the common defense, the international trade, interstate commerce, et cetera, et cetera, et cetera. Those are paramount. Proprietary capacity, in our case, you can think of it as the development of the minerals. A proprietary capacity is what a private person might do if they owned the land. The government bought this building so that we could build an office to house government employees. Okay, that's proprietary. Those kind of development, commerce, use of government where it's acting as a commercial capacity, etc. So, under the exception, remember, government gives us everything except what it keeps. It's keeping what's in a proprietary capacity. So, we need to figure out whether that is a proprietary capacity in which they bought the land or a paramount capacity. Well, that, we get there and it gets pretty easy because the Flood Control Act, flood control, paramount, Flood Control Act of 1944 authorized the Garrison Dam, authorized the acquisition of all this property that we're talking about. In 1944, the Flood Control Act says in a lengthy purpose statement, its purpose is navigation and flood control, paramount activities. But then it gets even easier when we say, well, in 1944, nobody knew there was oil in the Bakken. There was no technology for retrieving submerged minerals. Nobody was thinking about oil at all. Did they get this to control navigation and flooding, or did they get this land to develop the minerals underneath? Well, if you want a clincher, in 1951, when oil was discovered in the Bakken, at that point the federal government stopped acquiring the mineral rights. So the federal government did not get this land in order to develop the minerals in a proprietary capacity. Pretty clear that they did it in a paramount capacity, which means that the exception doesn't apply, which means that in 1953, and the Submerged Land Act gave this riverbed from the federal government to the states, to the state of North Dakota, which then gets us to the 89 Sovereign Lands Act, to the Furlong, Mills 2, and REAP, 40 years of Supreme Court cases. So we've petitioned for rehearing on that basis. And again, I think we'll see what happens with that. I do think this Salerno approach by the Supreme Court here is something that you guys will be citing in facial challenges in North Dakota your whole careers. So with that, I want to thank you for having me. Does anyone have any questions?
All right, if there are no questions, thank you so much, Terry.
Thanks, everybody.
Thank you. We are going to break for lunch, and we will see you all back here at 1. Thanks.
Test.
Check test.
She's right there.
Okay, and so. when it switched audio devices, it looks like it went to 100% on the HDMI. It's weird, yeah, I have no control. Okay. Didn't happen again, so. Well, I turned it to 2 rather than mute, so that it'll you know, if there's any sound that pops up, it'll be really quiet and shouldn't disturb anything. Test, test. Very good.
So, Professor Sigler is going to give some welcome back remarks after lunch, then I'm going to introduce you, and then while I'm giving my introduction, you two can switch places. So that's your own pace, if that sounds good.
Sure.
Is that okay? Nice to meet you. I'm sure you don't know Alex Sigler.
Okay.
Yeah, exactly. I'm still getting used to it.
Good afternoon, and welcome back to the North Dakota Constitutional Law Symposium, where we are commemorating over 130 years of the North Dakota Constitution. I'm Professor Alex Sickler, the faculty advisor for the North Dakota Law Review. Before we start the second half of today's program, I'd like to take a few minutes to thank all the folks who worked hard to make this year's symposium a success. First, I'd like to acknowledge the Law Review's outgoing editor-in-chief, Alexandra Carthew, and outgoing managing editor, Logan Carpenter, who assumed the additional responsibilities of planning this year's symposium. As you can imagine, planning and executing this annual symposium is an enormous undertaking in an ordinary year, but this is no ordinary year, and the extraordinary circumstances in which we find ourselves required that Alex and Logan plan this event not just once, but several times over during the last 12 months. And their dedication to planning the symposium did not diminish even in the face of the challenges presented by the coronavirus. I'd also like to thank Jay Moore and Rob Carolyn of UND Law School, who helped bring the symposium to fruition, again, coordinating many, many details several times over, along with other law review editors and members who have devoted time and effort to today's program. Thanks also to Assistant Dean Brad Parrish for arranging for CLE credit, and Associate Dean Julia Ernst for being here and for sharing some closing remarks with us at the end of today. Thanks also to Dean McGinnis and to SBAN for their ongoing support for the North Dakota Law Review. I'd also like to express gratitude to our presenters and our panelists for taking the time to be here today and to share their expertise on contemporary state constitutional law issues. Finally, thank you to everyone who is participating virtually. We hope that you enjoy the second half of today's program and that you will join us in April 2021 for next year's symposium. And with that, I'll turn things back to Alex and Logan. Thank you.
Thank you so much, Professor Sickler, for those wonderful remarks. Our next speaker is Justice Jared Tufte, who was elected to a 10-year term on the North Dakota Supreme Court in 2016. Before serving on the Supreme Court, Justice Tufte was a district court judge in the Southeast Judicial District with chambers in Valley City. From 2011 to 2014, he served as legal counsel to Governor Jack Dalrymple. During his time at the governor's office, he was also a senior policy advisor to the governor, with a portfolio including tribal state relations, courts, corrections, workforce safety, emergency management, and energy issues. A native North Dakotan, Justice Tufte grew up in Grand Forks and West Fargo. His undergraduate education was in computer engineering and economics at Case Western Reserve University in Cleveland, Ohio. After working as a software engineer for Motorola on its cellular telephone network equipment, he earned a law degree from Arizona State University, graduating first in his class. Following law school, Jared served as a law clerk to Judge Roger Woolman on the U.S. Court of Appeals for the Eighth Circuit. He and his wife, Mai Lynn, have 3 children. Justice Tufte wrote a companion article for the symposium issue of the North Dakota Law Review, out later this fall. It is titled, The North Dakota Constitution, An Original Approach Since 1889. He will be presenting on that same topic today. Welcome, Justice Tufte.
Thank you. I guess that was the long version of my bio. Apologies to the audience that had to listen to so many details. Just as an introductory point, I'm using a slides service that those of you who are not here in person can follow along online. I know we will have a camera trained on the screen here, but some of the slides have a little more text in than the professionals recommend. And so if you want to log a separate browser window into slides.com/tufte/deck/live, you can have a live shot of my slides that will advance as I advance the slides here in the room. You certainly want to keep the YouTube screen up if you want to participate in the comments. So first, thank you to the board, both outgoing and incoming, for inviting me to participate. I probably would not have been motivated to ask and research some of the questions that came together into this article and my talk here today if I hadn't been prompted to give some thought to participating. So thank you for asking me to do that. Thank you to Nick Samuelson, my most recent clerk who's now out in the real world of practicing lawyers. And it's, as a fairly new judge, it's always fun to see your clerks active and participating. And so it's fun to see him participating here along with me on the same panel. So my talk here today, as I said, will largely track my forthcoming article. It's simple in concept, and really it's a question that I found myself asking as I was a newer member of the court, coming to that job with some ideas about how I think constitutional issues ought to be approached. But I think any fair-minded person wants to ask, well, how has this institution that I've become a part of interpreted the state constitution, and what's our history and tradition and primary mode for interpreting constitutional issues, and is my initial take on what the right approach is consistent or inconsistent with what the court's done both in the early days of statehood and more recently. And sort of secondary to that, I asked along those lines, what sort of arguments, what sort of sources and methods have resonated with the court when approaching our own unique constitution, and to what extent are those things that are maybe a lost art in some respects, based on some of the arguments I've seen in a few of the cases that have been before the court, especially in those early months and first year or two. So I'll close today with based on my historical kind of empirical look at what the court's done in terms of its approach, with a few thoughts for things that an advocate wants to make sure that he or she addresses in presenting issues relating to the North Dakota Constitution that aren't well developed in the case law that we have. So try to be precise in my speech and lay out a couple of definitions, because some of these terms are things that people use in different ways. Different scholars even focusing on constitutional interpretation issues will sometimes use these terms in different ways. And so I'll just lay out what I mean by a couple of these terms before I get too far into the discussion. So originalism. Quite a variety of scholars that work on mainly federal constitutional issues and scholarship and interpretation. One is from our neighboring state of Minnesota, Michael Stokes Paulson. This isn't by any means the only definition of originalism, but it's one that I think is pretty complete and fairly nuanced articulation of at least one thoughtful scholar takes the term to mean. And so he says that originalism is the task of constitutional interpretation is to accurately ascertain and then faithfully apply as law the objective original public meaning of the words and phrases of the Constitution as a written legal instrument, that is, the meaning that the words and phrases would have had to a reasonably informed speaker and reader of the English language at the time the text was adopted, considering the structure of the document and specialized uses of any terms of art. There's a lot in there, and I don't intend to parse through all the nuances or discuss some of the competing definitions. I would just note at this point that some flavors of originalism speak in terms of original intentions rather than original meaning, sometimes caricatured as getting out a Ouija board and trying to channel the framers about what they really thought this meant or how it would apply in the real world. Modern originalism would tend to focus more on original meaning. And I would also note, as you see a photograph from the announcement of the filing of the Victims' Rights Amendment here just a few years ago, originalism is not just about interpreting old texts. These are tools that apply just as well to something enacted 5 years ago, 10 years ago, 20 years ago. They may apply differently because as we'll get into it, originalism in part was an interpretive approach developed and articulated and elaborated to address problems when language evolves over time and older provisions may not carry the same meaning that they do to a modern speaker or reader of the language. And so distilling it down in order for me to assess what our court has said it's doing in terms of constitutional interpretation and whether or not that overlaps or coincides with originalism, I'm quoting Randy Barnett and Evan Bernick here, that the core requirements of originalism are: one, the meaning of a provision of the Constitution was fixed at the time it was enacted, and they'll call this the fixation thesis. And 2, that fixed meaning ought to constrain constitutional decision makers today. And then they'll refer to that as the constraint principle. And so for purposes of my paper and our discussion today, I break out into a separate third element that the thing that is fixed and the thing that constrains is the original meaning of the constitutional text. The original meaning aspect is somewhat implicit in both of those two elements, the way Barnett and Bernick frame it. So what are the competing interpretive theories? There's a variety of them. For my purposes, I'll take any of these, living constitutionalism, purposivism, common law constitutionalism, as rejecting one or both of fixation or constraint. They either dramatically qualify or reject categorically some aspect of those core elements of originalism. And then one other side point as sort of a point of introduction. Originalism versus non-originalism is in sort of the legal commentary and some of the popular press often portrayed as a left versus right political axis kind of a division. And I'd just like to point out at the beginning that's not at all universal either. Certainly you could point to recent writings from Professor Adrian Vermeule, who's on the political right and who's rejected originalism as being inconsistent or insufficiently advancing what he views as the proper constitutional interpretation. On the left, political left, you'll find originalists, Akhil Amar and Jack Balkin and others who maybe run against the grain a little bit in that score. So this isn't at all uniform, and I think as you'll see how the court has approached the issues, it's not been labeled originalism until recently, but the core elements of what's now called originalism show up again and again. So finally, what kind of a claim is this? And the first sentence that you'll see here on the slide is really what I'm talking about today. What does the court say it's doing? That would be a pretty objective thing. You can read the words the court says. The court often sets out its interpretive principles, more recently pretty consistently in sort of a statement of the rule or a statement of our principles, and then an application of those. There's a period of time in the court's history where it regularly did not expressly state what the interpretive principles were. It simply either dove into direct application of the text, or it directly applied cases that had been applying that text without grappling with the text itself. So I'm not going to answer the second question. What in fact is the court doing? Is the court saying it's doing one thing and doing something else? Is it negligently or intentionally engaging in something different than what it says? Academics are much better at those kinds of arguments and discussions than sitting judges. And certainly without briefing an argument, I'm not going to be interested in trying to relitigate cases that have been decided previously by my court. And then finally, the last question, what should the court be doing, is also a separate question, also really beyond the scope of my narrow question here today. That'd be more of a normative question about philosophical and moral considerations about how courts, what objectives they should be aiming at in their interpretation. So with that out of the way, we can get to what is my claim and what am I trying to defend here today. Originalism best describes how the North Dakota Supreme Court has described its interpretive method for the North Dakota Constitution. So how did I attempt to answer this question? And I'll cover this at high level. It's in my paper. I try to show my work. I don't want my readers to wonder if I'm cherry-picking cases that support a preconceived notion. I want you as a reader, if you're interested or skeptical, to be able to reproduce my work, to replicate my searches, and to come to your own conclusions. So I tried to map out what I think is an objective selection of cases, understanding that the North Dakota Supreme Court has more than 17,000 published opinions. I can't read them all. I could ask my law clerk to read them all, but they'd promptly object to that as well. Even narrowing that down to the cases that cite or mention the Constitution, we're looking at over 1,500 cases, which is still an insurmountable hill to climb. And so what I did here was, using Lexis and Westlaw searches as a starting point, identified some keywords that helped me find which cases mention the Constitution. And because of optical character recognition and different citation styles. You have to use a variety of abbreviations for Constitution. You have to use a variety of phrasings. Organic law is sometimes used, things like that that aren't direct citations, and they don't often show up in the, they don't always show up in the citations in Lexis and Westlaw. So I put those together. I divided the time period into two, broke it at 1950 so that we could look to see whether citations patterns were different in the early years of statehood as compared to today. And I took those well over 1,000 cases and said, let's use this Westlaw search to sort by most cited. The theory being if there are cases and opinions that our court has regularly cited, they're much more likely to be a well-vetted statement of what the court's principles are. And if it's an outlier statement or an unusual or idiosyncratic statement, it's probably not something that the court's as likely to cite and to repeat. And so I filtered those down to the top 50 or so in each time period, and I had to find a breakpoint, and it's all labeled out. But one little nuance point, though, Westlaw's most cited search will aggregate brief citations in briefs, citations in secondary sources like law reviews, and no offense to any law review board members, but I wasn't interested in which cases were cited by the law review. I wanted to know what the court thought its method was. And so on top of all of that, and I think that's about enough detail on that topic, I layered on anything that Westlaw had put under its keynotes related to constitutional interpretation, whether they were cited one time, no times, 50 times. I added those to the pile because some other person, not me, had determined that those were relevant to how the North Dakota Supreme Court interprets its constitution. So that's my set of cases. And so what we did there was classify those according to, do they say anything about fixation? Do they say anything about constraint? And do they say anything about original meaning and how that's determined? And so just to summarize on the fixation classification of these cases, among those pre-1950 search results, I was only able to classify 13 out of 78 cases as including statements that appeared to agree with the fixation principle. I found one that appeared to disagree with that fixation principle, and 64 were silent and couldn't be fairly classified. And then among the post-1950 search results, 13 out of 115 appeared to agree with fixation, 3 disagreed, and 99 were silent. So we'll get into why so many cases are silent, but at least at first cut, those that you could classify appeared to be significantly in favor of supporting fixation. And I want to talk about a few of those illustrative cases to illustrate what I'm talking about here. So first case, pretty old one, you'll see 1904, Berry versus Truax. Berry case stands for the proposition that right to jury trial that's in our Declaration of Rights was fixed in all its essential elements when it became a part of the 1889 Constitution. And so the way the court described this as the right of trial by jury is a right well known and commonly understood at the time of its adoption, and it is the right so understood which is secured by it. And we have several later jury trial cases that follow Berry versus Truax, and they focus very intently on how did the people understand the right to jury trial to work in 1889 when they locked it into their Constitution. And the facts of the Berry case are pretty simple. The guy was tried and convicted for murder. He appealed, got it reversed. He had a second trial. The jury hung. The state then wanted to move it to a different county. And what the court determined was it was the understanding of the people in North Dakota when they adopted the right to jury trial that you could move venue of a criminal jury trial to another county if it was required to have a fair and impartial jury to try the case. And so that was part of the jury trial as it was understood, and that was retained as part of the jury, the right to a jury trial fixed into the Constitution. A couple of others that more directly and elaborately talk about the fixation principle. Anybody who's been to Dunseith knows what this is. Dunseith is a small little town in northern North Dakota, and like many small towns in North Dakota, they have unusual animal statues to attract roadside tourists. This case isn't about the turtle near Dunseith, but it's about prohibition, which is similarly quaint to our modern ears, but taxpayer suit by Adrian Egbert. And He sued the city of Dunseith because the city wanted to establish a municipal liquor store. And so he's arguing under the gift clause that it's prohibited from engaging in the enterprise of the liquor business. And what's interesting about this case is the gift clause was amended a couple of times in the teens. And it was amended in 1918 to read in part that the state, any county or city may make internal improvements and may engage in any industry, enterprise, or business not prohibited by Article 20 of the Constitution. So you hear that incorporation by reference. You have to ask, what's Article 20 of the Constitution? Well, Article 20 was adopted by separate vote in 1889 to prohibit alcohol, manufacture or sale of alcohol in the state. It had been repealed in 1932, and so this Egbert case is 1946. So the question is, what does that reference to a repealed article in the Constitution mean? And so the court, relying on that 1918 amendment, it inferred that the intent of the people was, as it stated, the proponents of the amendment and those who voted for its adoption was to permit the state and municipalities to engage in business enterprises. And so there wasn't an express intent about what the effect of any future repeal of Article 20 might be, but it applied the canons of construction to say that finding room for difference of opinion, a specific reference to another provision has the same effect as if the reference provision had been incorporated bodily into the adopting statute. So that's a pretty standard rule for statutory interpretation. The court's conclusion here is that the intent of and purpose of the people when they adopted this amendment in 1918 was to include the text of 20 into the gift clause by reference, and the repeal of 20 didn't implicitly erase out the repeal of then Section 185. It didn't erase that provision of the gift clause. So that's still in the Constitution today. There's still a reference to Article 20, which has been gone from the Constitution for 90 years now, nearly. And it still means as if that text from the Prohibition Amendment was still in the Constitution, and cities still cannot own and operate liquor establishments. So Dunseith does not have a liquor store today. One last case on fixation. I believe he pronounced his name Reimers, but I took German in high school and I always want to say Reimers. So if anybody happens to know exactly how he pronounces his name, I'd be interested. But he's a regular litigant in front of the court, and in one of his cases, he was charged with following too closely. And you can find some of these, this is the actual citation, I believe. You can find some of his citations still in our court files. Punishable by a $20 fine. And he sought a writ because the municipal court refused his motion to transfer the case to district court for a jury trial on this $20 traffic offense. The question presented to the North Dakota Supreme Court was, does the jury trial right under the Constitution guarantee him a right to a jury trial for a violation of a non-criminal municipal traffic offense that is punished by only a $20 fine? The divided court, and it was divided 3-2 on this question, engaged in original meaning about what meaning was fixed at the time of statehood. Now this time, again, it's the jury trial amendment that was at issue in Berry. The court put some additional emphasis on the word remain in the provision. The majority emphasized that Section 13 says the right shall, quote, remain inviolate, and used that as somewhat of a textual hook to say that whatever it was at that point in time, that's what it would be going into the future. And so ultimately, the court said that he had the right to have a jury trial, even for a municipal, fairly low-level offense like that traffic offense that he was charged with. Just a couple of illustrative, consistent cases, because I do want to at least highlight somewhat of the spectrum of cases that I found, and some interesting formulations of how the court has nodded to and applied this fixation principle. In Newman versus Hella, this is Harold Newman of Newman Signs. If you've driven in North Dakota, you've seen Newman signs all over the place. He brought a taxpayer suit. He didn't think the state should spend money on acquiring advertising rights along Interstate 94 when it was being built. And so the question was whether the control of billboards and advertising adjacent to highway rights-of-way could be considered part of a public highway at that time, because we had a special constitutional fund that could only be spent on maintenance and improvement of highways. And so the court looked at prior statutes that authorized the highway department and gave it the duty to remove advertising signs that were in the right-of-way and that were abutting the right-of-way. The court concluded that the understanding of the amendment would have been to include signage along the highway within the highway purposes that were at issue in that case. And as the court said, the people froze into a constitutional provision, a subject already covered by statute. Twitchell versus Hall, a little bit older reference, but talking about adopting by reference for all time. Again, a pretty hard and fast fixation kind of reference. Fettig was again a jury trial case focusing on the contemporaneous history at the time of adoption, and that's the only way, the only mode of construction that you could determine the intent of the framers and what was their purpose and effect. Finally, that Sherwood case, just briefly, they were focusing on the history of a 1912 amendment in a 1992 case. Again, going back an awful long way to figure out what would the people have meant by a constitutional provision that had a requirement that any disposition of state school lands has to be by auction at the county courthouse, and how that interacted with a statute allowing sale in lieu of condemnation when a government purpose, a public purpose, was the reason for the transfer of the school lands, in that case, construction of an airport. So the focus there was on the implementing legislation immediately after the constitutional amendment in 1912 and how that reflected on the understanding of the people who voted to ratify that provision. So now you've always been wondering, I'm sure, well, what are these inconsistent cases and what do those have to say? Because Tufte up there, he says, it's 13-1 or it's pretty lopsided, but there are some going the other way, and I think we have to take a close look at what the courts said in those cases. Norton is probably the most striking phrasing that, to my knowledge, can only be found in that case. And again, I wasn't able to read every single case of the North Dakota Supreme Court. But 1934, the Constitution is a living, breathing, vital instrument adaptable to the needs of the day and was so intended by the people when adopted. That doesn't sound much like originalism there. I'll leave it to the reader if you want to go see what that court actually did and whether and how they applied that. I'm not going to engage in trying to rebut each of these inconsistent cases to prove a point, because remember, my point is, what does the court say it's doing? That's what that court said it should be doing or is doing. And if you're interested in cases on either side about what they're actually doing, you have the citations. You're welcome to take a look. Just a couple others here on fixation and what appears to be inconsistent. We have Furch, Cass County case in 1953, talking about growing complexity and integration of society, that the concept of public use naturally expands in proportion. Not real consistent with fixation there. Tormashi versus Hele, that's quoting a Nebraska Supreme Court case where they're talking about provisions of Constitution that are constantly expanded and enlarged by construction to meet the advancing affairs of men. And then finally, a little bit more recent case in 1986. It's quoting its own, partially quoting its own prior opinion, that it had once stated the provision must be interpreted in light of the superior rights of the public and the necessities of the occasion. So there is some material to work with on the other side and some interesting contrary statements. But what about all those silent cases? And just to give you some idea of what I learned in reading all those cases that I wasn't able to classify. A lot of cases mention the Constitution in passing. There's a set that mention it purely for jurisdiction, but there's no constitutional issue in play. It might be a personal or subject matter jurisdiction question on appeal. There's a whole bunch of them that cite the Constitution without quoting it, without really applying it. Some that are in the Fourth Amendment or equal protection or otherwise, that just dive right into a case that's on point, and it's a very short opinion, and there's no need in that court's opinion or analysis to elaborate or interpret the text of the provision that's at issue. They felt like a prior case had decided the question. And secondarily, on the fixation point, it's, I think, fair to read some of these cases as this provision was enacted just a few years ago. It almost goes without saying that it means today what it meant 3 years ago when it was adopted, that fixation just doesn't come up very salient, doesn't become very salient for recently adopted provisions. So, finally, a little note on what Thomas Cooley has had to say about fixation. I mention Thomas Cooley because he spoke to the Constitutional Convention. He was the best-known scholar of state constitutions at the time that ours was drafted. And his treatise, I believe, was in the, well, it says there in the citation, the 5th edition in 1883, prior to adoption of our state constitution. So what he says would have had a little extra persuasive effect on how our court and how our ratifying public would have thought constitutions are supposed to be interpreted. I believe Cooley has been cited by our state Supreme Court on the order of 300 or 400 times. I didn't collect that number. He was cited by the U.S. Supreme Court even more times than that. So not an idiosyncratic cite. And so what he says is, the bolded part, the meaning of the Constitution is fixed when it's adopted, and it's not different at any subsequent time when a court has occasion to pass on it. So, moving on to constraint here, and I do intend to leave some time for questions if there are any at the end. But constraint is at minimum that constitutional actors in any of the three branches must act consistent with original meaning. And so, a court would state agreement with the constraint principle if its opinions state that it must act and require its coordinate branches to act within the limits of what it understands the original meaning of the constitutional text to be. And of course, any doctrines or implementing rules ought to be fairly traceable to the original meaning of the text. So we're not just talking about cases where the court is upholding a facial challenge and striking down a statute. We're talking about both upholding laws that are clearly constitutional and striking down laws that the court believes contradict a provision of the Constitution. And on the statistics on that, similarly lopsided. Pre-1950, I had 38 out of 78 indicating agreement with constraint. So a few more that you're able to classify there. 1 that appeared to indicate disagreement, and 39 as silent. Post-1950, I had 29 out of 115 state agreement with the constraint principle, 1 state disagreement, and 85 appeared to be silent or not able to be classified. So a few illustrative cases there, what kinds of cases and statements that I'm referring to when I think this court has said that it's applying something that looks like the constraint principle. Again, starting with an early case, Landboard versus McMillan, you see a picture of the, as it was then called, the State Normal School in Valley City, North Dakota. The court said, when the Constitution speaks, its voice is supreme, and its mandates are to be obeyed by all departments and all officers of state government. And here, the second quote I have on the slide, they're quoting Cooley for the true rule that contemporary construction can never abrogate the text, it can never fritter away its obvious sense, it can never narrow down its true limitations, and it can never enlarge its natural boundaries. So here the court had declared unconstitutional a statute that authorized investment of the permanent school fund in certain state bonds, and essentially the state had an argument that said it was a bond for this purpose but not for that purpose, and the court didn't find that argument terribly persuasive, and it interpreted the debt limit provision to prohibit the investment, even though that it acknowledged the legislature had intended for that investment to be authorized by the statute at issue in that case. Northwestern Bell versus Wentz, 1960 case here. We have challenges to a statute that allowed the state to pay utilities, including Northwestern Bell, the telephone company at the time, relocation costs when they're expanding or changing roads. The state authorized payment of costs to move the phone and power lines. There's a gift clause challenge there, that if the state had no legal obligation to move those, then the challenger said that it would be a prohibited gift under the gift clause to to pay that expenditure. And so here we have the court saying that the Constitution is paramount and it's a self-imposed restraint on the people in the exercise of their government sovereign powers, either themselves or through their agents in the legislature. Pretty direct statement, I think, there of constraint. This is actually, I think, the only case I cite from a time when I was on the court, just to illustrate the constraint and fixation and constraint both can come up in recently adopted constitutional provisions. But here I cite this in part because the usual formulation, and many of these are facial challenges, but not always, is that a statute's in conflict with the Constitution and it's void from the beginning as if it was never enacted because the legislature lacked the power to enact it. And that issue in the Strom case was a statute that was constitutional when enacted, and the Victim Rights Amendment became part of our state constitution in 2016. And so when the legislature does that, you call that an implied repeal. When the people do that and enact a constitutional provision that conflicts with existing statutes, it's similar to an implied repeal, but the way the court phrased it in that case was to render those inconsistent portions inoperative and unenforceable. And so those were effectively abrogated from that statute. So a couple of quick highlights on other consistent cases. I try to span a range of time to show at least what I think is a pretty consistent articulation of some of these principles along the way. We have Standish versus Nomlin back in 1893, where the court says if the legislature in any act disregard the mandate, it's the duty of the court to nullify the act. And the fact that the abortive legislation may be highly beneficial and salutary in its nature can in no manner control that duty. Again, we have the Constitution limiting the power of the people's agents, especially the legislature, in State versus Taylor. We have Langer articulating that it's equally obligatory on the court and on the legislature, and it's the duty of the court to uphold it in its plain words and meaning, so long as the court has imposed on it the sworn duty to uphold the Constitution. So these go back to those early cases, and they continue in more recent cases involving Reimers and others. But we do have a couple of inconsistent cases here that I think you also, again, have to acknowledge. And one of them is Norton again, the one that I mentioned as inconsistent with fixation. And so here we have a different piece of Norton, a different statement in Norton, where it says the Constitution was not a hard and fast piece of legislation, but a declaration of principles of government for the protection and guidance of those upon whose shoulders the government rested. This doesn't sound quite the same articulation of constraint or mandate or hard limits, but of guidance and declaration of principles. Definitely a different flavor. If you're interested in that Norton case, I think this case has echoes of the advice that Cooley gave at the Constitutional Convention. He articulates some very similar sounding themes in what he said, and those are at the Journal of the Constitutional Convention at page 66 and 67. Finally, we do have a more recent case, McCarney versus Meyer, in its election case. And in that case, they were talking about the requirements for referendum petitions. And the constitutional provision at issue says, each elector signing a petition shall also write in the date of signing and his post office address. And so the court took that provision, and it reasoned that it wouldn't promote the purpose of the Constitution to exclude a signature just because the signer failed to comply strictly with a technical requirement where the sample provided misled the signer to believe that the city and state, such as in that case Bowman, North Dakota, was a sufficient designation of a post office address. So the instructions and the forms that the Secretary of State gave out showed as the example post office address a bare city and state. And the court didn't read that as being a post office address because you can't deliver mail through the post office with just a city and state. But regardless, it went on to excuse strict compliance with a technical requirement. So I think one has to fairly categorize that as inconsistent with the idea that the Constitution constrains government actors in that situation. So those are the two inconsistent cases. We'll talk a little bit about what does the court mean when it talks about meaning. And it sounds like a bit of a tail-chasing argument, but I hope we'll get to a point of articulating what the court has said about this. So we have the court talking about two-sided communication. Any communication, it's implicit in what the word means. You have speakers and listeners, you have readers and writers, framers and citizens who vote to either reject or adopt a constitutional provision. And so the court phrases this in different ways, but it often says its primary duty is to determine the meaning intended by the framers and adopters. And so we expect, and I think it's generally true, that competent users of language will arrive at the same meaning. And if not, if the framers and the adopters have a different idea of meaning, we've got a failure to communicate that we'll have to resolve in some way. To my knowledge, our North Dakota Supreme Court has never found a situation where it believed the framers and the adopters had a different understanding of what a provision meant. But my thought there, and I think that the broad theme of the cases is it's the intent of the adopters that matters. If ever there's a potential conflict, it's what the people reasonably would have thought that meant, the people that voted to put that in the Constitution. I'll just gloss over this briefly. If you're interested in the topic of the law of interpretation, there's a fairly recent article on the broader topic that dives into some of these two-sided communications issues and what it means to read something as a legal instrument versus seeking plain meaning or ordinary meaning, how you bring in structure in terms of art. But one of the useful takeaways, I think, from this piece is to remind yourself that it's not an exercise of what do these words mean, but it's an exercise of what law did this instrument make. And sometimes in order to answer that question, you have to think about what was the law the day before this provision was adopted, and what was the law the day after, and what change did that enactment, that amendment, that new provision effect in the overall system of law. And that'll help you understand what law did the instrument make. So a couple of cases here. Miller versus Taylor, related to what was then called a state normal school, now called Minot State University. The court there grapples with the possibility that the framers and the voters of a provision might have had a different meaning. So this case turns on whether there's a technical difference between a constitutional revision and a constitutional amendment. Because there's a provision in the state constitution at the time of this decision that sets out the state hospital and state colleges and the Capitol and the state prison and various state institutions and says where they have to be. And the history of it's pretty interesting in sort of the regional divide in trying to secure some state jobs and state investment in different parts of the state. And so this provision relates to that argument and how it was settled. And the argument to the court here in this case was that a revision had a technical meaning that related to changing the Constitution by convention. And because this particular amendment at issue here was adopted through a legislative resolution that put it on the ballot, they said it wasn't a revision, and therefore the proposed changes to the state college in Minot were not consistent with that constitutional provision. But the court looked to what the plain and ordinary meaning of how the people used the terms revision and amendment. They looked at both sort of the legislative history of that resolution, and they looked at how the people in the public used those terms, and they found that they were used commonly interchangeably, and they meant the same thing. And so if there was a technical legal meaning to revision as opposed to amendment, it was the popular sense or common meaning that controlled in that case. Recall North Dakota, recall ND versus Jaeger. Again, a more recent case, a case that follows more of what I refer to as our house style on the court in terms of how opinions are structured and kind of block quoting some of these canons and interpretive principles. You'll see a couple of them here on the slide, that the court's seeking the intent and purpose of the people adopting the constitutional statement. And that's by reference to the plain, ordinary, and commonly understood meaning. Again, phrases that have evolved a bit over time, but generally the same formulation going back to statehood. And here, this was the case that was mentioned earlier today about attempting to recall a U.S. senator. And the court essentially said the proposed interpretation that you're bringing to the court is untenable because it would have added words to what was actually in the Constitution. And so the court felt it was limited by the words of the language in the Constitution itself and couldn't elaborate or adopt the proposed construction by the challengers in that case. So are there practical problems? Anybody know what movie that is? Anybody in the room? It's even sort of before my time. Okay. Remotely, if anybody wants to chime in, I don't have a prize, but if anybody in the comments, I'll try to get the remote listeners engaged. We haven't had failures to communicate. We generally do have pretty competent users of language when we write and adopt provisions. But like in contracts, like in other areas of law, the court's generally constructing a hypothetical reasonable person who's out there reasonably informed, voting on this provision and what they would have understood the language to mean and do as a legal matter. So, if you're an advocate, and several of you are here, and those of you listening online so you can get CLE credits, how do you reach these people? Because these are the people that as a trained lawyer, and if you're addressing a case in a district court or on appeal, you want to think about how can you reach your audience. And there's been some interesting commentary recently how in the U.S. Supreme Court advocates are gravitating to tailor briefs to certain individual justices and interpretive approaches that they think might work. And so you have Justice Kagan saying a few years ago that we're all textualists now, and you have commentators talking about a Gorsuch brief that some sort of more politically progressive advocates, even though they might prefer a sort of a policy-themed argument that talks about outcomes and consequences, they might go to dictionaries and close grammatical analysis and punctuation and something that they perceive as something that a Justice Gorsuch, that might resonate with him. And we've seen a couple of those kinds of opinions from him this last session that are very grammar and structure focused. So as an advocate, I think what you can take away from my talk is what's worked in the past and what do you want to make sure you don't overlook in constructing your arguments to the court today. And so just as a preliminary matter, of course, if you're in the trial courts, you have to preserve these issues and you have to raise them and brief them to the trial courts, especially if it's a facial challenge, because our appellate rules say, Rule 44, and similarly for municipal court issues under statute, if you don't raise it in the district court, it's waived, and you have to give notice to the Attorney General so that the state can participate and defend the statute if the state chooses to, and it often will. But assuming you've preserved the argument and you're still able to make it to the court, we'll start with the text. Way too many advocates skip right past what is the language of the provision that I'm arguing under, and they jump right to a case and apply the case because legal education, certainly in my day, and I think largely to this day, it's very case law focused because there's a lot of great things you can learn from reading cases. Certainly my colleagues' cases probably more so than mine, but there's an initial step. Those opinions are often interpreting statutes and constitutional provisions, and so if the cases turn on doctrine developed in federal courts or in other state courts, first tell us as a court, at least I'm interested in this question, is the language different? Is there a meaningful difference in the different language that applies to your case? The court has to determine whether the text is ambiguous because sometimes that opens up additional sources that it consider. But the court has said many times that the text is ambiguous if, quote, good arguments can be made for two contrary positions. Not two rational arguments, but good arguments is frequently the formulation. So starting with the text, of course, you do have to ask yourself, I'm a modern reader in the year 2020. Do I need to put myself in the shoes of the time and place that the provision was enacted? I might not know what I don't know about what these words meant. I've referred to the state normal school a couple of times. I don't know how many of you know what a normal school is. I didn't until I read some of those cases. It's a teacher's college. It's a college for educating teachers to be educators. And if you break down the term normal school and you figure out what normal means and you figure out what school means, you're not going to arrive at what normal school meant to that quarter, what it meant to the people who put those terms in the Constitution. So you might use dictionaries. You might not use that one necessarily, although the court has used that one quite a bit. Because that's probably the one that somebody gave you when you went off to college, and it's the one that's handy and it's on your desk. But if a provision's adopted in 1918, is that the right dictionary to consult? It might be perfectly good, but it might not be. So I'd suggest, if you're citing a dictionary, because maybe there's a reason to cite a dictionary in your argument, find one close in time to the enactment or adoption of the provision at issue. Pre-1924, everything's out of copyright. And so first edition of Black's Law Dictionary, 1891, that's pretty close in time to the state constitution. Maybe that'd be a good one to just take a look at least to see if it sheds some light on your argument. You've got Old Webster's 1886, also, again, out of copyright. Books.google.com, a variety of other sources. You can find these. You don't have to go hunting through the stacks at the law library to get these things anymore. We really are in a golden age for being able to do easy research if you're so inclined. Don't overlook terms of art. As I mentioned, normal school, but some of these other terms are treated, the unit of interpretation is not the word, but it's the phrase, or it's a compound, some sort of unit that has a specialized meaning. And so don't overlook the possibility that there's specialized meaning that you might find in those law dictionaries, but you might have to do some more digging to find out what the term would have meant to the people who adopted it. So a lot of times, like the right of trial by jury, which is treated like a term of art, is going to carry a lot of baggage from territorial code, from prior court decisions, and from other ways that people might form understandings about what those terms mean. All right, and treatises, I already mentioned Cooley and sort of why he's important. Again, these are available online in PDF if you want to check. One useful thing that I've found in at least looking at provisions from the original Constitution is that he not only discusses what many of these state constitutional provisions mean, and I'm not just talking about the Declaration of Rights, but I'm talking about the taxation provisions, the debt limit provisions, the separation of powers. He collects in footnotes numerous cases. He was a justice on the Michigan Supreme Court and dean of the Michigan Law School for quite a number of years. Those can be interesting and useful jumping off points if you need to find, from a historical perspective, a provision that hasn't gotten a gloss in our case law. Of course, if there are court opinions from North Dakota that interpret the provision you're working with, obviously you address those. I'm trying to just cover some of the things that I think people sometimes overlook, and specifically what our court has relied on. As I said, Cooley's been cited hundreds of times by the North Dakota Supreme Court over the years. The records of the convention, they're pretty sparse. There's not a lot of debate there. We don't have the equivalent of the Federalist Papers or detailed debates and amendments. Mr. Samuelson very ably covered some of the shortcomings and the limitations of what we do have. The committee work was entirely unrecorded. There is some press coverage. Most of it's not detailed. These newspapers of the day were typically 8 pages, often weeklies. So there just wasn't the inches of space to engage in much detail at all. Up until 1965, the Secretary of State published these publicity pamphlets. The courts relied on these several times to form an understanding of how the people would have understood a particular provision at issue. And so if you're looking at constitutional texts that came in before 1965, you might be able to find those and maybe develop some additional nuance or some understanding about what the people might have meant. You might also want to consider, at least as to the individual rights, that in 1889, the Bill of Rights had not been incorporated against the states. And so you have to remind yourself as a modern reader who's used to the federal Constitution being applied directly to the states that when similar language, often not identical, but often similar language was put into the state constitution, nobody thought the federal Constitution applied. So that might change your idea about how people might have thought some of those provisions operated. And so that's part of looking to the history of the time when a provision is enacted to consider what kind of problems they were trying to address with that change. And I'll close with sort of a note of caution. We've got some great advocates in this state, a lot of people that do a really wonderful job. A lot of lawyers have clients who have limited resources and they can invest endless hours of research and drafting time if they've got a private pay lawyer. And so I understand as an advocate, sometimes your client just doesn't have the resources for you to really do all the research you'd maybe like to do. And so with that context, sometimes we get arguments that are just barely a citation to the Constitution and please let me win because you can is the gist of the argument. That it's not really providing authority or reasoned analysis or giving us any textual hook, but essentially saying you can interpret the state constitution differently, so you should. And those are policy arguments that really haven't resonated with the court. I didn't find those types of arguments resonating with the court in the past. My suggestion is they're probably not likely to resonate, at least with this particular person who's on a court in the future. And so proceed with caution. If you're going to raise a constitutional issue, develop it and use some of the things that have worked in the past. My article is forthcoming, as was mentioned. I did want to mention that ndconst.org is something I've set up, and I'm collecting a lot of these sources that are, if you're interested in the history of our state constitution, if you're interested in developing and researching some of these issues, as I find them and as I use them in my day-to-day work, I collect them on here, and they're free for anybody to look at and to use to do your own articles or research or to perhaps aid in your advocacy along the way as well. With that, I'm interested in any questions or conversation.
Thank you, Justice Tufte. Ooh, that's loud. So first of all, a lot of people guessed Cool Hand Luke.
Yes, very good.
So good job to them. And then there was one question in the chat. So if a state has strong jurisprudence of interpreting the state constitution in a living and breathing document way, would the state Supreme Court have no obligation to continue that method for interpretation?
Okay, and I think I understand the question, and if somebody can ask a follow-up if I missed the mark. The way I think I would approach that question is if a court, a state high court, has a history and tradition of approaching issues in that living constitution kind of way, and the people adopt a provision into the Constitution, knowing that that's the legal regime in which that provision will be interpreted, I think that implicitly adopts the methods that people expect the text to be interpreted according to. So I think you've got a lot of legitimacy for a court that can say when the people put this in, they understood we were going to be living constitutionalists with it, and to carry on with that. Then the people have essentially told the court that the bounds are a little looser, the constraint is looser, the maybe evolution of language is looser. You might have some political theory arguments for whether that's consistent with separation of powers or whether that's consistent with kind of democratic legitimacy, that the people don't know how language will evolve. And a common example, just to sort of connect to the US Constitution, the term domestic violence appears in the US Constitution. Now, none of us understands domestic violence to mean anything other than generally spousal abuse or, somebody who is in a close, intimate relationship. But it's talking about insurrection in the US Constitution, and the language has evolved in that period of time. And I would really find it interesting if somebody were to decide our future government is going to be left to the whims of how language may evolve in unknown ways, and we choose to be bound by these unknown future evolutions of language. That's the common argument you hear against that. But I think the concise answer is, if the people are adopting a provision knowing that's the regime, then I think they're probably adopting the legal regime along with it. I hope that was responsive. If not, follow up.
One more question came into the chat. Since the adoption of the North Dakota Constitution was constrained by the Federal Enabling Act, how might the rights and liberties enumerated in the Enabling Act enter into the understanding of the enactment?
Well, and I'm not a scholar of the Enabling Act, so I wouldn't be able to put my fingertips on all the constraints that the questioner may have in mind. But Certainly there was a parameter put on North Dakota and the other 3 states that their constitution had to comply with certain religious liberty requirements, certain Republican form of government type requirements, and I think the US Congress could have decided that a state hadn't met the requirements if the adopted constitution didn't meet the parameters. As far as how that might inform the ratifying public's understanding of the meaning, that might be a useful source to take a look at, but I haven't really thought about that enough to give a full answer to that. All right.
Do we have any questions from the in-person audience?
Thank you.
Okay, thank you so much, Justice Tufte.
Technology is working good.
Testing.
Is it going to work? Okay, good.
Jeffrey S. Sutton has served on the United States Court of Appeals for the Sixth Circuit since 2003. Before that, he was the State Solicitor of Ohio and a partner at Jones Day in Columbus. He has argued 12 cases in the United States Supreme Court and numerous cases in the state Supreme Courts and federal courts of appeal. Judge Sutton served as a law clerk to Justices Lewis F. Powell Jr. and Antonin Scalia, as well as Judge Thomas Meskel of the United States Court of Appeals for the Second Circuit. Judge Sutton received his Bachelor of Arts from Williams College and his Juris Doctor from the Ohio State University College of Law. Judge Sutton served as chair of the Federal Judicial Conference Committee on Rules of Practice and Procedure from 2012 to 2016. He has also served on the Advisory Committee on Appellate Rules. He was appointed to that committee by Chief Justice Rehnquist in 2005, and Chief Justice Roberts appointed him to be chair of that committee in 2009. Since 1993, Judge Sutton has been an adjunct professor at the Ohio State University College of Law, where he teaches seminars on state constitutional law, the United States Supreme Court, and appellate advocacy. He also teaches a class on state constitutional law at Harvard Law School. Among other publications, he is the author of 51 Imperfect Solutions, States and the Making of American Constitutional Law, The Modern Experience, as well as The Law of Judicial Precedent. In 2006, Judge Sutton was elected to the American Law Institute, and in 2017, he was elected to its council. We are delighted he could travel to be here with us today. Welcome, Judge Sutton.
Thank you for that kind introduction. Thank you to the Law Review for inviting me. Thank you to the state of North Dakota. I think I might be the only person here by choice. You all were born here, you live here, you're stuck here. I've come here by choice. I think I'm the only non-North Dakotan to be here, so I really want to be here, unlike the rest of you perhaps. I also made another choice about North Dakota. My wife's mother's family, mother grew up in Culm, North Dakota. Father Cecil Ferguson is how you'd pronounce it back then, lived in Bismarck for a while. So I not only chose to be here today, I chose to marry into a North Dakotan family. Thank you so much. The other thing I would say about North Dakota is, other than my own state of Ohio, I think this is the only state that has invited me back twice to talk about state constitutions. I was here a couple of years ago, so this is now my second favorite state. And I'll be looking for a third invitation, I hope, in a year or two, but we'll see how today goes. Let's acknowledge some elephants in the room. It's a big room, there's plenty of room for elephants. Writing about state constitutions, talking about state constitutions, having a symposium on state constitutions can be a little humbling, even without COVID. I've got many stories to confirm the point, but I'll just tell you two. Story number one comes a couple weeks after this book, 51 Imperfect Solutions, had come out. I'm at church on a Sunday, and leaving church, and a retired doctor friend of mine, Dick Briggs, comes up and goes, Jeff, I heard you wrote a book. That's so exciting. Is it a mystery? I love mysteries. And I said, no, Dick, it's not a mystery. Well, is it a, autobiography? I really like that too. And I go, no, I don't think so. They said, well, what's it about? With a little frustration in his voice. And then with way too much enthusiasm, I said, oh, it's about state constitutions. Well, Dick Briggs is a very polite guy. He had no idea how to respond to that. So we had a long, awkward silence. And finally he said, you sure it's not a mystery? Fair enough. The second story is actually more humbling and cuts closer to home and takes me back to my North Dakotan wife, at least based on her mother's birthplace and where she was raised. So Peg, my wife, is a 7th grade English teacher. No surprise, she's quite good at grammar, always correcting my speech and writing. Gets annoying after a while, but I just decided to use this to my advantage when it came time to send the book off for publication. And I said, Peg, I'd really appreciate it if you just gave it a read. I'm sure I've got some, subject-verb agreement problems here, or split infinitives there, and it'd be great if you corrected this, and any other suggestions would be really wonderful. So I give her the draft on a Friday. She says she's really happy to do this. And by Sunday, she's just a chapter and a half in. Now, the first chapter is only 6 pages, so she's not progressed very far. And I said, Peg, I thought this was a little more of a page-turner, and, it is your husband after all, so a little more effort here. And she stops. She looks at me with way too much seriousness in her eyes and says, Jeff, I don't love you that much. So that's very humbling. So needless to say, read the book. You're going to love it. Now, my wife wants me to let you know that she ultimately did read the book. She does love me after all. She saw some points of it, maybe not all. But I'm not giving up on this state constitutional law thing. I'm actually working on a second book. I can't seem to give this up. I'm not sure what's wrong with me. Maybe by the end of this talk, you can give a diagnosis. But I'm going to organize my talk around my doctor friend's point that isn't a talk or a book about state constitutions really a mystery of some sort or another. And I'm going to organize this around various mysteries of state con law and my own interest in it. Well, mystery number one should be apparent is why in the world would a federal judge care? This is my 18th year as a federal judge. I never get state constitutional law cases. I think by the time I wrote the book, I'd had one. I've now maybe had a second. This has no efficiencies with my work as a federal judge. So it's really bizarre that I would enjoy this. I can, really deepen the mystery by, it's not just me, most federal judges see very few state constitutional law cases, so it's a very odd hobby for a federal judge to have. So why? What gives? Answer number one is I had the good fortune of being the Ohio Solicitor General back in the 1990s. Really a great break for me. If you're a law student, you really ought to think about working in the Attorney General's office. Wonderful job, and probably my favorite job in law, in truth. And that was the first time I realized the Ohio had a constitution. I started defending cases not only under the federal constitution, but under the state constitution as well. And I found myself really puzzling why weren't people talking about this? Why weren't the law schools teaching it? My law school, Ohio State, they didn't teach state constitutional law. And yet, these cases were big cases. School funding cases, voucher cases, tort reform cases, criminal procedure cases. I have to tell you, I lost a lot of cases in the Ohio Supreme Court under the Ohio Constitution. And maybe I wasn't a very good lawyer, but these were big cases, and it really made me puzzle why more lawyers, law schools, academics were talking about this. That was, I guess, explanation number one. But oddly enough, my real passion about state constitutional law comes from my experience as a federal judge. Not because I get the issues as a federal judge, but because I'm quite concerned about the path and future of the federal courts. What do I mean by that? Well, in one sense, being a federal judge is as good as it gets if you like to have influence, or put more crudely, power. My first year of law school was 1987. From 1987 to the present, I would say we have seen a constant upward trajectory
of the federal courts handling more issues under the U.S. Constitution, resolving more core disputes, doing more things that the American people care deeply about. Now, because I'm a federal judge, you would think I would love that. It looks like my ship has come in. Great decision taking the job. If you invest money, you'd rather invest more of it. If you have a job in government, you'd rather have more responsibility, more power, not less. So in many ways, I made a good choice. Being a federal judge is a very influential job. The one problem I've noticed after the last 30 plus years is the American people aren't fools. They may be fools in the short term, but they're not fools in the long term. And what the American people have come to appreciate is that the federal courts are exercising a lot of power, and the U.S. Supreme Court in particular is exercising a lot of power. And if you can get 5 votes on that court to support your position, you can do some very important things that people care very deeply about. Exhibit A, that the American people have come to realize how important the federal courts are, is our last presidential election. By too many accounts to deny, our last presidential election turned on a sufficient number of Americans choosing a president of the United States as a proxy to fill 1 seat on a 9-member court. In other words, the election turned on a sufficient number of Americans thinking a vote for President of the United States was most importantly a vote about control of the U.S. Supreme Court. You can read all you want about 1776 and 1789. You can read about it for the rest of your life. You'll never see anyone saying that was the government they intended to design. One in which 5 life-tenured justices on the U.S. Supreme Court could make the key decisions in American life sufficiently key that presidential elections would turn not on what that president would do as president, but what that president would do in selecting nominees to the U.S. Supreme Court. That's quite troubling. Why is it troubling going forward? What happens with this? Well, eventually, the federal court and federal judges, whether it's Chief Justice Roberts, Jeff Sutton, can go around the country saying there is no such thing as red robe judges, blue robe judges, Trump judges, Obama judges. And I personally believe that's true. If you look at my court, 90% of our decisions are unanimous. But notice what has been happening in the last couple confirmation fights, whether it's lower courts or especially U.S. Supreme Court. We now have confirmation votes that are almost 100% partisan. In the Kavanaugh confirmation, just 2 votes switched. 1 Democrat supported, 1 Republican didn't. We're getting very close to a U.S. Supreme Court justice nomination process in which the Senate vote is 100% partisan. Does anyone think the American people watching their elected representatives vote that way are going to believe that the judges they're voting for are not somehow reddish or bluish, Republican, Democrat, conservative, liberal, originalist, living constitutionalist? How can they can hear what the judges say all they want, but how can they deny what their elected officials are actually doing? And the worst part of the whole problem is it's deeply rational. The federal courts are exercising a lot of power. The American people should care who will have these jobs, whether it's at my level, the federal district court level, or the U.S. Supreme Court level. These are life-tenured positions with an awful lot of responsibility. So what do you do about this problem? My suspicion is we really have 2 options. Option A is the path we are on, and that path is one in which the court continues to exercise more power, and it's just a function of you get your rights, we get ours. Red rights, red rights, blue rights, and that's all you have. And it's the U.S. Supreme Court exercising more power, more authority, and the American people say, fine, as long as 50% of the time I win, that's good by me. But it ends, that particular story ends with a deeply politicized court, and a court in which the American people see them as politicians in robes. Whether that's true or not, that is how they will be perceived. And then when you need a court that can deliver a Brown versus Board of Education or something that the country really needs, you're not going to have enough credibility, trust that the court will do it, or perhaps a court that can do it 9-0. That gets very hard to do when there are a lot of expectations when people get put on that court. So that's path A. It's the path we're on, and my fear is that it ends in tears. We destroy this crown jewel of American government, which has done a lot of good in American history. Yes, it's made some mistakes, but it's done a lot of good, and it'd be an awfully terrible thing to lose and politicize. Path B has a glib solution and a less glib solution. The glib solution is I can solve this entire problem if all 320 million Americans read my book. The less glib answer is why would I say that? And that's that my whole theory, and it's really what I'm setting up to talk about now, is that this problem is our problem. This is an American people problem. This isn't the justices' problem. It's not the U.S. Supreme Court's problems. We Americans love judicially enforceable rights. No country in the world, no country in history has embraced judicially enforceable rights the way we Americans embrace them. That is just part of our civics education, and I think it's going to be very difficult to change that way of thinking about rights and constitutions. This is what we expect, and it's going to be hard for us to deny that. So my suggestion is we accept that, but change the way we do it. And the way we change how we do it is that we use the state courts more often, more forcefully, when it comes to identifying new constitutional rights. So that's really what I'm trying to get at today. Mystery number 2. How did we forget about state constitutions? How did this happen? Every single constitutional guarantee that we Americans cherish or that you know something about originated in a state constitution. The greatest era of constitution writing in this country, indeed in world history, was before the fabled summer of 1787 in Philadelphia. It's from 1776, when the states break, the colonies break from Great Britain. They, of course, had to create charters of government. They did create charters of government. People like John Adams wrote those charters of government. The Massachusetts Constitution, 1780, still the oldest constitution operating in the world, and of course in this country. That was the era when the constitution writing was done. Philadelphia in 1787, I hate to put it this way, was a cut and paste job, or worse yet, an act of plagiarism. All that happened in Philadelphia was they picked and chose. They said, let's set up the legislative branch this way, the executive branch this way, the courts this way. We're borrowing from Maryland here, Massachusetts there. When they did the Bill of Rights, the first 8 amendments, those are all taking individual rights from one state constitution and another state constitution. How strange that all of these federal constitutional guarantees, which we take so seriously, we rely on so heavily, somehow we've forgotten where they came from, and worst of all, forgotten that they're still there. Every state, of course, that's why there are 51 constitutions, the 50 state constitutions and the one U.S. Constitution. So that's a real oddity. The answer to that mystery is hard to pin down, and certainly hard to pin down in a relatively short talk. But I'd say it goes something like this. The state constitutions were not forgotten for the first 150 years. As Justice Tufte pointed out, when you drafted yours in, 1889, when you wrote individual rights guarantees, there was no other individual right. There was nothing, the federal individual rights guarantees didn't apply to the states at that point. So the state constitutions really did matter for probably the first 150 years. And I think probably incorporation during the Warren Court era made them a little less relevant because people thought, why not go to the U.S. Supreme Court, winner take all, national right. And that probably had something to do with lessening the influence of state constitutions. I suspect it didn't help. Some eras in American constitutional history were not known for great rights protecting eras. Think of the Jim Crow South. That obviously brought disrepute on state courts. and state constitutions as sources of individual liberty, or for that matter, property. But whatever those experiences, whatever those explanations, they make no sense going forward, because going forward we do have two sets of guarantees, and there's good reason, as I hope I'll be able to show today, for taking them both seriously. Mystery number 3 is a pretty short, easy mystery to deal with, and a little depressing if you're a lawyer. The question is whether, the mystery is whether American basketball players are smarter than American lawyers. And sadly for you all, I don't see a lot of basketball players here. The answer is the American basketball player is way smarter than the average American lawyer. Forgive me, but I'm here to tell you the truth, and the truth hurts from time to time. Why am I so confident about that? There's never been an American basketball player in the history from when James Naismith invented basketball on, I don't care whether it's CYO 7th grade all the way up to the NCAA tournament or the NBA, there has never been an American basketball player that was awarded a 2-shot foul, missed the first shot, and chose not to take the second shot. That has never happened. It never will happen. In fact, the law students in the group, you can think of 2 different ways to deal with this problem, this level of ignorance that most lawyers have. One is you can listen for the rest of my talk, and I think I'll be able to correct this problem and put you on an even playing field with the average American basketball player. Or, when you're done with 3 years of law school, take a post-grad year and play basketball for a year. And you will then, this lesson will sink in, that every time you get 2 chances to do something, why not take the second chance, particularly when the first chance does not work? So, every time there is a state or local criminal prosecution, every time there is a state or local law that your client does not care for, you have 2 shots, not 1, to deal with the problem. You have the federal constitutional guarantee, let's say 4th Amendment if it's a criminal case. You have Article 1, I forget which number, state constitutional guarantee in North Dakota for the criminal case. Use the search and seizure protection there. That's 2 chances, not 1, in order to get relief for your client. And the same with any civil laws, as long as it's state or local. 4th mystery. Am I right about what I'm saying? Is it really the case that there are 2 independent shots? Is it really true in my hypothetical criminal prosecution by a local prosecutor, and your client thinks there was a search and seizure problem in the way the arrest, discovery of the evidence was conducted? Is it really the case that the North Dakota Supreme Court could take a different path from the U.S. Supreme Court in determining what search and seizure means? Particularly when sometimes the words are exactly the same. That's a good example. Your search and seizure provision has many words that overlap completely, and for the most part is pretty similar to the 4th Amendment. And the answer is most definitively yes. All the North Dakota Supreme Court has to do in that kind of case, it does have to honor the federal guarantee. It does have to honor the U.S. Supreme Court's interpretation of the 4th Amendment. It can't reject that. The Supremacy Clause requires, it mentions state courts in particular, it requires state courts to adhere to federal interpretations of federal guarantees. That just happens to be the first shot. If you lose that shot, nothing prohibits the North Dakota Supreme Court from construing its search and seizure guarantee to be more protective, or frankly to be less protective. It can go in either direction. I mean, oddly enough, they could convert the words of the search and seizure guarantee into numbers if they felt like it. No one has more authority, no one has any higher authority over the meaning of the North Dakota Constitution than the justices of your high court. If the people don't like it, they can of course amend the Constitution, they can elect new justices, but the North Dakota Supreme Court has a final say over every phrase, every word in that Constitution. It truly is an independent shot. It is not just a second bite at the exact same apple. It's a different independent shot. Next mystery, I think I'm at number 5. Well, what would be the grounds for doing that? Let's say they can do it. You accept that there are 2 shots. It really is like a basketball game and 2 free throws. You grant me that the state court has the final say over whatever the North Dakota Constitution means. How does the lawyer pitch that argument to get the North Dakota Supreme Court interested in taking a path different from the U.S. Supreme Court? Because if your court is following the U.S. Supreme Court, it's 1 shot, all right? Does everyone understand the stakes there? If you don't get them to think independently about it, you're not taking 2 shots. You're just going to miss it again because it's the exact same shot. So how is it that the lawyer convinces a state court to take seriously the second shot under the state constitution? Well, first is real easy, and I've already gotten the invitation to come out here to speak at the symposium. Thank you. I don't want to seem ungrateful, but I'm now going to give you an assignment. I realize how unenforceable it is, but you seem to be a group of people with a conscience, even virtually. And so here's your assignment, and I hope you'll do it within the next day or 2. It might work to do it before going to bed. This kind of thing sometimes helps with getting to sleep. Pull out the North Dakota Constitution, and all I'm asking you to do is read Article 1. All right, it's not going to take you more than 5 minutes. I did it while listening to some of the other speakers. It will not take a lot of time. You are going to notice it's just going to jump out at you. Article 1 of your Constitution, first of all, is where you put your rights. Stop and think about that for a second. At the U.S. level, rights came last. Structure came first. It's only 2 years later that the Bill of Rights even come into existence. The U.S. Constitution was focused on structure, organs of government, how this gets organized. In North Dakota, by the way, this is typical of the states. All states, to my knowledge, except I think Colorado and New Mexico are the only 2 that come to mind that don't follow this. Everyone else does what you do, is you prioritize rights. It is Article 1 of your Constitution, right after the preamble. And you've got one right after the other. And you're going to notice that the norm in your Constitution is that individual rights vary, the language varies from the language of the U.S. Constitution. Different words, different meaning. So the very first thing to do, the easiest thing to do, the thing that will take the least amount of time for your client, whether it's a criminal or civil case, is just look at the Article 1. You're going to find very quickly there are some explanations for thinking about this guarantee in a different way from the federal guarantee. Second explanation for the state court to chart a different path. History. Justice Tufte talked about history, fixed meaning, original meaning, contemporaneous meaning. All of that is so important, so essential. And by the way, I'm often asked, I must have read thousands of state court opinions by now, and I'm often asked, what gets state court judges, what excites them, what makes them want to take a different path? Obviously, text makes a difference, but history they love. There's nothing that'll grab a state court more, I don't care whether they're elected or not, nothing will grab them more than an argument premised on a chapter in North Dakota history that speaks to the problem at hand. At that point, it doesn't matter whether the judge is conservative, liberal, red, blue, originalist, living constitutionalist. All state court judges are proud of their state's history. It just comes with the oath, it comes with the title, it comes with the disposition of being a judge. So the history will often really make a difference, and I guess I would say history and culture pull together. So your preamble mentions faith. A great way of illustrating that is to compare free exercise rights. You'll notice, by the way, your free exercise clause worded very differently from the federal First Amendment. But think about these states and a free exercise claim. Utah, Pennsylvania, Rhode Island, Maryland. All 4 states were founded by religious dissenters. When they put in a free exercise clause in their state constitution, they meant business. They left where they were for free exercise reasons. They prioritized the point when they put it in their constitution, and the history and presumably the existing culture confirmed the point. Now think about the difference between a state court and the U.S. Supreme Court in dealing with that history. When the U.S. Supreme Court has a free exercise claim, can it look to the history of Rhode Island and Utah in deciding what the meaning of the federal guarantee is? Of course not. They're construing a constitution for 50 states, 320 million people, God knows how many localities. They can't customize, or at least they should not customize, a guarantee to account for one segment of the population, one area, one group, one class. That's exactly what they shouldn't be doing. They're construing it for the whole country. But can a state court customize a free exercise guarantee to account for the citizens of that state, their culture, their history? Of course they can. So that could be true in North Dakota with free exercise. It could certainly be true with property rights. It could be true with right to bear arm rights. And think about that for a second. What in the world are we doing focusing on one national court saying that gun rights ought to be the same in every pocket of the country, and that's the only way to think about gun right to bear arms? That's absurd. The right to bear arms understandably might mean something different in a very urban setting as compared to a very rural setting. Property rights, again, the use of takings clauses, eminent domain. Perhaps there ought to be a difference between an eminent domain in New York City, Manhattan, where land is, I would say, pretty scarce, and Montana, where it's not quite as scarce. How could you want to live in a world where we have one rule for such diverse places? So the second reason the state court could try something different is because they can customize the guarantee, whether worded the same or differently, to account for your history, your culture. Third explanation, which I hope will surprise you because it seems a little odd, but it's actually one of my favorite points. State courts are allowed to disagree. I invite them to disagree with me. By the end of this talk, you'll realize there are plenty of reasons for disagreeing with me, and there are plenty of reasons for disagreeing with the U.S. Supreme Court when it comes to the meaning of things like due process, free exercise, free speech, equal protection, you name it. Let's drill down on what I mean by disagreement. Here's one obvious one. This applies in half the cases you will get. Half the constitutional cases that I'm talking about, what I'm about to say, is very, very true. Justice Tufte just gave a talk about how North Dakota Supreme Court historically has been originalist in outlook. There are a couple exceptions, but that seems to be the norm. Meaning's fixed. It's designed to constrain public officials. I'm not making a judgment call about this. I'm just responding to what he observed and described. If your case, we'll stick with the criminal procedure case, your Fourth Amendment case, if the federal guarantee is construed through a living constitutionalist U.S. Supreme Court decision or a pragmatic U.S. Supreme Court decision, the North Dakota Supreme Court should start with the presumption it's wrong. That, judges take methods of interpretation seriously. And if you tell me, and I happen to share Justice Tufte's views and your court's views, I'm inclined towards the originalist perspective, but that doesn't matter. But the point that does matter is, as a judge, if you tell me that was a living constitutionalist decision, I'm bound to be skeptical of it. That's not how I think judges should interpret law, but that's half the debate. There's the other half that thinks that's right. So the point I'm making is, if you have a claim, it's a two-shot claim, you remember the basketball player, you look at the state guarantee, you see the federal precedent, you realize it's a living constitutionalist precedent, you point out to your state court, you shouldn't be following this. It's not construing these words in the way you traditionally construe them. That's one form of disagreement. What's another form of disagreement? You know, the federal courts get it wrong. I'll give you just one example, and then I'll prove how many others there are. Think about tiers of review in equal protection. Now, I don't want to be too hard on federal judges. These are my colleagues, and I certainly don't want to be too hard on the U.S. Supreme Court. I report to them and just assume they don't reverse me any more than they have to. But I happen to think tiers of review is not one of the best doctrines out there. And my skepticism arises from being a law student, and I just couldn't connect the dots. It just didn't seem to make any sense to me. First there was rational basis, then there was strict scrutiny, then there was intermediate scrutiny, then there was rational basis plus. I'm up to 4. Professor Tribe from Harvard says we now have 7. I'm really embarrassed to say I don't even know the last 3. I've probably been reversed on 1 or 2 of the last 3. It explains why. I didn't know about them. But let's just put it this way. If we have 7 tiers of review, at some point, is it worth reconsidering? I mean, I do like 7. I mean, there is something to be said, you know, on Monday, the first day God said we'll have rational basis. The second day he said we have strict scrutiny. The third day he said we'll have intermediate. I mean, if you can make it biblical, it does sound, that's always good for judges to make it sound legit and credible. But other than the 7-day thing, I'm not really a fan of this. And does anyone think it's going to stop at 7? What hope of that is there? If there's 7, there's going to be 8. And, it's not even the days of the week anymore. Why would a state court casually embrace tiers of review? And why would you, as a lawyer, casually assume that's what they should do? The state courts used to deal with this through something called class legislation. They had a bunch of doctrines historically. Go read Cooley's book, you'll see them. This is a great way to get your client out of a bind. But let me give you the best. You already are experts on coming up with arguments as to why state constitutions should be construed differently, and you don't even know it. But I'm about to tell, this is worth like $10,000, what I'm about to tell you. It is so valuable. I'm just so excited I finally figured this out. Because my frustration, of course, is that the law schools don't teach state con law enough. And all they do is tell the single story about the federal Constitution. And so I used to go around complaining about that. And I've now realized, wait, this helps me. Do you know why this helps me? Ask yourself how federal constitutional law is taught. As a federal judge, I'm quite sensitive to this, and I understand it quite well. Here's how federal con law is taught in every law school in the country, at least for the last 100 years. You read the case. You come into class. One student gives the facts. Not a lot of drama. What's the holding? A little more drama, because fights about holding. But this is all by way of warm-up for the law professor, the federal con law professor and expert, to get you to the real point of the class. And the real point of every federal con law class, best I can tell, is for the professor and the students to identify all of the mistakes the federal judges have made. Let's read Judge Sutton's opinion. Where did he go wrong? He made this mistake, he made that mistake. And of course, I don't like this. I'm not even there. I can't even defend myself. It's quite agitating, as you can tell. And of course, what I like even less is it seems like the whole point is for the professors to show how much smarter they are than the federal judges and justices. Doubly annoying. But this has brought my ship into the harbor I have been waiting for the last 10 years. Because guess what this means? This means the one thing you know very, very well is you don't know what's good about Fed con law. You know exactly what's bad about federal con law. That is what you are an expert in. You are experts in why tiers of review don't work, why substantive due process doesn't work, why content-based restrictions on speech don't work. I can go on and on and on. That is the only thing you learned. Everything wrong with federal con law. What does that mean? Every time you have a state con law case, you remember what the professor said was terrible about the federal doctrine. You tell the state court judges, don't make that mistake. They'll probably remember the same lesson. Boom, you've got them. It's like the biggest, shiniest lure you'll ever use. It'll work every time. So you're already an expert in something you didn't quite realize. So the last explanation for why the state courts usually will be inclined to listen to you when it comes to charting their own path under their state constitutions is that the words we care the most about, the guarantees our clients invoke the most, and the ones we politicize the most because we fight so intensely about them, are the most generally worded. The key words in federal and state con law, the key guarantees in federal state con law, are all written at a very high level of generality. What processes do, what protection is equal, what speech is free, what exercise is free. They're constitutions, after all. They're written in very general language. They demand disagreement. The last thing that should be happening with such general language is one interpretation for the whole country. That doesn't make any sense. How can someone insist that there's only one way to think about due process for 51 constitutions and 51 jurisdictions? That is an absurd proposition. So the key thing for the lawyer is to make the point, hey, this is a general phrase, and the way to customize that phrase to our circumstances is to do A or B or C. So these general words become your friend. Mystery number 6 is, I think, where I am now. What gives that, and this is not a criticism of your state court, because I don't think they have this problem, but I will say, generally speaking, what I'm about to describe is the norm of state court judges in this country, and has been for about 50, 70 years. The norm is for the typical state court judge, when they get a 2-shot case, is they'll handle the federal claim first. Even though they're a state court judge, they'll start with the federal claim. They remember federal con law because that's all they had in law school. And then when it comes time for the state claim, and you try to say to them, hey, this is a second shot. It's an independent shot. It's a different shot. Give them all these reasons. The typical state court judge presumes that their state constitution mirrors the meaning of the federal constitution. I said the word presumes. I said it's not categorical. You can get them off that presumption. But presumptions in law are huge. Where people start as judges is often where they end. So if they presume the 2 guarantees are likely to mean the same thing, the odds are very high they're going to get there unless you do a really great job with the points I just made. Why do they presume that? Where does this come from? You know, some people think it's because they're elected and they want to say the federal courts, you know, when they do something controversial, they want to say the feds made us do it as opposed to taking responsibility. I don't know, that seems very cynical to me. It's not consistent with the state court judges I know. I actually think elections cut the other way. I think if I were an elected state court judge, I would be ashamed to be presuming that my constitution meant the same thing as the national constitution. That didn't make any sense. But let me try to illustrate the point in 2 ways and just kind of show how silly this is, and maybe this is a way you can there's a way you can use this in your arguments. Think if I left the bench tomorrow and decided to run for the North Dakota legislature. I guess I'd have to move here and get some land, but why not? You've invited me here twice. I'll come 3rd time on my own and get some property, leave the bench, and run for the state legislature. I give my first stump speech. I'm here in Bismarck. I get a few people to come. Maybe it's all virtual because COVID's still going on, and I'm all excited, and I tell people all the good things I'm going to do for North Dakota. And when I'm finally done, someone asks me, the first question is, you know, Jeff, I love your enthusiasm. Even though you're from Ohio, you seem like you're kind of like us. You certainly don't dress very well. That's good. We don't like uptight people. So maybe you'll fit in. And but I want to ask you a serious question. When you get a really hard problem, like you know, opioids is a big problem these days. Data privacy is a big problem these days. COVID's a big problem these days. Where do you go? Like, you know, how do you organize your thoughts to figure out how to solve this really difficult, new, challenging policy problem? And what if my answer was, oh, that's easy. Every time I have a really hard question as a state legislator, here's the very first thing I'm going to ask myself. What would Congress do? If I gave that answer, my political career is over. I just moved, I bought some property, I gave up the federal bench. I have no chance of ever getting elected to anything in North Dakota. There has never been a time in the history of any state in this country where you could answer a question about trying to run for state office by saying, I always look to what the national government does in solving problems for North Dakota or Ohio or Alabama or whatever it is. That is not what people want. They expect you to solve things locally. They're actually skeptical of the people in Washington. Guess what every state court judge in the country who presumes the federal constitution has the same meaning as their state constitution is doing? They're saying the answer to that question as a state court judge is, what would the U.S. Supreme Court do? I do not think that is a tenable answer. If you disagree with me, run for the North Dakota Supreme Court and try it and see how it works. I don't think it's going to get you very far. And the same thing if you run for governor. You can't say, well, what would the President of the United States do to solve our problems here? Let me look at the same problem through an historical lens, which I'm actually working on the second book, and I've got a section on the Dakotas, which I'm excited about, and I've learned some stuff today. Is it Nick, I think? Yes, from Nick, so I'm going to use some of that stuff in the book. I'm pretty excited about it. It requires a little history, but I think you'll appreciate this, and I suspect North Dakotans like this part of their history. So if you're not a state that was an original colony, that meant you were a territory. There are a couple exceptions to that. Texas, of course, thought it was a republic, but the bottom line is most states outside the original 13 colonies were territories for a while, often 10, 20 years. What did territory status mean? Territory status meant you weren't independent, you weren't sovereign. It meant you were an agency, a creature of the United States government. And what had happened is the United States government had said, in, say, the case of the Dakotas, this region will be called the Dakotas. We'll have a governor, we'll have a state high court. There were some complicated ways for creating a legislature. But the bottom line is you remained under the authority of the national government. The state high court judges were appointed by the President of the United States, Washington, D.C. What did that mean for the territories, whether in the Dakotas or elsewhere? That meant very often the territorial judges, that's what they were called, were not from the area. And their relationships, connections were usually on the East Coast, and of course with the president, his party, his supporters. People in the territories did not like territorial judges. The Dakotas very much did not like the territorial judges. One or two of them was in bed with the railroads, lots of corruption. Guess why many territories were very eager to become states? They wanted to choose their own judges. They didn't want carpetbagging judges from the East Coast, educated at Harvard, coming to the Dakotas, telling everybody how to do things. They wanted people that understood their culture, their history, their way of living, and were them. We're part of their community, neighbors, etc. Why? Because they would construe, well, first of all, the other thing statehood would do is allow you to create your own constitution, your own rights, your own structure of government. And because you selected the judges as opposed to the President of the United States, it meant the judges would reflect your values. People like that. Guess what a state court judge should be described as today, who presumes the meaning of the North Dakota Constitution is the same as the U.S. Constitution? There's a two-word phrase for that, and it ought to be an epithet. That is a territorial judge. That's back to the carpetbagging judge that the Dakotans wanted to get rid of and every other territory wanted to get rid of after the 13 colonies. That was one of the impetuses for statehood, was to have this independence and not report to Washington. How ironic that we've come full circle and so many state court judges act like territorial judges. It just doesn't make any sense. It's very odd. Well, I'd love to have questions. Well, let me I'll skip to one last mystery point. Okay, Jeff, all this is good. I get it. 2 shots are better than 1. I think I'll remember that. I'll try to read most of Article 1 before I fall asleep tonight. Thank you for that little assignment. But I still have in the back of my head that one big feature of American history is that there have been times in American history where it's been very hurtful that our individual rights were not uniformly applied across the country. So race is a good example of this problem, Jim Crow, of course, and it's easy to think of other instances where it would seem to be a very good idea to say that this constitutional guarantee is so important, it really ought to have the same meaning across the country. We don't want patchwork guarantees where search and seizure means one thing in Montana, another thing in North Dakota, still another in Ohio. And doesn't that undercut my argument? And because uniformity is such a good idea. And the answer briefly is no. Uniformity is only something you like when you like the underlying guarantee, and you'll tend to despise it if you don't like the underlying interpretation. Uniformity by itself is not a true value. The exception, of course, is if we're talking about something that actually is in the US Constitution. I mean, if we're construing something that's there, obviously federal judges, and for that matter state court judges, shouldn't be ignoring it. But all these debates are really about the cases like substantive due process, where the guarantee is not clearly in the US Constitution. In fact, it may not be there at all. It's identified through interpretation, and in those settings, uniformity is not necessarily a good, and in fact, it might be quite dangerous. One of the chapters of the book is about the search and seizure story, and in particular, the development of the exclusionary rule. The exclusionary rule is to remind you, is where if the police violate your search and seizure rights, say an illegal seizure or illegal search, usually the court will suppress the discovered evidence at the subsequent criminal trial. Now, the Fourth Amendment doesn't say anything about an exclusionary rule. Not a single state constitution says anything about an exclusionary rule. It's a classic example of something developed through interpretation, for better or worse, not taking a stand on it. But here's what I will tell you, and this kind of, I think, illustrates my point. When the US Supreme Court created the exclusionary rule in Mapp versus Ohio in 1961 or so, this was one of the reasons they did it. They did it because they thought, boy, we ought to have a rule of suppression that applies to every prosecution, all Americans, you name it. So uniformity was really one of the driving forces for why they created the exclusionary rule. They didn't want a patchwork. At that point, about 25 states had exclusionary rules. The federal government had an exclusionary rule, but that left about 25 states without one. And so they thought it's time for one uniform approach. That's why they did it. Guess what the punchline to that Mapp versus Ohio story is? Do you think we have more uniformity in search and seizure law today than we did in 1961, or do we have less? Very easy. We have far less uniformity today. Why? What happened? What can go up in US Supreme Court interpretations can go down. Since 1961, the US Supreme Court has developed exceptions to the exclusionary rule, good faith exception. Since 1961, the US Supreme Court has narrowed some Fourth Amendment interpretations, and most people are very happy that lots of state courts have filled those gaps. Uniformity by itself tells you nothing other than whether the person saying it prefers the right. It identifies nothing else. So the key thing for me, and this is where I'll close, and maybe a question or two, if I had my druthers, and this is, I guess, maybe the last mystery, why would this be good for federal con law? And the way it'd be great for federal con law is we need to go back to what Brandeis said. Brandeis said we have laboratories of experimentation. You have a new social problem. No one knows quite how to deal with it. It would be insane to pick one solution right out of the box to fix that problem. Imagine that with COVID. Imagine if the minute the problem struck, we said we have to have one uniform national rule to deal with COVID. No way. If ever there were an illustration of the virtues of federalism, it would be dealing with those challenges. So it's kind of the way you have to think about it. We have to do the exact same thing with federal con law. I don't care whether it's substantive due process, equal protection, free speech, you name it. If it's a hard issue, The U.S. Supreme Court should come last and not first. The vanguard should be the state courts. The innovators should be the state courts. When Brandeis used his laboratories of experimentation metaphor, he was talking about legislatures as the laboratories, and they could set the stage for the national government to nationalize a winning solution. My whole point is to do the exact same thing with state courts. Why not have the state courts be the innovators when it comes to this or that guarantee, this or that constitutional problem? Let the U.S. Supreme Court observe, let the results come in, and if there's a winning approach, nationalize. If there's not a winning approach, regionalize, and let different regions, different areas do different approaches. So I've talked more than I thought I would, but I'd love to get a question or two, or do whatever you want. I'm a guest, but thank you.
Thank you, Judge Sutton. Do we have any online questions? No. Any questions in the audience here?
Yes?
Hi. I hate to disappoint you because the question is actually not specifically about your presentation, but I was putting the pieces together because I recently heard a podcast. Yes, where you were featured.
Now I have to tell still more people that I only got into one law school.
Well, and I don't know about if anybody listens to Malcolm Gladwell's Revisionist History. If you don't, you should. He's a wonderful, I'm getting a head nod from Alex down there. Malcolm Gladwell's, you should read his books, and he's not paying me to say this. He is pretty good. Outliers yeah, he's great.
Good.
Yeah, and he actually showed me the podcast. So, but you were featured on, I listened to it just, I was a little late, but I listened to it a couple weeks ago, and he was, to give background, so he's a clerk for the Supreme Court, and Justice Scalia had talked about, doing this path to get onto the Supreme Court, to be a clerk, and you have to go to these certain law schools and blah, 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 but yet his best clerk that he ever had was you.
I think he meant the best clerk he'd ever had from Ohio State.
Now what the podcast
guess how many
said.
clerks he's had from Ohio State.
Now what the podcast said. I think you're being humble. I think you were the best one, if I remember correctly. And so it was, and then they interviewed you for a little bit on the episode. So again, this is Malcolm Gladwell's a lot of fun. He's a really clever guy. I think what he was coming from, it was a little bit about whether LSATs are useful indicators of who gets into law school, or useful indicators about capacity for law, and probably realizing lots of people almost did what I did, which is take the LSAT and not do well and think, well, maybe I won't be a lawyer. In fact, now that I think about it, I've humiliated myself at the beginning of the talk. Now, thanks to you, at the end of the talk. Let me. If I'm going to lose this game, I'm going to win by saying the most humiliating thing. So I'm ultimately going to win here, humble though I am. So I do take the LSAT. I have no idea what I want to do in life. Law was a third choice. I was a school teacher. Was thinking of foreign service. No lawyers in my family. I take this darn test. Do not do very well. I call my mom. What else is there to do at that point? And she says a very motherly thing, and then one of the worst things I've ever heard from anybody ever. The very motherly thing is, well, Jeff, maybe you shouldn't be a lawyer, but I think you should take the test again. It's probably not a good idea just to be defeated. Have a little grit, try again. That's good for Mom. And so the conversation's winding down. She's helped me feel better about this, and I say, well, Mom, I guess if there's a silver lining in this, it's going to keep me humble, this low LSAT score. And she goes, oh, Jeff, you already have so many reasons to be humble. My mom. I mean, I don't know, where do you go with that? Anyway, so can anybody outdo me on humility here? More humbling moments. But I think Malcolm Gladwell is quite right about the LSAT being overstated as an indicator. And my little advice point would be law is always for the turtle. It's all hard work, it's all sweat, it's all effort.
And the good news is after 10 years of that, this is a Malcolm Gladwell point, or 10,000 hours, 10 years, I guess at the big law firms, 3 years, it gets easier. It does get easier. The problem is you'll get better and more people will want your time, but I love this career. First lawyer in my family, I love law. I loved it in practice, I loved it in government, I loved being a judge. It's an awesome career. But you do have to work hard. It's not like some jobs where once you learn one little thing, it's easy. But what's great about it is it's stimulating. I mean, you keep wanting to do stupid things like write books about state con law. So, I must love it, huh? Any other questions? Or I know we have another speech or talk. So I'm so grateful to be invited. I really have enjoyed this, and good for you in doing a symposium on state constitutional law. Congrats to the editors of the Law Review, and gosh, talk about grit. I mean, how many times did you must have thought about, maybe this isn't such a good idea. God is telling us something, but you persisted, and now you know something about state con law. Good for you. Thank you.
Thank you. We will take a break until about 3:15, so thank you, and we'll see you soon.
I can just touch that? No. You can press it.
Oh, good. Perfect. So we no longer.
Welcome back. Attorney General Wayne Stenjum was unable to join us today, but we are delighted Deputy Solicitor General Jim Nicolai could step in. Thank you for being here. Jim Nicolai joined the North Dakota Attorney General's office in February 2017 to work as the Deputy Solicitor General in the Civil Litigation Division, where he represents the state and its agencies in federal and state court. Before joining the Attorney General's office, Jim clerked for both Judge Kermit Bai and Judge Myron Bright in the 8th Circuit Court of Appeals, as well as Judge Rodney Webb at the United States District Court for the District of North Dakota. He was involved in the briefing for North Dakota Legislative Assembly v. Burgum, which Jim is presenting on today. Welcome, Jim.
Thank you. Before I get started, I just wanted to apologize on Wayne's behalf that he was unable to be here after this event got scheduled from the spring till now because of the pandemic. And he doubly wanted to apologize that I was the one that he had to send to replace him. And then the other thing, I see my timer is going to black out on my phone, so I'll have to watch up there, I guess. Before I get started, too, I wanted to thank Seth O'Neill from our office. I'm a little bit technology challenged, as many people from my office could tell you. When I can't PDF a file or I screw the printer up, and Seth was good enough to help me put together this PowerPoint and search the Google and the clip art for some of the illustrations. What I want to do before I get to the case itself is talk a little bit about the story behind the case. And where that story starts, interestingly enough, after following Judge Sutton and Justice Tufte talk about North Dakota state constitutions, is a provision of the North Dakota state constitution, in my opinion. This is the story behind the story starts here. And that provision is found in Article 4, Section 7, and it says, no regular session of the Legislative Assembly may exceed 80 natural days during the biennium. In other words, North Dakota has selected a biennial legislative system, which means the legislature only meets every 2 years. It can space those 80 days out, but every 2 years it only has 80 days to do its business. Well, what does that have to do with this case? Well, think about it. If we had to pay our bills and plan for all our contingencies in just an 80-day period for the next 2 years, what problems practical problems that could create? The furnace goes out, you need a new refrigerator, you have flat tires on your car, you need a new engine, you have unexpected medical bills. So many things can happen in a 2-year period. And that's the practical problem that a biennial legislature has. And think about all of the services that are provided by the state and all the expenses and all the money. So many things, the Department of Transportation, Department of Human Services. The state doesn't operate only 80 days a year, it operates year-round. And there's all kinds of things that can happen. A tow truck or a plow can go out. The state can get a huge expense in litigation. So many things. And so we can't just go around and give every state agency one of these things with a pocket of money in it and say, oh, in case something comes up, there's your money. The legislature has to plan. And, you know, as North Dakotans, we pride ourselves on being practical. So what did we do about this problem, this practical problem? Well, it starts in 1965, and I don't know if you can see the date up there, but the legislature decided that we better create what they called a budget committee. So they passed this resolution in 1965, and then the next year, that became a reality with one of the responsibilities of this committee to report to the director of the budget. Flash forward now 5 years later, and by then, we actually have 2 budget committees, Budget Committee A and B. And there were enough things, to do to control the budget, to help with the budget, that they had created 2 subcommittees. And in 1971, they said, well, we have these 2 smaller budget committees. Some things are important enough, we want the whole group to come together. And they called that combined budget section committees, or combined budget committees, a budget section. And that's where we have that term come from, called the Budget Section Committee. And then there are many things that happened from 1971 up through 2017 before this lawsuit between the governor and the Legislative Assembly. At least 21 different provisions, by my count, required some sort of budget section approval for payment of appropriated funds or other substantive matters in already existing legislation. And this screen just gives 4 of those examples. In game and fish spending, if there's going to be an amount that reduces the balance of game and fish's budget below $15 million, it requires authorization by the budget section. Purchase of lease or aircraft without specific authorization from the Legislative Assembly or the budget section. Investments by the Board of University and School Lands cannot occur without prior approval of the Legislative Assembly or the budget section. All of these examples are found throughout North Dakota statutes and require some sort of budget section approval during that period between when the legislature is in session and when it's not. But this wasn't all clear skies. There was a storm brewing from that date on in all those statutes. And the 3 attorney generals between 1985 and present were all asked at various times, hey, is this something the budget section has the ability to do? And the first of those was, boy, I can't read this. In 1987, Attorney General Spaeth got asked whether the director of the budget, the director of budget shall reduce affected budgets by percentage sufficient to confer the estimated losses caused by the initiative or referendum action subject to the approval of the budget section. And the Attorney General was asked, well, is that something that the budget section can do? And the short answer is that there exists a substantial question whether the role reserved by the legislature in executing that statute impermissibly usurps executive functions and violates fundamental separation of power principles, and goes on to discuss specifically the budget section's ability to disapprove or veto cuts altogether. And not to get into the meat of it, but the long and short of this is, if this is a legislative function that the budget section is doing, legislation requires presentment to the governor, passage of a bill by the full legislative session, legislative assembly, and presentment to the government in the form of a bill to be vetoed or approved. And if a smaller section, just one, not the full legislative assembly, but just a subset of its members, is exercising what amounts to a legislative power, the question is whether that's a legitimate exercise of a legislative function, which is the appropriation of money. And then the other issue that was focused on in these Attorney General opinions was whether that was a violation of separation of powers, in that if this is actually a legislative action and it's not presented to the governor in the form of a bill that can be either passed or vetoed, whether that, disrupts one of the checks and balances that the founding fathers put into our system way back at the beginning. Then we have another one in 1991. This one was also, Attorney General Spaeth, Nicholas Spaeth was our Attorney General. And again, it has to do with a provision in a law that required the approval or the oversight of the Budget Section Committee. And again, the long and short of it is that the authority exercised by the budget section is comparable to that given to the board, and it is my opinion that this authority is executive in nature. It is therefore my opinion that when the budget section, which is an agent of the legislature, acts in an executive capacity, it violates the separation of powers doctrine. Then we have Attorney General Heitkamp being asked to review something that allows the budget section to authorize line item transfers in Section 4 of House Bill 1002. And Attorney General Heitkamp refers back to the two opinions that Attorney General Spaeth had written earlier, and basically says, I'm not going to cover that because it's already been covered before. 2007, we have our current Attorney General, Wayne Stemgen, being asked about the budget section's authority to approve or reject a plan to construct or remodel state correctional facilities. And the long and short of that, again, is that Attorney General Stemgen, relying upon referring again to past decisions of the other Attorney Generals, says, no, I think that might be a problem. So we flash forward to the 5 disputed vetoes that are covered in the case. The first one involved workplace safety, and there's the language of the bill, and the highlighted part is the part that Governor Burgum struck. So we have a larger appropriation of $2.25 million with specific things designated for where that money is going to go, 900 of which was going to be distributed to the three entrepreneurial centers in Bismarck, Fargo, and Grand Forks, and 300 of that to an organization that provides workplace safety. And Governor Burgum decided he didn't want to approve that one specific amount for $300,000 to workplace safety. And so this is the letter that he sent to the President of the Senate indicating that he was going to veto that. Another one involved the School of Nursing. And this actually was a statement that was within the part that was vetoed is the part that says 4 credit hours completed at the school. But it was part of a phrase that was just basically stating the intent of the Legislative Assembly. It is our intent that these general fund appropriations be used for this purpose. And there's a number of cases that talk about one legislative assembly not being able to speak for future legislative assemblies. So, but very often the legislature still does this so that they give a roadmap for future, this was what we intended when we did this. And there again is Governor Burgum's veto letter that says I'm striking that part of the bill. Another one is the Dickinson State any portion veto. And that's just that one little phrase is the part that the governor struck, indicating that Dickinson State may not discontinue any portion of its Department of Nursing academic program for the biennium. And Governor Burgum thought that language would cause confusion, and so he notified the Legislative Assembly that he was vetoing that. And the last one of the 5 involved the Water Commission. Or wait, this is number 4, isn't it? I can't count. And there again, you have, there were 2 of the 5 that involved the budget section, and this is the first of them. And so there's a general appropriation of almost $300 million to the Water Commission, divided into 4 different pools for various things: water supply, rural water supply, flood control, and general water. But the second provision there, the second paragraph, says that the Water Commission can transfer stuff if they need to between these pools, but it has to be subject to budget section approval. And Governor Burgum struck that, referring to previous Supreme Court decision, Kelch, that talked about the non-delegation doctrine, which we'll get into in more detail once we get to the opinion itself. And then the last one is the University School Lands Project veto. And this was a bill that said we're going to give, the legislature said we're going to give $3.6 million for an IT project, but of that total appropriation, 1.8, half of it has to be spent only upon approval of the budget section. And Governor Burgum struck that language about budget section approval, and again referred back to the same Supreme Court decision that talked about the non-delegation doctrine. So those are the 5 vetoes, and after these vetoes were made, the Attorney General got asked to express his opinion again by both the Senate and House Majority Leaders, and there's the letter that they sent. And basically what they were asking were these proper vetoes? And so Attorney General Stemjum sent back a letter opinion expressing his opinion on whether the 5 vetoes were proper or improper, concluded that the 2 involving the budget section were improper because they attempted to strike a provision, a condition on appropriation without striking the entire appropriation itself, and that's a no-no. But he went on to say that to express an opinion on whether the condition itself was constitutional, and again referring back to those other provisions or other times when attorney generals had expressed opinions on some legislative functions that were exercised by the budget section, concluded that it would violate the separation of powers doctrine to authorize the budget section to approve or disapprove any transfer of funds by the State Water Commission, or spend only half of the 3.6 appropriated for an IT project. In conclusion, however, he said that courts have consistently held legislatures may validly hold committee hearings and conduct investigations. This is a long recognized power of the legislature to form study committees and ascertain facts. Therefore, it's my opinion that it's not a violation of the Constitution if the Legislative Assembly creates statutory committees to study issues related to different functions. So now we get to the lawsuit itself. After receiving that opinion, the Legislative Assembly still decided to file a lawsuit, or a petition for review, actually, for direct review by the North Dakota Supreme Court, challenging the 5 vetoes. Now we get to the fun part, and there's a lot here, and obviously there's the opinion is full of rich quotes that I could have picked from, and we're not going to be able to cover everything in an hour. But the Justice Tufte, in his majority opinion, summarized very well what the overall fight was about, saying first, the Legislative Assembly wants a declaration voiding the 5 partial vetoes and declaring the bills without the challenge vetoes to be the current law. If that's not granted, seeks the alternative, a writ of mandamus compelling the governor to treat them as a nullity. And then mentions the governor and attorney general's cross petition regarding the 2 provisions where budget section approval was required before funds could be spent by a state agency. And the court lays out some ground rules, I think, are really just covering territory that had already been covered in previous decisions. And one of those important cases was State XREL Link versus Olson from 1979. And the import of the Olson case is the distinction about the governor's line item veto having the ability to strike particular items or conditions on it as long as the entire appropriation was struck as well, unless it was something that after the part struck had to be separate and distinct enough that after removing that specific item, the bill could stand as workable legislation comporting with the fundamental purpose the legislature intended to effect when the whole was enacted. And then the key part there at the end, he may not veto conditions or restrictions on appropriations without vetoing the appropriation itself. The other case that was reaffirmed dates back to 1935. And this involved a challenge to a governor's veto where there were 12 items in total in a particular appropriation for the salaries of the assistant dairy commissioners and the salary of the dairy commissioners, among others, or dairy commissioner, among others. And the governor vetoed all except one of them. That was the salary of the dairy commissioner, which was $3,584 of the total. And part of what was at issue in Sandiger was how did that affect the amounts, the remaining amount. I mean, the bill still said the total, but the effect of the veto was to reduce that total appropriation to just the $3,584 that the governor approved. And what the court said in this case is the veto power is an eraser, not a pencil. In other words, the governor, when he strikes a particular item, he doesn't have to engage in the math. So if we go back to that screen, I'm not going to click through here because I'm not going to be able to get back to the right spot. But if we go back to that one veto involving $2.25 million total and the governor struck 300,000. What this says is the governor didn't have to go, he could strike the 300,000 and the rest of us could figure out the math. He didn't have to go to the 2.25 and strike that out and reduce it by the amount that he had vetoed. And this was a principle that was talked about way back in 1935, and our court basically reaffirmed that principle in this case. So let's go to the 5 vetoes and focus on the language that the Supreme Court addressed on each of them. First, with the workplace safety veto, we have a $300,000 condition or an item that is, let's see, is this the right screen? Sorry. Oh, yes. We had that $300,000 amount that was part of a bigger $2.25 million. And essentially what the Supreme Court said is that's an appropriate veto. The $300,000 is for a specific item, workplace safety. The governor didn't have to strike $2.25 million and rewrite in 1.9, I can't do the math, but $300,000 less. And that the Legislative Assembly may not insulate an item from veto by including it within a larger appropriation, funding that larger appropriation from multiple special funds, or failing to identify the funding source for the item. Here it is plain which funds are allocated to which expenditures, so the itemized appropriations each satisfy the required specification of purpose and amount and funding source to identify that this was a specific appropriation. And so they said that that veto was a valid one. Now we move on to the credit hour future intent veto. The fight here really focused on, is it because legislative intent is just that, intent, it doesn't do anything more than express a wish or desire, was it inappropriate for the governor to strike that language that was within a statement of legislative intent? And the court answered that question, said yes, the governor cannot do that. The Legislative Assembly has the prerogative to state its intent in legislation without the governor altering that statement by selectively removing portions. The Water Commission veto, this is one of the ones that involved budget section approval. And so this was a condition on an appropriation. There's almost $300 million appropriated, but transfer of it among funds was subject to budget section approval, was subject to that condition. The governor vetoed just the condition without vetoing the appropriation itself. And so the court said, no, that's an ineffective veto. And then finally, the other veto that involved budget section approval, the court said that's a condition. It's striking a condition on an appropriation without striking the appropriation itself. And so again, that veto is invalid. So at halftime, we have the Legislative Assembly 4 wins, the governor 1, with just one of the vetoes being upheld. But wait, there's more, the second half. We have the cross petition that was filed by the governor. And this was the one that said, well, maybe my veto is invalid, but I still think that condition about the budget section approval violates the Constitution. And so I'm going to challenge that. And kind of as a side here, this isn't about the fight itself, but the Attorney General was the one that brought that cross petition on behalf of the governor, and the Legislative Assembly argued, well, Attorney General is supposed to be defending us. the constitutionality of our statutes is at issue, and that's the duty of the Attorney General to defend, not attack it. So they said he may not properly advocate on behalf of the governor against the constitutionality of our statutes. And so the court addressed that because the response was, I'm defending the Constitution. And the court said the Constitution wins. Whenever there's a conflict, the Attorney General's overriding duty is to the Constitution he is sworn to support. So we hold that the Attorney General is not precluded from representing the governor and challenging the constitutionality of a statute. And then there we go. And then we have State Ex Rel. Link v. Olson revisited to some extent. That was also basically a cross petition brought by a governor, in substance the same, where there was ineffective vetoes, but the governor still went on to say, well, maybe my veto was invalid, but I'm still challenging the constitutionality of the provision I vetoed, and the court went on to address that. And you see that. We say, having determined that these vetoes were unauthorized, we must now determine whether or not the part of the law challenge is constitutional. And so the bottom line there is, even when a governor's veto is ineffective because it strikes a condition without striking the corresponding appropriation, the governor can still ask the Supreme Court to review whether the condition itself was constitutional or unconstitutional. And the two big provisions or doctrines that were discussed by the opinion, the first one was the non-delegation doctrine. And I don't have to summarize because Justice Tufte did a really good job of describing what that doctrine means. And that's that the legislative assembly may not delegate to another body the power to make law, to legislate, but it may bestow authority to execute the laws that it enacts. In the modern view, that is, in a complex area, it sometimes may be necessary and appropriate to delegate in broad and general terms as long as there are adequate standards and procedural safeguards. So in other words, if the safeguards are in the law to begin with, right, that's a legislative act. Someone else, a subset of legislatures, or in some instances the executive branch, is just applying those standards. And one of the previous cases in North Dakota was Stutzman County that involved what the meaning of historical value. The historical board said that it could determine the historical value in order to put something on the state historical registry. And they said that phrase, historic value, has a meaning, and it's sufficient standard that the board is not exercising legislative authority. The legislature already did that by putting in place the standard, and now the board is just applying that law. So the bottom line is, if there's appropriate standards and guidelines, safeguards for another body to be carrying out, executing a legislative act, that doesn't violate the non-delegation doctrine. Some of the other key statements that the court made in addressing this broader rule, some of this seems obvious, but it's important to remember the power to make a law is legislative, but the power to administer or execute the law is executive. Power to appropriate is purely a legislative power. And then it talks again about what specifically an appropriation is, as far as having to have a specification of the amount, the object, and the fund from which the amount is set apart. And so kind of the bottom line is, once the legislature takes act and it performs its legislative function of appropriating money, those dollars fly away, and they are to be spent by the executive branch. The power to execute the law is the executive power. but it's only the legislature that can initially make the appropriation. And then the court went on to consider the two different challenge vetoes involving budget section approval. They first reviewed the Water Commission bill. That was, remember that one that says Water Commission gets almost 300 million divided into 4 pools. It can transfer money between the pools, but it's got to check with the budget section first. And that's all it said. It didn't say it's got to check with the budget section first if condition 1, condition 2, safeguard 3, safeguard 4 are present. So basically it just said the budget section has complete discretion to approve or disapprove the transfers. And the court said that is not good. A law that provides no safeguards against arbitrary action is a clear sign that the Legislative Assembly has improperly attempted to delegate legislative power. The full legislature has to be the one that can do that, not a subset. And because the Water Commission bill lacked any guidelines, the statute attempted to unlawfully delegate legislative authority to the budget section. Therefore, that bill is unconstitutional in violation of the non-delegation doctrine. Went on to address the University School Lands IT project veto under the non-delegation doctrine, and it similarly held that there were no safeguard standards guidance put in it. It basically said the IT project gets 3.6 million, but 1.8 million has to be approved by the budget section without indicating any standards on how to make that decision, how to exercise that legislative power. So again, the court said the budget section lacks adequate guidance, leaving it discretion to approve or reject the use of 1.8 million appropriated for an IT project, subject only to the budget section's subjective assessment of efficiency achieved or budget savings. Thus, this is a violation of the non-delegation doctrine. And when you think about it from the standpoint of the request for proposal that has to be made by a company who's going to bid the project. Here they've been given this, the universities get this IT project, but we don't know if it's 1.8 or 3.6. And a contractor preparing an RFP would look at it and say, well, how can I tell whether it's going to be 1.8 or 3.6? Do you want half the watermelon or the whole watermelon? And how am I going to determine? So that's one of the practical problems that arises from this standardless determination of half the amount. After talking about non-delegation, the court went on to address separation of powers, and that had been the focus of those previous Attorney General opinions for the most part. And this is not about a legislature delegating its power to a subset or delegating a power to another entity without appropriate standards that are set forth in law itself. This is about the legislator delegating it to itself or to a subset of its members, a non-legislative function, an executive function, or a judicial function. And that violates what's called the separation of powers doctrine. And the highlighted phrase there sums it up. Under our constitutional system, the legislature may not delegate it to itself or to a subset of its members, executive or judicial functions. And that's part of the balance that the Founding Fathers saw with the checks and balances put together with the three systems. Some key statements there. This again focuses on something that's pretty basic. Legislatures appropriate and the executive branch executes. So if the legislature is trying to hold on to that power to execute, that violates the separation of powers. It's basically performing an executive function. And it's also not going through, it's an attempt to pass a new law. It wasn't part of the original legislation without presenting it to the governor for his signature, which is required. And the court said, by arrogating to itself through a committee of its members the power to administer appropriations once they've already been made, the legislature has unconstitutionally encroached upon the executive and consolidated power to both make and execute the law into its own hands. This is a violation of the separation of powers. So this is where the opinion gets interesting. When we count votes, the court was unanimous on the non-delegation doctrine. All 5 justices agreed that both the bills that had budget section approval violated the non-delegation doctrine. So we don't have any issue with that, and the takeaway from that is that you have to have those standards placed in the legislation itself so that the budget section committee has something to go on when it's determining whether or not, for example, the 1.8 of the 3.6 million for the IT project. What are the criteria? What is the historical value, if you want to refer back to Stutzman County? What's the standard that the budget section is applying that the legislature already put in place? But when we get on separation of powers, that's a little more challenging to figure that out. We know that Justice Tufte and Justice Jensen both felt that these two challenged, they signed on to the majority opinion. But Justice Van de Waal wrote separately, and he said, I don't sign on to that part that discusses separation of powers. And he gave us the reason why. I do so because it is unnecessary to our decision, and I'm not convinced the delegation to the budget section, if proper standards were in place, would violate the separation of powers doctrine. Justice, was I a screen behind on you guys? Yeah, that's where Justice Van de Waal said that. And then Justice Crothers wrote a separate decision that was also joined by McEvers and Van de Waal. And what he says is, and this is kind of a general doctrine that is usually followed by courts, our court and other courts, that we want to decide things on the narrowest grounds possible. And Justice Crothers said that he believed the non-delegation doctrine was a narrower ground to determine this issue than separation of powers. And so he said we should have just stopped when we got to that. But what's interesting about this and what makes it hard to count votes is he never expressed an opinion. He never says what, if I had decided, and we're not, courts aren't supposed to do that either, right? We don't want issuing advisory opinions. So we don't know his position. We don't know Justice McEvers' position if they had actually had to decide the separation of powers, which leaves it an open question. And if you look back at Justice Van de Waal, the reason I have the question mark on the one that represents his vote in the middle is he just said, I'm not convinced. So I think what he's saying there is I'd need to see the facts of the case, the law itself that's being challenged, to determine whether something might violate the separation of powers. So what we have at the end is the final score. The governor made up some ground. Despite the fact that his budget section vetoes were invalid, the point he was trying to make was recognized, that the budget section violates the separation of powers doctrine. So final score, Legislative Assembly 2, Governor 3. What did the legislature do in response? It passed ND Sent Code 543502.9. This talks about the budget section, what the membership is going to be. And by the way, I didn't include this on a slide, but if you're interested, you can go to the Legislative Assembly's website, and they have different sections that describe their different committees. And the Budget Section Committee actually has about, and it doesn't go through point by point these individual statutes that require budget section approval, but the budget section is very involved, and it, again, stems back to we're practical people. We have a biennial legislature. There are certain things that come up during those 2 years, and we need to address them. So they have, I want to say, almost 30 different duties that are laid out of things that they're supposed to do and report back to the legislature between the biennial sessions. But in this case, what the Legislative Assembly sought to do is to put in place some standards and guidelines for when the budget section is acting. And they did this in this kind of one size fits all, instead of going and finding all those different 21 different provisions that require budget section approval. They wanted to handle it all with this one statute. And there are the 8 conditions or safeguards or standards that they put in place that we're going to always apply. The request has to be for a specific purpose, specific amount of funds, specific time frame, must conform with legislative intent, be consistent with related statutory provisions, support state priorities, improve state efficiencies, must not extend beyond the current biennium if it's for a new program or addresses an emergency. And so the question about will there be a sequel, it could come up in a number of ways. Someone could challenge those standards and say, well, that's not sufficient. Or someone could say, yeah, the standards are sufficient, but so we're not dealing with a non-delegation problem, but we still believe that even with those standards in place, this would be a violation of the separation of powers doctrine by having the legislature basically trying to perform through the budget section an executive function. I hope I didn't go too fast. I see I have a little bit of time left. I don't know if there are any questions. Sure.
Thanks, Jim. How do you bring in them?
I guess they want you to wait for the microphone here.
Thank you, Logan. Thanks, Jim. How do you read that case in light of the Emergency Commission's actions over the past 3 months?
Good question. I didn't come to talk about anything involving the Emergency Commission. I think that's a topic for a whole nother day. And to get into the weeds, the Emergency Commission is a commission that's set up to deal with some of those emergencies that come up when the legislature's not in session. And usually the legislature says, well, we might have these emergencies come up. We're going to set this money aside. And traditionally, the the Emergency Commission was comprised of a mix of both executive branch members and legislative branch members. So it was a mixed body, so that it wasn't the legislature basically delegating to a subset of its members. It was a mixed group. So yeah, I'm sorry to dodge the question, but I think that's a whole nother can of worms, and I just wanted to focus on the the case for today. Sorry.
Any more?
And by the way, that brings up another topic. You know, if I say anything right today, Wayne gets full credit, Seth gets full credit. If I say anything wrong, it comes with this disclaimer. These are just my opinions and not the official opinion of the Attorney General's office.
Any more questions for Jim? Any online questions? Thank you very much for being here today.
Yep, thank you.
This is the handheld.
That is
All right, we're running a little ahead of schedule, but we're just going to keep rolling. It is my pleasure to introduce our next speaker, Rachel Steenholt. She works as an assistant federal public defender in Fargo, North Dakota, with a focus on appeals and retroactive projects. Before joining the federal public defenders, Rachel worked at human rights organizations in Minneapolis and India, a legal aid clinic in Philadelphia, and an international criminal tribunal in the Netherlands. Today, Rachel will be discussing the Fourth Amendment implications of mandatory breath and blood tests in drunk driving investigations through the lens of the 2016 case Birchfield v. North Dakota. On a personal note, Rachel was also a wonderful mentor to me after I had just finished my first year of law school, and it is just wonderful to see you again. Thank you for coming out.
I paid Alex to say that, so remember to circle back at the end of this so I can give you your 20 bucks. Hi, I'm Rachel Steenholt. Like Alex said, I'm an assistant federal public defender in Fargo, North Dakota. I should thank UND for inviting me to do this, pulling me out from behind the computer screen, as most of us appellate writers like to spend our time. Also wanted to thank UND for this opportunity, because Birchfield, you will soon find out, Birchfield versus North Dakota is about drunk driving. That's not normally, that doesn't come across in my work as a federal public defender. So it was an opportunity to venture into a kind of new area of law for me to learn about. So that was exciting. And so, okay, let's get started. So the case is Birchfield versus North Dakota. That case was decided by the Supreme Court in 2016. Let's start off with a little bit of history. So my slides aren't going to rival Jim's, the clip art from Jim's PowerPoint presentation, but I tried. So let's start with a little history on drunk driving laws. Drunk driving has been a problem since cars have been around. So, so a brief overview is how that area of law has developed over the years. In the 1930s, when Prohibition ended, there was an increase in drunk driving, not surprisingly. And that's when you first saw, around that time, they were setting committees up to solve the problem, and they first got the concept of the blood alcohol content level. They set that at 0.15, and that was a rebuttable presumption. So, so if somebody was determined to have that blood alcohol level, they weren't automatically convicted. It was, they could rebut that. Over time, states have moved away from that and have since lowered it to 0.10. Some states are 0.08. And it has become per se illegal. It's no longer a rebuttable presumption. So that's a little background on that. A little bit further background is the idea of these implied consent laws. So today all 50 states have adopted implied consent laws, and what those are in essence is if you want to drive on the road, you, as a condition of being able to drive on the road, you are supposed to adhere to certain standards. One of them is not to drink and drive. So, normally what states have done is that there's certain ways to regulate this, right? So on the top there we have testing. So to test blood alcohol, there's normally a blood test. There's also a breath test. So states, and North Dakota specifically, didn't like this idea of forcible testing, to force people to give blood tests, and they don't want to avoid the violent confrontations that those could possibly entail. And they've made the testing voluntary. So they've asked them to please consent to do this. And if they don't, there are penalties for refusal. That has primarily been through administrative remedies. So namely, we're going to revoke your license, which is a privilege to drive on the road. It's not your constitutional right to be able to drive on the road. And so normally that has been, if you refuse to consent to one of those two tests, then they say, that's great, give us your license. So what North Dakota did in 2013, and Minnesota had done several decades prior, is my understanding, is that not only did they enforce the administrative remedies, but they had added criminal prosecution. So not only if you refuse is your license going to be revoked, but you could also face jail time, and you could be criminally punished for refusal. So, which, when you look at the numbers, there had been a considerable decrease in drunk driving deaths had gone down proportionately over the years because of higher regulation of first the refusal, or first the revocation of taking back people's licenses, and then also in Minnesota with the threat of criminal prosecution. So North Dakota adopts that in 2013, and then it culminates in 3 cases that are consolidated for Supreme Court review. So the namesake of the case is Birchfield. It's a North Dakota case. That gentleman was given a roadside breath test, which, what I've learned, only produces a preliminary result. It's not admissible in court normally. That's done at a later, they actually bring folks into my understanding of it, into the station to do a more accurate breath test later on. That is an important fact that will come in later in the presentation. So Birchfield does this preliminary test, and then it blows high in the 0.25 range, and but then he refuses to permit the blood test. So he gets convicted of a criminal offense, and then he argued that the Fourth Amendment prohibited criminalizing his refusal to submit to this test. We have Bernard out of Minnesota, and Bernard refuses to even do the breath test. So at the Supreme Court and throughout the appellate process, he argued that that just warrantless breath tests violate the Fourth Amendment. And then, I'm not exactly sure, Bayland is our third case that was consolidated for the Supreme Court case, and that also came out of North Dakota, and he agreed to have his blood drawn, and that was analyzed, and he was convicted of a drunk driving offense. But he argued that his consent was coerced because he was told that refusal is a crime, and so that consent shouldn't count. And so the Supreme Court decided to take all three of these very, related cases to decide this issue once and for all. So I had the opportunity to listen to the oral argument, very interesting argument to listen to. It had started off with one of the justices, well, a couple of the justices framing the argument as, should this be something that when people are signing up for their driver's license, should we have them, should we include a consent that they have to sign that says you agree that you will submit to these types of tests? So that the argument starts off a lot of questions along that line. And then it shifts to reframing the question as, this is a search by taking somebody's breath test or blood test, so this should be analyzed under our search doctrine. And so doing this is a search, and it's a warrantless search. These officers don't have a warrant to do this. So we know that the Fourth Amendment doesn't prohibit all searches, just unreasonable searches. So, since these officers aren't doing this with a warrant, we have to see if this falls under one of the warrant exceptions. So they looked at these two types of tests, blood tests and breath tests. And so the first doctrine that they look under is exigency. And that one, based off of case law, well, besides one justice, Justice Thomas was, you'll see later on, he was all on board on this should all be exigent circumstances, and that's all we need. So both of these should be admissible. And the argument for exigency is that blood alcohol diminishes, the alcohol in your blood diminishes over time, and you metabolize it, and so it's exigent to get the test because you won't have the evidence, it goes away. They determined by looking at their case law that they had actually looked at the natural dissipation of alcohol from the bloodstream and decided in McNeely that does not always, as a categorical rule, that does not always constitute exigency, which justifies warrantless samples. So they said, we already looked at that, and we've already kind of decided that issue. And Schmerber, which was decided after that, agreed and said that exigency is really a case-specific. It's not a categorical type of rule, it's case-specific. So exigency is not the doctrine that this falls under, and that captures most of the justices except for, like I said, Justice Thomas, who rode exigency until the very end. So the rest of the conversation shifts to the search incident to arrest doctrine, which is another complicated doctrine that has developed throughout time. The Supreme Court has grappled with this area throughout the years. The idea behind that is there's this officer safety and an evidence destruction, right? So when somebody's arresting an individual, then where we have landed is that the officer, for their own safety, for officer safety, is allowed to pat down the individual and also the area immediately surrounding them. So they started looking at these tests, the blood and breath tests, as under the search incident to arrest doctrine, where primarily there's a balance. What the majority found is that, based off the Riley case in 2014, is that how we're going to look at this in assessing blood and breath tests is we're going to look at weighing the legitimate government interests that they have in getting drunk drivers off the road and making sure that the roads are safe for everybody versus an individual's privacy rights to their information and their body. So that's where the majority decided to focus their decision making on. So when we look at breath tests, so with breath tests, they found that your privacy interest in your breath is minimal. So everybody's constantly exhaling. You guys are wearing masks, so it's, we are all constantly exhaling breath at all times. It's not something that we have to do. It's natural. It's painless to do the breath test. You shoot through a straw into this little device. So it doesn't reveal much about you like a blood test. It can reveal, a lot more personal information. Breath doesn't. It really is, your blood alcohol content and maybe what you ate for dinner, but nothing else. And it's not embarrassing to do a breath test. So they were looking at the breath test, and it's relatively quick, even though I did mention before that you do actually have to go down to the, as it currently sits, you go down to the station and they perform the court admissible one there. But all things considered, they say legitimate government interest to get drunk drivers off the road, this relatively easy, painless breath test, that's minimally intrusive. We are leaning towards and ultimately deciding to do a categorical warrantless exception by allowing breath tests. When they look at blood, they land differently. So you're not constantly shedding blood, or you shouldn't be. So that is different from breath, where you're, constantly breathing. So there's pain associated with retrieving the blood. That sample can be preserved, and they can use it for DNA analysis later on, and it reveals certainly a lot more about you than breath does. So for a number of reasons, they felt that blood test is much more of an intrusive infringement on your personal privacy rights, and thus there's the line between the two. So what the majority lands on is that they are going to permit a categorical exception to the warrant for breath tests, but under the search incident to arrest doctrine. And then for blood tests, they say, we're not doing a categorical exception. This is going to still be a case-by-case basis. We're hoping that you opt for it's more of a last resort. So go with the breath test if you can, but it sort of falls back under the exigency where it's a case-specific analysis where you're looking at the facts specifically. So that's where the majority lands. So I have Justice Sotomayor up here because, and she was very interesting to listen to at the oral argument, if anybody gets the opportunity to do this. I know Justice Sutton already gave you guys homework, so if you're really bored, you could listen to this. And she was actually pretty funny on this. But so she takes issue with this. So she actually ends up writing, she concurs in part and she dissents in part. And so she says that there should be a search warrant. You should get a search warrant every single time that you're going to do. She agrees with blocking the blood test, right? And then she says a breath test. You should also get a search warrant for a breath test as well. And so the majority addresses that argument, and they say Justice Sotomayor says that this whole warrantless exception proposition is we should use this rarely. That shouldn't be the norm. And the majority says that her understanding of categorical approach versus case-by-case basis is misunderstood. We need a categorical approach in this situation because we need to give police officers something workable. They're out on the field. They need to be able to have pretty clear-cut direction on how to pursue drunk driving cases, which is, unfortunately not abnormal to face regularly. So they also talk about how search warrants aren't practical. Their point is that North Dakota is a state where there's not, a ton of magistrates that are, so there's a fair amount of drunk driving arrests. So in essence, that it would just put this undue burden on judges to have to add all these extra search warrants into their caseloads. So they said it's also practically unworkable. And the benefits that Justice Sotomayor is advocating is of a search warrant. The benefits of a search warrant in general is that, number one, you have a neutral magistrate judge to rule and weigh in on, you have an officer coming to a neutral magistrate judge for an objective opinion. And in their response, the majority opinion is that, drunk driving cases, the facts are pretty similar across the board. Slurred speech, bloodshot eyes, walking unstably. So, and also a neutral magistrate judge who they're waking up at 2 in the morning versus the field officer, their point is that it really is hard for a neutral magistrate to, they're in a poor position to really challenge these types of characterizations. They're not there, and they're often not there for search warrants, but also here it's hard for them to, how bloodshot are their eyes? How wobbly are they? It's just hard for them to really second guess those and challenge the assertions that they're making. So they said that benefit of that search warrant isn't really met by enforcing them. And then the second one that they said is a benefit of having search warrants that's not really met in this scenario is that a search warrant really limits the depth of intrusion. So, in a normal house case, maybe it will say you can only search the closet, you can only come into the kitchen. Whereas here, it's only breadth. They already have that limit. It's already there. So, and that's obvious by a breath test. So, so that objective is already met as well. So the search warrant goals that Sotomayor is saying is so important, check and check is what the majority is saying. But Justice Sotomayor, she gets her chance to write her opinion. So what she says is, again, it's under this premise that warrantless exceptions to the Fourth Amendment should be rare. They should be the rare carve-out. They're not something that we should be just chipping away at the Fourth Amendment bit by bit until it's no longer existent and you don't need warrants for anything. So, so she said that the question is not really whether the public interest justifies the type of search in question, but more specifically, whether the burden of obtaining a warrant is likely to frustrate the government purpose. So, so she looked at the burden. How much of a burden is it really to the people of, a state like North Dakota to be able to enforce search warrants? And so she looked at 5 different aspects of this analysis. So first she says the government's interest in protecting the public from drunk drivers is already met. When you pull somebody over for drunk driving, they don't get to continue to drive just because you didn't take a breath test. So they're already pulled off the road once you identify that they're suspected of drunk driving. If they refuse to submit to the breath test, then doesn't mean they don't go back to the station. Like, they still go back to the station. So there's still that immediate threat to the public of somebody being drunk on the road is eliminated. So at that point, the majority stress on this, public interest concern, we got a safety to the public, that is met by the police officer pulling the person over and arresting them. So that does not mean that they shouldn't also have to do a search warrant. Then she addresses this concern about, being able to pull this. Normally, search warrants, especially under exigency, the exception to that allows you to quickly get evidence, so there's not this prevention of the destruction of evidence. And she says, the search warrant here is not going to add a lot of time. The part that I said I was going to come back to about the part that there's the preliminary road breath test, and then, which is not admissible in court, or at least not at the time when this case was argued in 2016. They have to go back to the police station to do the breath test that is admissible in court. So she's saying you're already taking the 15-minute, the 20-minute drive, whatever it is, you're already doing that. So there's already this delay built into the process of getting these tests. So you can call a magistrate, and they had people write amicus briefs, and in Montana and Wyoming, I think, are the two states that who are similarly rural. They said they're able to get a search warrant in 15 minutes, and so they kept pressing the attorneys at oral argument to say, give us on the facts, on the ground problems about why this is impractical and unworkable. If states like Montana and Wyoming are able to do this in 15 minutes, North Dakota, you should be able to do that as well. There's also the part about the burden on, she wasn't too sympathetic to the fact that they were trying to say, North Dakota is this state that we don't have as many judges. There's some areas where they only have one police officer at a time, and so in essence, we're going to have to hire more people and staff this more. And she said she doesn't agree with that it doesn't actually, there's not this huge cost aspect of it. So she looked at the statistics, and she said that, so if you take North Dakota, for example, so assuming, and again, this was in 2016, but assuming that no warrants are done with those statistics, assuming no warrants are ever done in drunk driving cases, and then it switches to now search warrants are going to be in every drunk driving case. So assuming those two extremes as your starting point, she said that on average would increase the search warrant analysis for judges to be 2 times per week. So that's all the burden that you're adding, is an additional 2 search warrants for judges to assess per week. And she's like, that's not crazy. And that's the extreme, that's the extreme, where no search warrants are being done to search warrants in every single case. And then she said, if you look further, sometimes just I don't want to call it a threat, but like the discussion of, hey, we're going to have to, while you're on the ground, you're talking to the person that who's suspected of driving under the influence, and you say, hey, we're going to have to get a warrant for this, so hang tight. A lot of times, she said that people voluntarily consent to the breath test anyways. There's a fair amount of voluntary consent going on already without requiring search warrants. And so when she looked at how many people are already voluntarily consenting to doing these types of tests, she said instead of it being 2 search warrants per week that was going to be added to the burden of each and every judge, it would only be 1. So she's like, I don't believe you to the majority about how burdensome this would actually be on judges. Because when she ran the numbers, again, in a state like North Dakota, she said it would really only add 1 extra search warrant a week. So there's a convenience argument, which is next. And that has a big X under that. In the sense that she says it doesn't matter if it's more convenient. That's not how this analysis should work. Mere convenience in gathering evidence does not justify an exception to the warrant. So that shouldn't be a consideration. Then the last one is compliance. So she said that this court has, in essence, there is a mechanism besides having this. If the carrot and stick in this is there's a criminal punishment coming your way if you don't comply. Because at oral argument, the state folks kept saying, we need this because if people can just refuse, and then there's nothing we can do. We take their driver's license away. But some of our state statutes are structured in a way that are recidivist in nature. So if this is their second DWI, then they get an enhanced penalty. And so if we just punish them for refusal to take the test. We don't actually get the test results. That allows us to convict them for an enhanced, for the drunk driving, which doesn't allow them to enhance it. And she's like, you're asking me to write new laws. She's like, that's a problem that you need to talk to your state legislators about. We're not here to draft a new law because that's how your recidivist statutes work. That's not our problem. And she said, take that to your state. You still have a mechanism to impose criminal penalties, specifically criminal penalties for people if you go through the warrant process. Again, she keeps advocating for a warrant. So she said if people do refuse to do the warrant, then you can punish them criminally for obstruction, and which is, again, it's not drunk driving. But that you can structure the laws for obstruction to be just as, forceful of a punishment as maybe what, drunk driving would be. But, so she says that, a search warrant doesn't mean, by implementing a search warrant, that doesn't mean that you're taking away the state's ability to criminally prosecute anything, really. So that's how she goes through why she feels that search warrants should be part of both blood and breath tests. It should be or stated differently, that we shouldn't budge here on a categorical break from warrants. It should still be assessed case by case and not a categorical exception. So, told you that Justice Thomas took the opposite of Judge Sotomayor, and Ginsburg joined Sotomayor, and he said he's kind of out on his own in the exigency camp, and he says that, that this blood alcohol is diminishing as your body metabolizes it. That's sufficient. We should have a categorical carve-out for both blood and breath tests. The end. He's on his own island on that opinion. And then, so where do we land with our three individuals where we started the case with? So with Birchfield, that led to a reversal. So that he was our namesake for the case. He is the person who did submit to the preliminary breath test and then refused to submit to the blood draw later on. Blood draws are, they said, you're not allowed to have the law that says that that's criminal to refuse that. So he got that, his conviction got reversed. Bernard out of Minnesota didn't fare as well. Again, he was a breath test gentleman who failed to do the breath test. Supreme Court said, we are allowing warrantless breath tests, so that conviction's affirmed. And then our last gentleman out of North Dakota, he was the one that did agree to the blood draw, but says that should be reversed because my consent was invalid. And so they remanded that, and they said, when you look at consent, that's something for the lower courts to assess under the totality of the circumstances, so we're not in the position to do that. So that's going to be remanded for further exploration of the facts. So that is where the Supreme Court case ultimately lands. Like I said, this case came down in 2016. So a few minor updates since then, and I'm sure there's listeners that are listening right now that that DWI defense or even prosecution is their bread and butter. So if they're listening right now and have the more on the ground sort of updates on what's happened since Birchfield came out, then please write it in as to our live chat. But my understanding of what's happened since post-Birchfield is that the statute has been amended now, since obviously the Supreme Court found that the blood tests are criminal prosecution for it is for refusal. So that statute has been amended. They've also had cases where that has extended to urine tests. So And then also that it applies retroactively, which is the disclaimer where if somebody's listening right now that has an old DWI that they want to challenge, speak to somebody else who does this kind of work, because like I said, I live in the federal world where I don't do DWI stuff, but so when it applies retroactively, what that means is that people who had previously been convicted of having a DWI, for the blood test specifically, they can, just like Mr. Birchfield did, they can go back and have that reversed, and potentially they can challenge that and say, and have their conviction vacated. And so that's my understanding of the post-Birchfield world in North Dakota. So that is the little journey down DWI in North Dakota and Minnesota, and how that made it all the way up to the highest court in the land, and how they got to explore the ins and outs of North Dakota specifically. So, any questions?
Thank you so much, Rachel.
Yes.
Do we have any questions on the online chat?
There are 2 questions on the online chat. So the first question is, does fear of COVID justify refusal to submit to breath test without a mask or other prophylactic?
That's a good question. And again, I feel like there should be, DWI is not my world. It's, again, federal stuff, and DWIs live in the state world mostly. So I don't know the answer to that. I can give a 2-cent opinion for whatever that's worth, probably those 2 cents, which would be my understanding, which is very limited, of breath tests. I learned a lot through this opinion in general, is that they're blowing into it's very targeted what you're blowing into. It goes into a tube, like it's really directed into a specific box. It's not like you're breathing out all over, I should say in front of the mic, it's not like you're breathing out and, to the officer, and the officer's like, 0.27, it's not, so I don't know how much risk is really caused by having this straw mechanism. It seems like it would be limited inherently. But again, if there's folks that are listening on the live part that know these breathalyzer things, the ins and outs of them, and disagree with my opinion, speak up. But I don't think COVID would really impact this too much.
And then the second question is, can a magistrate permit blood withdrawal at the nearest outhouse?
At the nearest outhouse was a twist to that question. Does that outhouse, that makes me think of a bathroom. Is that what that person?
That's what it says.
Okay. Outpost or, so my understanding of where they do the blood test specifically, so the breath test is where they go back to the station. I know that part, and then they explain that blood tests, they're taken to a hospital. It's like a very medical, it's not like these officers are doing those kind of things in the back of the squad car. So maybe that was a typo on that person's part, but if it wasn't I don't think anybody was ever doing anything no, I don't think a magistrate judge would permit a blood test at an outhouse. So any live questions? No. Okay.
All right. Thank you so much, Rachel.
Yeah.
We are going to take a short break until 5, where we will reconvene for a panel. Thank you. Stream anything for this. Okay. So they don't have a PowerPoint or anything. This will just be, if we can.
Logan. We don't need your laptop for anything else, do we?
So
Well,
this says,
Yeah.
oh, sure, 50.
Oh,
Now you're on.
yeah.
That's hot.
Oh,
That's
yeah.
hot.
Sibilance. Sibilance. Unique New York. Unique New York. B1.
3, right?
Bop, bop.
B3. Yeah, and that's the one that's missing. Oh, so we have to switch whoever has. Okay, sorry. I have to do this again.
You want to swap?
What number do you have?
B1.
You're good.
Can you hear me now? Okay. Did you
Good.
say something a minute?
Just
It
testing.
was super loud when I was talking into it, so.
Okay.
You good?
Sibilance.
I'm like,
Sibilance.
no one will understand what.
Very important. Good.
Let's see. Action shots.
You got it.
My iPad gets a lot of PBS Kids on it, so.
Oh, yes.
Do they pop up automatically sometimes?
It's such a good show.
Yeah.
Which one is this?
Molly of Denali.
Oh. This is.
It's a Super Readers. You ready to do Super Y?
Y?
Yeah,
Yep.
that's a good one.
Word girl.
Oh yes.
Word girl.
Yes.
And then he says words that I'm like.
Has it, but as long as there's not the, that's not good.
No. Oh, yeah.
The ones that hang down.
Oh, yeah, that's something to watch.
Still, like, I have tried to look back and remember conversations about alternate resource.
Yeah.
I just let that escape my mind because
Yeah,
that was
right.
something I didn't want to remember.
Right. That's a fair answer, by the way, for anything.
It's like,
Seriously.
This is so loud. Oh, it's like, I don't want to think about this.
You weren't on it, were you?
No.
No, you're there.
Welcome back. We are so excited to be concluding the day with this panel on the Ethics Commission. So let us introduce our panel and our moderator. Leslie Bakken-Oliver is a graduate of the University of North Dakota School of Law. Following law school, Leslie served as a judicial law clerk for the Honorable Herbert Meschke of the North Dakota Supreme Court. After her clerkship, Leslie joined the Vogel Law Firm. Currently, Leslie serves as general counsel in the office of Governor Doug Burgum. And I am so excited to see Leslie again because I interned in the governor's office with her during the 2019 session. Levi Andrus, to my right, is a native North Dakota and graduate of Concordia College and the University of North Dakota School of Law. While in law school, Levi served as the editor-in-chief of the North Dakota Law Review. After law school, Levi served as a judicial law clerk to Chief Justice Vanderwall of the North Dakota Supreme Court. Currently, Levi engages in an active government relations practice, working with state and local decision makers to create solutions on his client's behalf.
Representative Shannon Roars-Jones is a North Dakota native as well and graduate of the College of St. Benedict, the University of St. Thomas, and the University of North Dakota School of Law. Shannon currently serves in the North Dakota House of Representatives as the Majority Caucus Leader representing District 46. She also serves on the Board of Directors for the NDSU Research and Technology Park. Thank you for joining us today, Shannon. Senator Erin Oban lives in Bismarck, North Dakota. She has served as a senator for District 35 since 2015. Senator Oban received her Bachelor of Science in Mathematics from the University of Mary. She is the Director of Community Engagement for Central Regional Educational Association. Senator Oban also serves on the Board of Directors for YouthWorks, the F5 Project, and Designer Jeans. She was named a 2020 Aspen SOAR Fellow and a 2015 Build Fellow as well. We are thrilled that you all made the time to join us here today, and we can't wait to hear your conversation. Thank you.
Well, good afternoon. We've really had a lot of fun putting this together and hope you enjoy the topics. This is a great team. We have 2 legislators and a lobbyist. To talk about the Ethics Commission.
And a non-attorney. My bio needs to be made perfectly clear. I'm the only non-attorney on this.
And that's why we picked you, Erin. So we're going to talk about the Ethics Commission. We know that there were several efforts by the North Dakota legislature to establish an Ethics Commission during previous sessions. In fact, there were bills in 2013 and 2015 introduced. Both were defeated soundly. And Erin, you might have been a sponsor of the 2015 bill?
Correct.
Any thoughts, panel members, on why the 2018 measure passed? Why Measure 1 worked?
Wow. Well, I think your intro provides a little context in that the body responsible for passing laws chose not to do it themselves. And at some point, I think sometimes if it's something the public finds important enough, they will do it themselves. I would also add that in 2011, there was also a bill introduced to create an ethics committee. So in 3 subsequent sessions, soundly defeated efforts to put something in place legislatively were defeated. And I think that sometimes sends a message to the public that if you want to do this, you might want to do it yourselves.
Thank you.
I guess the only thing I would say is, while I don't entirely disagree with Aaron in the fact that this has come up and it was defeated a number of times, and we've seen some of these things, other topics like marijuana being pushed out to the initiated measure platform, I also think it's important to acknowledge that we have had a series of measures that have been promoted with a lot of financial resources from outside of the state. So I certainly think that that helped the process along. Whether that's a good thing or a bad thing is open for debate, but I think that that's important to note, that there was a lot of backing from financial groups outside of the state.
Yeah, oh, go ahead, Senator.
There's a lot of money that
Rebuttal.
goes. I mean, we can have a money in politics
Right.
discussion that would probably last all night. There's outside money that goes into influence campaigns for political candidates. So that is not unique to initiated measure or constitutional measure. It is true. I'm not denying that. However, we tend to like money that agrees with us and dislike money that doesn't. So.
I would say just a couple other maybe alternative perspectives, even maybe a bit more granular, is I think you have to look at, the funders of the measure, and really it begins with Post Citizens United and kind of this right to know. There's a movement in many states, we saw the South Dakota and here, to essentially enshrine in state constitutions, appropriate topic today, kind of the citizens' right to know as an alternative kind of path of jurisprudence to kind of establish that line of thought. And the other thing, I think pragmatically everybody can agree, is ethics sells. I mean, how can you generally be against the topic of ethics? So, a 3-page measure, when you dig into it, there's a lot of substance in there, there's a lot of nuance, but on the very superficial level, ethics sells.
Great answers. I just want to remind the three of you we have 1 hour. Okay, so let's move on. We're going to talk a little bit about the authority of the commission and subsequent legislative action and commission rulemaking. On the slide is Section 3, which establishes the Ethics Commission. There are 4 sections to Article 14, or 5. I should know that.
4.
Someone look it up,
It's
would
4.
you? Okay, but this is the 3rd, and this does establish the Ethics Commission. It gives the commission broad authority to investigate allegations involving corruption, lack of transparency related to elections, basically, and lobbying, activities by lobbyists. And as Levi said, deals with a lack of transparency and is a cure for the lack of transparency. That's Section 3. Section 4 says that, and I'm looking at the second line, laws may be enacted to facilitate, safeguard, or expand, but not hamper, restrict, or impair this article. That is language directly to the legislature, sort of instructions about how the enactment of Measure 1, Article 14, should be handled in the state legislature. So, actually, I'm going to go back. Look at Section 3. The Ethics Commission is authorized to adopt ethics rules, to maintain a confidential whistleblower hotline, and basically, there are no parameters outside that. It seems to be very broad authority for that purpose. And during the 66th Legislative Assembly, the legislature enacted Section Chapter 5466, which is the State Ethics Commission. And there are two excerpts from Chapter 5466 on the screen. Section 05 says, in looking at the bold language, if a complainant does not provide the complainant's name, address, and phone number with the complaint, the Ethics Commission may not investigate, refer, or take other action regarding the complaint. Essentially, the complaint must be disregarded. And under looking at Section 5, making a complaint, the legislature modified that language a bit, saying if a complainant does not provide the complainant's name, address, and telephone number, the Ethics Commission may not investigate. So we go from very broad authority to limitations on the authority under 5466.05. So a question to the legislators. When House Bill 1521, which became Chapter 5466, when it was debated by the 66th Assembly in both the Senate and the House, was the nature of the complaint and the identity of the complainant an issue?
Yes. Yes. Yeah, I mean, obviously, it still passed in the form that it's in. There was a lot of back and forth about the conversation. A lot of the legislators, not being attorneys, looked at this as kind of a due process issue, as the right to confront someone who's accusing you of something. Obviously, in most cases, these wouldn't result in any sort of criminal charges, so, you know, the issue doesn't really apply. But a lot of people felt like if someone was making an accusation against them, they should have the right to know who that person was.
Okay. And looking at the next section, Section 5466.06, when the accused individual is notified about a complaint, the accused individual must be notified of the identity of the complainant who made the allegations. Again, was that debated vigorously?
Well, Leslie, I will say that I believe Erin served on the committee that worked on the ethics bill language, and so she may be able to speak better about the debate that was had then. But I do remember in discussions amongst legislators that it was a real concern that this could be a political weapon that could be used against them as far as an anonymous complaint made at some point close to election time or things like that, where they wouldn't have any ability to refute that allegation because they don't know where it's coming from. But Erin was on the committee that had that conversation, so probably has more insight about the debate.
My insight, I have done everything in my ability to forget about the intense debates we had on the legislation that came forward after the passing of the constitutional measure and creation of the article in the Constitution. It all, with regard to this topic, was debated around the difference between anonymous and confidential, and the very idea that many people may hesitate to bring forward a complaint if their name is attached. And so there were comparisons to what the process is in place for whatever the governing board for lawyers is, things I don't know about or care about for the most part. And how, you know, you could file an anonymous complaint to the police if they are able to investigate it. And so there were comparisons to processes that exist already, and that they seem to work okay, and that all of a sudden that process couldn't possibly work for an elected official. It was, to me, silly. I thought a lot about if I were somebody who witnessed something that I felt was worthy of passing on to the Ethics Commission to review. Would I be more hesitant to do that, to go against an elected official? Yeah, I certainly would be. If I was a casual member of the public, if I am in any way feel like I am in a position of less power than the person who I am reporting.
And on that front too, if I could add something.
Of course.
I thought, you know, the Ethics Commission itself, and I think I saw on the YouTube stream that Commissioner Paul Richard is actually on here, so I hope Commissioner Richard will chime in on the comments if he sees a need. But they do have, the Ethics Commission has a draft bill that's actually going to address this part of it. And specifically what it will say is, if the complainant wishes to remain confidential, they may. However, if it gets to the point where the complaint is also a witness, essentially that evidence cannot be used against the person that the complaint was lodged against. So it kind of becomes this issue of evidence the further along in the stage it gets. If there's enough evidence outside of that confidential complaint, I suppose there could be a situation in which the person that makes the complaint can kind of back out, and there's still enough reasonable basis, I believe is the words that they're using, for the Ethics Commission continue themselves as the complainant. So it would essentially be a Ethics Commission brings complaint against public official or regulated community, not necessarily complainant brings complaint against member of regulated community.
Looking at Section 4 in Article 14, and the direction to the legislature that requires laws be enacted to facilitate, safeguard, expand, but not hamper, restrict, or impair the article. Is there anything about either Section 5, or, sorry, I'm PowerPoint impaired. Is there anything about Section 5 or 6 that impairs or limits the authority of the commission?
I think the commission would say yes. Just in sitting in their meetings and having their draft bill. I think they would say that generally speaking, the legislature in passing 1521 put too many hooks in the complaint process, which is why I think they'll be, it sounds like they'll be pursuing legislation to fix that piece of it.
I know that the commission would say yes because they appeared in front of the interim judiciary committee, and that's kind of jumping ahead here, but they our interim judiciary met a couple weeks ago, and the ethics committee director, Mr. Teeley, appeared before us with the draft that Levi was referring to and said that they believe that their scope of authority has been limited by the legislature, especially related to the ability to make anonymous tips. And so that's why they've submitted the draft legislation that Levi was talking about, and I'm sure that we'll have a further discussion about all of that.
We might, yes. And we know that the Ethics Commission has adopted rules related to complaints. In fact, the screen shows an excerpt from the complaint rules. And there is a definition of a confidential complainant and an anonymous complainant. A confidential complainant, as you described, Levi, is really someone who submits a complaint but would prefer that their name not be associated with the complaint, and a process for the commission to consider the complaint and, based on a reasonable belief of a violation, the commission would become the complainant. An anonymous complaint, I suppose, could be submitted through the anonymous hotline, which is in the measure.
Confidential hotline.
What?
Confidential hotline.
Confidential, I'm sorry. Confidential, anonymous, confidential.
I know.
But you could have an anonymous confidential tip from a hotline, and that could be considered after review by the commission. By a majority vote, the commission would have, under their rules, the ability to initiate a commission complaint with the commission as the complainant. So, question to the panel, are these rules, well, maybe this is a statement of the obvious, but are these rules a direct contradiction of the legislative language in 546605 and 06 for that matter?
I think at this point, I mean, yeah, I mean, I think you probably could make arguments both ways, but I think the Ethics Commission is kind of exercising their jurisdiction pretty assertively in that regard and saying, yes, it's a direct contradiction, and they'll kind of move forward with the bill that would try to reflect these standards.
Okay, and under the rules of interpretation, where we have conflicting statutes or rules, the courts try to reconcile the differences. Is there a way to reconcile the commission's rules with the language in Chapter 5466?
That's an excellent question. I don't know. I think it would depend on the facts of the scenario, and I would, not to jump ahead of two, but I think there's also separation of powers issues at play that might have to be decided before you get to whether or not you're going to try to reconcile the legislation and the rules by the commission. I think the commission has had a handful of cases, but they've all been seemingly summarily dismissed. So until the facts kind of arise, I'm not sure that question will be addressed before the 21 session has an opportunity to consider the Ethics Commission's bills.
Yeah, I would hope it wouldn't reach that point and that the legislature would respond to what the Ethics Commission is bringing forward. I mean, it will ultimately be up to the legislature to determine if we address that and reconcile it, or if somebody is going to, if we deny that opportunity, if it is going to have to be taken somewhere else to reconcile.
It will be interesting.
As always.
Let's talk about lobbying. Let's shift gears a little bit, especially since we have a lobbyist on the panel. And I start maybe with some introductory questions. So with our citizen legislature, which Jim Nicolai talked about a bit, how important is the role played by lobbyists in the whole legislative process?
I mean,
you can start.
I think it's critical. I don't know, how many, probably people here or attorneys are more knowledgeable about the legislative process and what's happening in the legislature. But I will tell you that most of the citizens in the state are very unaware of how our legislative process works. And a lot of the people who are elected to be legislators come in with maybe just a very cursory knowledge of not only the process, but the issues that they'll be making decisions for the whole state on. And so I think our access to not only lobbyists, contract lobbyists, but also the associations that we work with is very important to understanding their issues and how the decisions that we as legislators make impact them and their ability to be successful, whether it's in the ag industries, whether it's in energy. I mean, all across the state, we hear from lobbyists and associations, from the arts to the industries, and we don't have the staff as citizen legislators in North Dakota. We don't have any staff, and we don't have the the pay that would allow us to dedicate our full time to studying all of the issues that we have to make decisions on. And so we really, truly rely not only on lobbyists and association leaders, but also our legislative colleagues to help us learn about and understand all of the history that goes along with the issues that we make decisions on, and kind of the impacts, how this decision that seems like a cut and dried thing really has ripple effects that affect a number of different industries or areas.
Yeah, I completely agree with Shannon, and would just add that not all interests are represented by the same by the same ability to lobby. And so it is the responsibility, if you want to be a good legislator, to seek multiple different perspectives before you make a decision. A lobbyist comes to the table with a very specific interest, and that is to lobby on behalf of their association or their client or whatever it happens to be. In no way am I insinuating that means they get up and lie to us. I don't. But they have a very specific interest and a very desired outcome. And sometimes there is a different perspective that needs to be thought about before you make that decision. And not all groups, not all interests have that same ability to pay a lobbyist to be there full time. I mean, there are volunteer lobbyists, there are volunteer advocacy teams, and while those people probably have just as much education and insight into the issue, they don't always have the ability to be sitting around waiting for bills, waiting for a committee to call itself in and to make a decision. And so I would just say, that there is that other side that needs to be considered. And I said this on the floor of the Senate when we were debating the ethics bill, 1541 or whatever the Senate bill number was. There is a negative connotation and context to the word lobbyist, much like there is to the word politician. Mm-hmm. It is not inherently bad. And lobbyists are not inherently naughty. Like, as I said, I'm married to one. I think he's a pretty decent guy who works for an association. I mean, part of the reason we got married is because we share very similar values. And he works on behalf of public school teachers and public employees like that. So this idea that just because it's something that exists makes it naughty is just not appropriate. And it's the same way I feel about people who just rag on politicians. Like, we're not all bad, but we have a lot of really bad examples right now that people are seeing. And so I think the idea of making sure that the process is transparent and that there are some parameters in place by which people operate is important to trying to restore a level of trust that has really diminished by the public just with the operating of their government.
The only thing I might add, Leslie, and panel is, it's all about trust. Would you agree to that? I mean, there's the old adage that, you have one opportunity to not tell me the truth. And so while there is like a legal, regulatory, ethical regime, there's also an interpersonal one in which, your personal relationships and rapport with people matter, I would say, even much more than these actual, the rules that are black letter.
We've all seen headlines and news articles about business relationships between elected officials and lobbyists, or state employees and lobbyists. Represented, of course, is a conflict of interest. Has Article 14 changed the nature of personal relationships for public officials, or changed the comfort level for public officials about having personal relationships with lobbyists, especially in a state where everybody seems to know everybody else? Is that an issue?
So I think there are two very different questions here, changing the relationships versus conflict of interest. And so, you know, I will let I'll probably let Levi take the conflict of interest one if he so chooses, or Shannon. You know, I share a story. Shannon and I have talked a little bit about this, in that I almost think that it doesn't change it hasn't changed relationships at all with me and individuals who lobby or influence government action. I think because I have not been around for very long. And so the people I have heard complain the most about this have been legislators for quite a bit longer than I have, who make it sound like the only way you can possibly have a working relationship with a lobbyist is if they're taking you out for a meal or paying for your coffee or whatever. That's not how I've ever operated. And while it is a very casual thing to do for each other in North Dakota and likely elsewhere, we're not that unique in North Dakota, let's get over ourselves a little bit. I mean, I buy cups of coffee for people all the time. And I just make it a point where if I'm meeting with somebody, you know, I'd like to pick up my own tab, or I purposely get there ahead of time. So it isn't even an awkward conversation. I don't have to say no, you know, it's just not a deal. Just because I don't want to call that stuff into question, and I don't want to make people uncomfortable. So I think, but I also spent a couple years working for a United States congressman who, this is how they operate. Like, this has never been stuff in question. They just pick up their own tabs. Or they did, I don't know.
Yeah, I think I agree with Aaron on that level where we're talking about maybe a one-on-one or a small group interaction. The place where I would differ, that I think is an important opportunity for people to get in front of legislators, and an opportunity that we could lose if the Ethics Commission tightens the rules too much, which I think they're moving away from, is the large gatherings put on by associations where all of the legislators are invited. And usually those events will have some sort of appetizers or something, because they're held in the evening after we're done in the Capitol. And I guess I don't need to talk directly to Leslie, but it's an opportunity for, you know, I don't know if I would always want to spend my evening with the Soybean Association or the corn growers, because it's a little bit outside of my wheelhouse. But I know it's important, and if I don't have to forgo going out and finding my own dinner because I know I can have a chicken wing or an egg roll while I'm there having that conversation, and that's something that's open to everybody, I think that is a different scenario. The other thing I was just going to say about conflicts of interest in North Dakota is the one thing where I think we are different from other states is the fact that we're so small. And, you know, there's no 7 degrees of separation in North Dakota. It's pretty much 1.5 degrees of separation, where you know someone who knows someone. And so recusing yourself or trying to declare a conflict of interest, which I don't know if Levi wants to talk about, can happen on almost any issue if you go, you know, 2 steps away from your own personal business relationship, if it's a friend, if it's a family member, that sort of thing. And so I think that's going to be a careful balance we have to work out.
Yeah, I mean, I think just to use a couple examples, if there's a construction bill that would affect like lien holding or something, you know, should Representative Rose-Jones have to recuse herself on that? Or if there's an education funding bill that affects rural education associations, you know. Regional, thank you.
Yep,
is there a mechanism there? There actually is a technical rule in each chamber in which a legislator can, on the floor, announce a conflict of interest. It is almost always, I've never seen it where it hasn't been waived by an immediate voice vote. So everybody, the cultural expectation is, this is a citizen legislature. If there's a bill affecting a car dealership, we want Don Vigasa, the car dealer owner, to be able to weigh in on it. So that's kind of the idea. The technical piece, though, that I think the Ethics Commission hasn't really talked about it all yet, where it does deal with conflicts of interest, has to do with the executive branch. And it has to do with quasi-judicial hearings. So a part of Article 14 essentially says that certain executive branch officials have to, A, avoid the appearance of bias, So that's one piece. There was already in the Administrative Agencies Practices Act a little thing about ALJs having to avoid appearance of bias, but this will probably capture more people in that appearance of bias standard. And then the second, it's a disqualification provision. So it says, the executive branch officer, commissioner, head, whatever you want to label it, must disqualify themselves in any quasi-judicial proceeding, essentially in which there is monetary in-kind support for that person that is not shared by the general public. So to me, there's an opportunity there. That is that's a new standard regarding conflict of interest of an executive branch decision maker. And there's judicial canons on appearance of bias. Should there be some equal standard for executive branch decision makers? Perhaps, perhaps not. But there is definitely a new regulated community outside of administrative law judges in agency heads and I think even licensing boards and those decision makers, where there's a lot of new regulated people there that are going to have to be very cognizant in their decision making one way or another.
Oh, I agree with you.
Particularly if they're elected. Yeah.
And the Industrial Commission, which issues orders by its members, has a code of ethics that predate Measure 1. There are other entities that have ethics rules but all of that will be impacted by whatever rules are adopted by the Ethics Commission. And I'm not aware of those. And a very interesting subject, not one we had planned on discussing today, but thank you for bringing it up. So just to look at gifts, conflicts of interest, gifts and the whole issue of lobbyists giving gifts, public officials receiving gifts. The concern is undue influence, creating a conflict of some sort. So members of the Assembly, Aaron and Shannon, today, how much of a problem are gifts from lobbyists, from your perspectives? Is it an issue?
I guess I don't know if it's an issue with regard to influencing decisions. There are gifts, or at least there have been prior to these last sessions, where a group would come to the Capitol for kind of their association day, and they would put something like a coffee mug or a cell phone holder or a pop socket or a portable charger on every person's desk. And there would be a thing with their logo on it on every person's desk. Now, is that going to influence me to vote for their particular issue or in their favor or against something that they don't want to see happen? No. Do I think it's going to influence most legislators? I don't, but then there's always the issue of the meals and things like that. And I think that Aaron's right. There are some legislators who have come to expect that that lobbyists are going to take them out and spend a certain amount of money on them. We've heard stories about legislators who will call up lobbyists and say, where are you going to take me for dinner tonight? And I think that's wholly inappropriate, and I think most legislators would agree with that. I think that's the exception, not the rule, but that's how we end up in the situation that we end up right now, is that we have those exceptions to the rules, and so we need to create rules to deal with them.
I agree. Frankly, if I think about it from the perspective of these associations who, I don't know how much they spend on that stuff, but God, save your money. I hate going home at the end of session with a box full of trinkets. But that's maybe a personal thing, And Shannon's totally right. There are just exceptions to kind of the normal operating procedures that have led to people distrusting their government. And so I think that's why these things are created. When folks are taking trips, and here's the deal, I made this case my Republican counterpart in the Senate when he was arguing with me that this stuff doesn't happen. And I said, but it does. I mean, I've had groups offer to send me on trips. Let's say, for example, somebody who just would offend, Republican, anybody who you don't agree with who's sending me on a trip, I bet you want to know about, so that you can use it as, it would be an issue with voters in my district if some crazy left-wing group was sending me on a trip and paying for everything. And they would deserve to know that, from my perspective. They are sending me on a trip to influence my decisions on the outcomes of my actions as a legislator. My voters deserve to know that. And I didn't have to tell them anything. So I tried to flip the script a little bit and understand that stuff does happen. And it doesn't just happen. It's not Democrats accusing Republicans of being the ones who do it solely. Democrats do it too. And so if Planned Parenthood is sending me on a trip, do you want to know about it? Because it does happen on both sides. And so I think there's just this assumption that if you support it, it's because you don't like the other party. And that's not the case with me at all.
I think there's two perspectives my way to think about it. One is, Senator, when I talk about transparency and sunlight and knowing. From our clients, nobody is afraid of transparency in this environment. So that to me, transparency is kind of a very well accepted standard. And then I would say the new regime is the prohibition or limitation on gifts, as Article 14 provides. So previously, there was no limit on what a gift could be to a legislator from a lobbyist, but there was sunshine, an arguable sunshine, I guess. So the law, and actually currently still the law, is that it's a $60 reporting threshold per legislator per event. So if there's a standard above $60, that has to be reported. In reviewing 5 years of disclosure reports with the Secretary of State's office and having never reported a reportable expenditure, it's just not very common for for anything over that threshold. I know the governor's office has its own ethics policy, which is a $50 standard, I recall. So there's also, and lots of states do it this way, where they set essentially an actual gifting threshold. You can do it above or below, and you have to report any threshold. Whereas the North Dakota Ethics Commission interpreted Article 14 pretty boldly and assertively and said, nope, basic rule is no gifts. And then they provided some exceptions in there.
Great segue. So on the screen is the proposed rules by the Ethics Commission on gifts. Basically, lobbyists may not knowingly give gifts to a public official in conjunction with any effort by the lobbyist to lobby the public official. And in order to understand what that means, it's helpful to see what the proposed rule defines as lobby, which is also on the screen. Are there circumstances, and this really is one for you, Levi, are there circumstances where it is acceptable for a lobbyist to give a gift to a public official based on the proposed rules of the commission?
Yeah, absolutely. To me, if you look at the plain language of the rule, if a lobbyist would give a gift to a public official that is not in conjunction with lobby, as that is defined up here, that would be entirely permissible. So while that being said, while the legal analysis on that front to me is pretty straightforward, there's definitely an overarching analysis, maybe one would call optics, that I think probably would call into suspect that type of activity, again, being entirely defensible under this standard. So,
do you have an example?
Well, so I haven't not a personal one since this has been in place, but if I've been a friend with Senator Oban from Ray, North Dakota, or Senator Rochon since law school, we could theoretically see each other at some event where our kids are playing together, or a swimming tournament, or some Lutheran event, and I could buy a cup of coffee, and it has nothing to do with in conjunction with lobbying. So again, that factual scenario, in my mind, would comport with the proposed rule, and it'd be fine. Again, it's in these kind of gotcha days of politics, it would be, the greater concern would be who wants to have a tracker, and that, again, not that you all have trackers in your races necessarily, but who would want that kind of picture and kind of have that be an issue, even if it's entirely permissible. And that's something I think the Ethics Commission really has to grapple with, that to me that's a tough standard. It's actually their intent, I think, is really good. It's like Article 14 is trying to limit and constrain gifts and transfers of value between public officials and people trying to influence government. So I think on the one hand, the advocates would say, well, even that cup of coffee at the Lutheran event or at the swim meet in South Fargo, that even of itself would reek of not good influence. And then I think there's a lot of people in North Dakota that would say that's not really a problem and that's not some undue influence of some kind. I'm certainly in that camp.
So if I can add in this conversation, because it's something I felt pretty strongly about when we were debating the bills in the legislature, was the definition of lobbyist. So the legislature decided to stick with the very narrow definition of what a lobbyist is. And we know that there are people who are not registered lobbyists because they wanted to only use the word registered. There are people who are not registered lobbyists in North Dakota who influence very strongly the decisions that our government makes. They just aren't registered with the Secretary of State. So they would be able to give a gift, according to the legislation we passed. As long as they aren't registered, they can give any gift they want.
Right. One clarification, though, I might add, though, is it's not whether or not you're actually giving the gift that triggers whether you are a lobbyist. It's one of three things. Are you trying to advocate for the passage of defeater legislation? Are you trying to influence the affairs of interim legislative activities? Or are you trying to secure the veto or non-veto? So if you're doing one of those three things, and there's some exceptions, if you're a government employee or if you're on your own individual behalf, things like that. But if you're meeting one of those three things and you're doing it on somebody else's behalf and you haven't registered, that's a violation of the law for not registering. So to me, that does, even though if a person wouldn't register, and we're very conservative, if you even come close to touching one of those three things, we advise our clients all the time to register as lobbyists. I mean, it's like $15. You go on a public database. It's really not a big deal to do that. So that to me, you got to meet the registration threshold first, and then the gift rules kick in.
And that's the same track that the Ethics Commission is taking with the proposed rules. Those are the same factors that they're using for determining what is lobbying.
Right.
So I think it aligns well.
An interesting legal issue, though, too, is that to me it's arguably a shared jurisdiction. Who gets to decide what a lobbyist is? The Ethics Commission has expanded by adding D what the definition of lobbyist is, but only for purposes of the gifting rule.
But isn't that responsive to their requirement to the ethics measure language about quasi-judicial decisions and an attempt to influence a public official action or decision? Because the Industrial Commission could be lobbied to issue an order or forego issuing an order in a major matter. I mean,
the difference why D was added is the legislature has that three-pronged definition, but Article 14 says
Influence state government.
It's lobby. It's not just legislators. It's public officials,
right,
which encompasses more than legislative decisions. So they added D essentially to capture both legislators and public officials to essentially expand the universe of who's regulated for purpose of gifting.
Okay, so I have a question that I wasn't going to ask it earlier. So is the Ethics Commission legislative or executive branch?
I have compared it to the State Board of Higher Ed. I mean, legislators complain all the time that the State Board of Higher Ed is like its own
branch of government.
Branch of government. I would suggest the Ethics Commission is very similar.
It's in a special category?
Yeah,
There isn't really, I'm not looking for the right answer.
I was going to
That's
say
my
yes.
opinion.
I do, I mean, it's an autonomous branch of government. It does not involve elected officials like the Industrial Commission or other things like that. So I think the State Board of Higher Education analogy is good or accurate.
Thank you. The good news is the proposed rules are, I think, open for comment, and they're available on the Ethics Commission website. I threw this in because we were talking about, Shannon, I think you were talking about the events, and this is another proposed rule under the gift rules that would require notice to the Ethics Commission of a public event, that was planned perhaps during the Legislative Assembly. And I really hadn't looked at it until yesterday, but Levi, you've been very involved with the commission. Do you know the origin of this particular rule?
This was just added as part of the proposed rules package at their last meeting, and I think the general philosophy behind it is the idea of sunshine and transparency. I admittedly was not listening to that part of the meeting, but the idea is if you're going to have a private or public social and educational event, as those terms are very specifically defined with numerous elements, then you'd have to provide notice. And I know that Dave Teeley, the executive director, has said his intent would be for it to be something you could type into a website within a couple minutes. I think I still have some questions about the mechanics of that, given that by invitation only events are still allowed, and those things can happen on the fly. So I think there's probably, it's going to kind of add a transaction in the whole getting together with your public officials. But.
Well, and it looks, if this rule is approved, it looks like it's required.
Right.
Right.
Shall file.
I like the idea of having the information out there as far as who's offering events that legislators can attend. It provides that sunshine and whatever. The only thing I wonder is if there will be confusion amongst the public if this then becomes a public event. And, if it's published, if it's out there, does the public feel like they have a right to attend?
It's a really good question, and I hope people really look at those rules, especially those statewide association types that invite a lot of people, because if you look at the definition of a public social and educational event, it's open to any resident and others. And I'm not aware of any event where that would actually be the case. Mm-hmm. And maybe people just will market their events differently or something to comport with that. But it's a really legitimate issue to consider.
I mean, I don't think any of the associations ever contemplated that they would have an event where all of their association members could come and all of the legislators could come. And I mean, there can be hundreds of people. So how do you know how many members of the public might be filing through that? But if you're putting it out there for the public to say this event is happening at this date and this time and this location, how do you prevent, any member of the public and their family from coming through and, partaking of whatever complimentary food is there? I think it could be an interesting problem.
Mm-hmm. Thank you. We're going to shift gears because we have 8 minutes, and this is a seminar for attorneys. And Levi, I'm going to ask you a question as the lawyer/lobbyist on the panel. Under the Rules of Professional Conduct 5.7 particularly, lobbying is a law-related service. Does the Ethics Commission, does Article 14 change the game for attorneys who are also lobbyists? Does it create an additional set of rules you have to follow, an additional burden?
Yeah, I mean, the rules of professional conduct will apply regardless. So I would say it doesn't, either way, you're just going to have another set of rules to essentially comply with. I think the main thing for lawyer lobbyists, or even lawyers who work at companies or work out nonprofits, even those maybe who are on boards of nonprofits in their communities, is just to be cognizant with regard to the Article 14, because there might be things here and there. I think like the Catholic Conference and Lutheran Social Services North Dakota, for instance, they've got these contracts with the Department of Human Services, right, which are discretionary actions. So you have to kind of figure out whether those entanglements amount to any questions. But from a pure, is it a game changer for North Dakota attorneys and lobbyists? I would say not really. But on the other spectrum, really the full jurisdiction, potential jurisdiction, I might add, of the Ethics Commission hasn't really been discussed or pressed in any way. So I think I'd like to reserve a little bit of judgment on that question too, just depending on, you know, what direction the Ethics Commission goes.
Quick follow-up question. Could you, if an attorney lobbyist was reported for misconduct through the bar, would that person also be subject to reporting or to discipline by the Ethics Commission?
I think it probably depends on the facts, but I would say it's probably a concurrent jurisdiction type of activity. If you would have some conduct, I take like even under the ethical rules or the rules of professional conduct, even if you're exempted as a law-related services, as you said, the general rules that apply to lawyers and other professional conduct rules would still apply. So we're still talking about, you know, advertising, solicitation, improper influence, those types of things. And to me, the real hook here from where both jurisdictions might overlap a little bit is in relation to candor with a tribunal, if you will. I think the rules could be really widely interpreted that, yes, a lawyer has to be candid with a court and a judge or a jury, but they also have to be candid with tribunals like legislative committees and with things like the Senate chamber or the House chamber for that matter. So as we often say, the rules of evidence do not apply in lobbying. So, you know, I got a couple courtesy laughs. Thank you.
There's not very many people.
Right, no, exactly.
Yeah.
I was really listening.
Chuckles behind their computer, yeah.
But the short answer is not really, but perhaps.
Thank you.
Yep.
Good comments. And we have just like 4 minutes left, so I'm going to ask the cleanup question, and I'm going to thank Levi for this one. There are a lot of unanswered questions related to what Article 14 means, how it's going to look in the final analysis. But as you sit here today, are there broader issues or even legal issues resulting from the Ethics Commission, either in statute or rule or in the Constitution, that clearly need to be resolved? What are the legal issues or broader issues that need to be resolved?
I mean, I think the most obvious one that we've discussed a bit is the ability to make anonymous complaints or confidential complaints. Obviously, right now, that's not allowed under the statute that was passed last session. We have the proposed legislation from the Ethics Commission. I think we'll have a lot of discussion about that in our upcoming Judiciary Committee meetings, which I think our next one is like September 20th or 22nd. So, you know, we'll have one or more meetings here before the legislative session begins, and we'll have an opportunity to start to flesh out what those changes will look like and what kind of bill we would end up bringing forward. But I think we will see some changes, and I mean, I know there will continue to be pushback from members of the legislature on that ability to have someone anonymously accuse you and the fear of the unknown that could come with that. But I think we will see some changes because they're obviously, you know, looking at the reducing the authority of the Ethics Commission. I think it's clear that the authority of the Ethics Commission has been reduced with the bill that was passed last session, and we need to make adjustments to allow some sort of a process.
Okay, Aaron?
Yeah, I think there's a few things. I think that's a big one. I really, coming from the legal ethics side, having the ability to have an advisory opinion, to me is just, it creates a culture of compliance and not one of gotchas. I think that's a really good tool in the tool chest, and one that has a safe harbor. So much like the legal ethics rules, if you comply with the material facts and the opinion, you can't be held to some other standard after the fact.
Is that like an attorney general's opinion?
Well, I think it would be, because that's not really, that's a binding on an agency, I suppose.
Yes.
Yeah, so it could be in that regard.
Yeah. Well, I just wanted to mention, and we did receive a draft bill for advisory opinions from Representative Clement at our last meeting too, so I think that will continue to be a part of the discussion in the Judiciary Committee.
Yeah, that'll be an important tool, I think, and it'd be a good culture setting tool. There's a couple of really interesting legal arguments that I just think are unanswered too. There's this idea of facial versus ripe challenges and like delayed effective dates. There's a taxpayer standing in there for, lawsuits that there's like no standing requirement. It's just like if you kind of care about it, you wake up one morning, you can sue. I think where the real kind of national play is for the proponents of the measure is on ultimate and true source. And that to me is really, again, unwinding Citizens United in that regard. It's interesting. There was the ACLU lobbyist from last session even talked about a vagueness challenge as it relates to how far up the revenue stream you go. So in other words, if you have an ACLU donor in Nebraska, which ultimately could feed the advocacy machinery of the ACLU, is that the ultimate and true source of funds used for the purposes of influence? So that's the reason, the ACLU chimed in. And then I'd say, I just think it's, there's also the very last sentence of Article 14 I think folks should read. It's an interest supremacy clause. It's a bit cynical for my taste, but it essentially says this trumps any other constitutional provision. Hold on, let me say that again. Article 14 trumps every other constitutional provision. Okay, so I think there's kind of an unresolved, like, what does that mean and what context would it bring up? And particularly in a First Amendment challenge, where could you have a First Amendment challenge to some rule that then says, well, no, the Article 14 trumps the state guaranteed First Amendment. There's probably still federal First Amendment guarantees there, but anyway, interesting questions.
Thank you. Aaron?
You can just argue with yourself all day, couldn't you?
And he does, yes.
Should talk to my wife.
I do, she's lovely. To be very frank, debating these bills during the legislative session was exhausting because I feel like people dug their heels in, not necessarily on good grounds for everything, but just for a matter of principle, for a matter of hating how this became part of the Constitution. I'm not saying you can't have an opinion or that opinion can't differ from anybody else's. What I am saying is it doesn't matter. You don't have to like it for it to exist and for us to have to deal with it. And so I think just to be super honest, I quit paying attention after we finished our work as legislators. I am glad that that the Ethics Commission is operating and that they are going to bring forward some questions and recommendations. And then we'll just have to be very thoughtful in the way we debate it and keep moving forward. So that's sort of how I look at it.
Well, thank you. It's been a real treat doing this with the three of you. Our time is over, and we may have some questions from the audience. Logan?
So we'll get to one of the questions. So they want to know about the application of Native American cultural gifts within the context, and they added a comment that tribes and states have had a history of bad dealings for 200 years, and I would think that the making of gifts might help that.
There is an exception for cultural gifts.
I guess I'm curious about receiving the Native American cultural gifts from us, because I know after a bill last session, I got a quilt as part of the bill signing ceremony. Is that what they're referring to, or is there something beyond that that I'm not thinking of?
I think there's a lot of cultural gifts within the
And there's
Native American tradition.
in the gift rules, I believe,
Yeah, it says gifts are things of value shared as cultural or social norms as part of a public or private social and educational event. So you could still do that. To me, again, the more ambiguous question is, can the Cattlemen's Association provide us a T-bone? Right? I mean, so there's bigger legal issues with regard to what are social and cultural norms, but that should address the question.
Thank you very much. We'll conclude with that. Thank you to all of you.
Thank you, guys.
Thank you.
All right. Thank you all for giving your time. Just in closing tonight, it is my pleasure to introduce Associate Dean Julia Ernst of UND School of Law. She has a few closing remarks to make to you all. Thank you.
Thank you. Thanks so much to both Alex and Logan. First, please do save the date of April 15, 2021 for the North Dakota Law Review Energy Law Symposium. So they wanted me to be sure to remind you all of that. Next, thank you very much to all of our speakers who shared their wonderful presentations with us today, celebrating the 130 years of the North Dakota Constitution. And a special thanks to Judge Sutton, who traveled such a long distance to be here with us today. As a constitutional law professor, I was especially excited about the topic of this event when I was informed about it quite a few months ago. And the students in my constitutional law class and in my legislation class read both the U.S. Constitution and the North Dakota Constitution. So all of the law students at UND School of Law are at least somewhat versed in the North Dakota Constitution in addition to the U.S. The law school is also incredibly grateful to the North Dakota Law Review Board and especially to Alex and Logan for all of the tireless work you have put into making this event today such a success. They are shining examples of the phenomenal law students we have at UND School of Law. So we are incredibly, incredibly proud of all of you. We also want to thank the Heritage Center for providing us with this venue, to thank Professor Alex Sickler, who is the exceptional faculty advisor for the North Dakota Law Review, to thank J.Tois Moore for making the event such a success behind the scenes, and also to Rob Carolyn for helping facilitate the event, and also to Dean Mike McGinnis, who has provided his long-standing support to the North Dakota Law Review. Dean McGinnis sends his regrets that he was not able to be here personally today, but he is helping with the orientation of our full class of incoming first-year law students this week, which is why he wasn't able to come. I was very excited to help welcome our new class of 2023 during our convocation ceremony last night, and then drove immediately to Bismarck so I could be here with you today. At the convocation ceremony, U.S. District Court Judge Peter Welty gave the keynote presentation and made wonderful remarks, including the importance of the North Dakota Constitution along with the U.S. Constitution. And he also administered the Pledge of Professionalism to our new UND School of Law students. I will be delighted to use the materials that I have learned in this symposium when I teach all of them constitutional law this coming spring. Finally, thank you very much to all of the members of our audience who have joined us today. We hope that you have enjoyed the symposium, and we really look forward to seeing all of you at the North Dakota Law Review's Energy Law Symposium on April 15th. Thank you again to everyone, and have a great night.